My lord, it is fine.
Your Lordship, I moved a memo for withdrawal on last Friday. Yesterday, we followed it up with 2024 minutes. It's not listed. My request for end of the list minutes because today, setting the matter in the trial court Thursday minutes.
What is the urgency in withdrawing?
But evidence confirmed.
It will be listed on Thursday, next working day. File ಮಾಡಿ.
Foreign overbetaಗಿದೆ.
Huh?
Petitioner or foreign overbetaಗಿದೆ.
ನೋಡಪ್ಪ ಏನಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. ಆಯ್ತು ಮೊದಲು ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
ಮೊನ್ನೆ ಫ್ರೈಡೆ withdrawal ಗೆ ಮೆಮೊ ಮಾಡಿದ್ರಿ.
ನೋಡಿ ಅದು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರು ಅಂತ.
Yesterday it was directly released, but it was not listed yesterday.
Okay. ನೋಡಿ in that case 2:30 ಮಾಡಿ. Otherwise
My lord,
the memo ಮಾಡದೇ ಇದ್ರೆ end of the list.
Your Lordship, the respondent is 84 years old. December is filing here.
File.
2:30. End of the list.
ಏನು ಕೇಳ್ತಾ ಇಲ್ಲ.
ಜೋರಾಗಿದೆ.
27. I've been moving memo from 3 weeks, but it's 3 months. It's not
7. Yes.
My lord, yesterday I was not there, my lord. It was dismissed, my lord. Instead of dismissal, my lord, may I request for withdrawal of the writ petition, my lord. Yes.
Sheet change
Out of-
ಅಭ್ಯಾಸದಲ್ಲಿ
ನಾನು ಮಂಡೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದೆ. Instead of taking adjournment, I thought that
Sir, I never done that. Changing the order sheet, changing the
ಅಲ್ಲ
order.
ಸೈನ್ ಹಾಕಿಲ್ಲ ಅಂತ being spoken.
ಹೋಗ್ಲಿ ಬಿಡಿ, ಏನ್ ಮಾಡು.
It will affect adversely affect in the trial. That's why High Court ನವರು dismiss ಮಾಡಿದ್ರಂತ ಅಲ್ಲಿ ಮತ್ತೆ ಇದಾಗ್ತಂತ. To avoid that,
Merits ಅಲ್ಲ, not on merits,
it will not affect the.
not on merits. If I have given any reason, that definitely will affect. No reasons are assigned. ಏನು ಬರಲ್ಲ. Yes.
Any adjournment? List 1, page 5, serial number 15 to 18.
My lords, serial number 20, my lords. Serial number 20, I am not keeping well. Maybe next week, my lords.
Preemptory order ಆಗಿದೆ.
Serial number 20, Srihari.
Preemptory order ಆಗಿದೆ, finally ಆಗಿದೆ.
ಇವತ್ತು ಹುಷಾರಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
Who's for the respondent?
Shivanand Reddy for respondent.
He moved the memo. He moved the memo.
True, my lords, but I can't stand, my lords.
Counsel for the petitioner, prays for time on the ground that he is not keeping well. Respondent number 2 had moved the memo for listing. Order sheet dated so and so reads as under. Considering the grounds on which the learned counsel, the petitioner is moving for an adjournment, I deem it appropriate to adjourn the matter. However, both the parties are directed to address their arguments on merits on the next date of hearing without fail. When
Next week, any date.
adjournment.
Please, my lord, please.
Yes.
Grateful.
Serial number 24, my lord. I have a doctor appointment in the afternoon for my son, my lord. Next week, any date, my lord, I am ready to go on with the matter, my lord. Today, only little inconvenience.
Objections, vacating.
No, those are all compliant, my lord. It is your lordship's directed to hear the matter on merits.
That is to be complied with by the respondent, sir.
My lord, that has been complaints regarding the vacating stay. I have received the copies, my lord. As such, my lord, the lordship's.
Just that he has received the copies of IA 1 and 1 of 23 and 1 of 2024.
Interim order may kindly be extended.
Office objection raised on the applications are complied with. Learned counsel for the petitioner undertakes to address his arguments on merits on the next date of hearing. Instead of hearing IA 1 of 23 and 1 of 20. Filed by the respondents for vacating the stay. The submission is placed on record list for final hearing. Admission ಆಗಿದೆ.
Serial number, respondent number name change ಆಗುತ್ತೆ.
ಯಾವುದು 24 ಅಲ್ಲಿ
R3 ಗೆ
24
ಹೌದು.
ಒಂದ್ ನಿಮಿಷ ಇದೆ. ಏನಾಗಿದೆ? Admission ಆಗಿದೆ.
Interim order may kindly be extended.
List for admission.
Interim order may kindly be extended, my lord.
Next date of hearing, no agenda.
No, my
will
lord,
be
no, my
given.
lord. I will not seek, my lord.
And on merits, you have to address the.
Please, my lord.
Respondent number
Extended. ಅದಕ್ಕಿಂತ ಮೊದಲು. Yes, R3 who is representing?
respondent number 3.
ಯಾರು?
ಹೆಸರು.
ನಿಶಿತ್ ಕುಮಾರ್ ಶೆಟ್ಟಿ ಆಗುತ್ತೆ.
ಇದೆಯಲ್ಲ.
IT ಆಗುತ್ತೆ. ಇಶಾಂತ್ ಅಂತ.
ನಿಶಿತ್ ಕುಮಾರ್ ಶೆಟ್ಟಿ ಅಂತ ಆಗ್ಬೇಕಂತ.
ಕುಮಾರ್ ಶೆಟ್ಟಿ. ಅಲ್ಲಿ so and so ಅವ್ರದ್ದು correct name ಕೊಡಿ. Then counsel for respondent number 3 submits that his name is split spelled wrongly. Office is directed to spell his name correctly as so and so.
Interim order may kindly be extended. my lord.
3, R3 ಗೆ copy ಕೊಡಿ, HCGP,
My lord, we will comply in the meantime, my lord.
ಅವ್ರಿಗೆ ಕೊಡಿ, copy ಕೊಡಿ.
Please, ma'am.
Interim order may kindly be extended.
Extended, but get ready to address the.
Please, my
argument.
lord,
No
next
further adjournment.
positively I'll address.
List one, page one, serial number one. N. Srinivas Babu, Cyril Prasad.
For the petitioners, my lord, need to file in a limitation application regarding recalling application.
ಮತ್ತೆ. Yes, what about office objections?
Need to file a delay application.
Huh?
Delay application file ಮಾಡ್ಬೇಕು ಅಂತ. We
ಯಾವಾಗ ಮಾಡೋದು?
have counted the
No, what is that application you have filed?
recall application of judgment of 1612, my lord.
Why it is to be recalled?
My lord, at that time I was held up in other court, my lord. By the time I came here, it was already disposed of.
Dismissed for default.
ಇಲ್ಲ,
That is
For
on
the-
merits.
earlier ಎಲ್ಲಾ dates ಅಲ್ಲೂ ಬಂದಿದೆ, ಅದೊಂದು date ಅಲ್ಲಿ late ಆಯ್ತು.
I have disposed of the petition on merits. Where is the question of recalling?
It was mentioned as non-appearance maybe,
Please understand the situation.
but it was
Only way left is to challenge this order. That's all.
not an
It
intention.
will be recalled.
Intentional earlier date ಎಲ್ಲ ಪ್ರೆಸೆಂಟ್ ಇದೆ, ಅದೊಂದು ಲೇಟ್ ಆಯ್ತು ಬರೋದು.
ಇನ್ನೇನ್ ಹೇಳ್ಬೇಕು ನನಗೆ ಅರ್ಥ ಆಗಲ್ಲ. Once order is passed on merits, it cannot be recalled. Either it can be reviewed or you have to challenge the order.
I will file a review petition.
I don't know. I will dismiss this application. Yeah, ಏನ್ application ಹಾಕಿದಾರೆ ಅವರು? IA 1 of 2025, 5 filed for recalling the order dated 16th December 2024. The said order is passed on merits of the case. No reasons are as, there are no reasons to recall the order passed on merits, hence IA is dismissed. Yes. ನೀವು ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ ನಿಮಗೆ ಗೊತ್ತಿರ್ಬೇಕು. ವಾಟ್ ಈಸ್ ದ ಪೊಸಿಷನ್ ಆಫ್ ಲಾ, ವಾಟ್ ಈಸ್ ಟು ಬಿ ಡನ್ ಅಂತ ಎಲ್ಲದಕ್ಕೂ ರಿಕಾಲ್ ಬರಲ್ಲ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Serial number two, Hnumantrayappa K.
Partition. During the course of the day, I will comply with that.
Pass over. Please comply with that.
Serial number three, Tigdi Veerಣ್ಣ.
Commissioner, 2 days time, my lord. I process paid, my lord.
Counsel for the petitioner prays for time. Petition is of the year 2020. PF for issuance of notice to respondent, but no one is not furnished. Do not find the reason to adjourn the matter, however, to afford final opportunity.
My lord, interior matter extended, my lord. Interior matter.
Finally posted. So moderate extend. Next.
Great.
Serial number four, Giri Kumar SV.
My lord, appear for a petition, my lord. My lord, there is no instruction from my client side, my lord. I have filed a memo for retirement, my lord.
You are representing whom? Petitioner?
Yes, my lord.
When you filed the memo?
Today in the counter, my lord.
PF paid.
Whom you are representing?
I am also one of the advocate only, my lords.
You continue to appear?
Yeah, I am continuing.
You there.
Giri Kumar SV. My name may be deleted.
Your name.
Hello, where is your
You
memo?
have
sir?
filed wakalat.
Memo is filed in the counter, please, my lord. Sorry. Excuse me.
Pass over. ನಿಮ್ದೇನು ಹೆಸರೇನು ನಿಮ್ದು?
Sangeeta is.
ಅವ್ರದ್ದು ಹೆಸರು ಬರ್ಕೊಡಿ.
ನಾನು ವಕಾಲತಲ್ಲಿ.
It's not received.
You are Mr. Girikumar, is it?
Yes, my lord.
Yes, my lord. Yes, my lord.
Learned counsel Shri Girikumar SV submits that he has no instructions to represent the petitioner. In the meantime, Srimati so and so submits that she has also filed wakalat for the petitioner and she continues to appear for the petitioners. Submissions are placed on record. Office is directed to delete the name of Shri Girikumar and counsel for the petitioner and show the name of so and so. Next, when counsel for the petitioner submits that PF for issuance of notice with the petition copy and annexes are furnished for issuance of notice to respondent. That is to verify if PF is paid with annexes, issue notice to respondent number 2. Yes.
Serial number five, Harisha AS.
For the petitioner, my lord. My lord, wife ಗೆ ತುಂಬಾ ಹುಷಾರಿಲ್ಲ so one short at the beginning.
ಯಾರಿಗ್
Which is for the
ಹುಷಾರಿಲ್ಲ?
withdrawal, my lord.
ಯಾರಿಗೂ ಹುಷಾರಿಲ್ಲ?
Petitioner wife.
ಪೆಟಿಷನರ್ ಬೇಡ, ನೀವು ಪಿ ಎಫ್ ಕಟ್ಟಿದ್ರೆ ಆಯ್ತು, ಅದು ಪೆಟಿಷನರ್
ಅದು ಸೆಟ್ಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಔಟ್ ಆಫ್ ದ ಕೋರ್ಟ್ ವಿಡ್ರಾ ಮಾಡ್ಕೋಬೇಕಾಗಿದೆ.
ಆಯ್ತು,
I
I'll
have
dismiss
filed a
this.
memo.
I'll dismiss this. Either you pay PF or I will dismiss.
I pay the PF, ma'am.
Next,
Pass over, ma'am. Finally.
pass over.
Serial number 6, Matri Mohammed Ismail.
Pass over.
Serial number 7, YK Narayan Sharma.
For the appellants in this case.
APF for the
Taking affidavit of it. Threatening to vacate the premises.
ಏನಾಗಿದೆ?
That's IPF for the respondent in this matter.
The takes to file affidavit on behalf of the appellant to explain the date within which vacate the scheduled premises.
Please, that's by way of a compromise, my lords, 2 years time was granted. Lords, which ended on 31st of January. Beyond that, my lords,
One
they have
minute. Initially.
2
time
years.
was granted till,
31st of January 2025.
Ah,
My lords,
now-
now 25 days, my lords, along with 2 years, my lords, again 25 days, my lords, they were message itself. Now this application is filed seeking, my lords, 6 months more, that is till June.
5th June.
June, my lords, so my instructions are, my lords, it's a small premises. They took 2 years, my lords, to vacate. My lords, my instructions are, my lords, beyond 15 days, my lords, they are not entitled to.
Yeah, why 6 months?
Sir.
You undertook to vacate on
Please,
31
please, my lord.
January.
My instructions are I am searching for a new premises in the.
Let him search,
Please,
but that cannot be the ground that you can squat over the property forever.
I am
is
paying
not
the
even
damages also, my lords.
When initially the suit was filed,
My lords, suit, my lords, is of
2009.
2009.
Huh?
9, 2009, 9
still
suit.
you are searching
No, my
since
lords. After
2009.
that, the RA was filed, RA is set aside, I thought.
When the suit for eviction is filed,
Please, ma'am.
you should know that you have to vacate the premises.
I'll vacate, my lords. I only undertake.
Many years have lapsed. 16 years, still you are searching.
No, my lords. I'll vacate by the date which I have mentioned in my affidavit, my lords.
He is
My
not
lords,
agreeing for that.
My lords, we have, my lords, even in fact, during the
the range?
compromise also, we agreed for 2 years, my lords. And the last moment they filed this application.
Compromise 2 years ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವಾಗ್ಲೂ ಸರ್ಚ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ಮಾಡ್ದೆ.
ಎಲ್ಲಿಂದ ಸರ್ಚ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
ಮಾಡ್ದೆ sir.
ಅಲ್ಲ,
ಅದು ಸಣ್ಣ ಜಾಗ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ.
ಆ ಸಣ್ಣ ಜಾಗನು ಬೇರೆ 2 ವರ್ಷನೂ ನಿಮಗೆ ಸಿಗ್ಲಿಲ್ಲ. 16 years ಬಿಟ್ಬಿಡಿ, 2 ವರ್ಷ ಅವ್ರು ಕೊಟ್ಟಾಗ್ಲೂ ಸಿಗ್ಲಿಲ್ಲ.
ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. Within 6,
ಸಾರಿ, ಎಷ್ಟು, what is the rent?
2000 damages I am paying.
2000,
Please.
ಡಬಲ್ ದ ಅಮೌಂಟ್ ಕೊಡಿ 6 months.
ಅಲ್ಲ, ಈ 2000 ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಡಬಲ್ ದಿ ಅಮೌಂಟ್ 4000 ಕೊಡಿ. 6 months I will grant. If you are
He
agreeable,
request-
I will grant, otherwise no. Don't be under the impression casually the court will extend the time.
ಅಲ್ಲ,
We should
Hold on,
safeguard
my
the
lords.
interest of the owner also.
please, my lords. I bow down, my lords. Only request, my lords.
ಕೇಳ್ಕೊಂಡ್ ಬನ್ನಿ.
Please,
And you have to file a affidavit to that effect.
please. 1 week time may be granted, my
October.
lord.
Pass over.
That's the
Please.
parties have to come from Mysore.
First make the submission.
Please,
I will record your submission and grant time.
please.
Yes.
My lords, may request, my lords,
Hmm.
may request at 2:30 minutes,
2:30, yes.
oblige.
Petitioner, in this matter, based on the report given by the Caste Verification Committee, my lords, holding that the petitioner does not belong to Kanyan community, the FIR was lodged against him, my lords. That order of the Caste Verification Committee is quashed by this honorable court, upheld by the division bench, my lords, and also, my lords, a fresh caste verification order is passed, my lords, which I have produced at with the memo dated 7/2/2025. Sindhutva Pramana Patra kottidare that he belongs to Kanyan community. So this complaint does not survive. The only complaint, my lords, if your lordships would go to the FIR, page 68 is the relevant portion.
Yes, who is for the Jagdish, where is he?
See Jagdish here appears.
He has to appear.
Jagdish never appears even in the.
No,
even,
he appears through VC.
no, in this matter he did not because Sindhutva Pramana Patra.
In all such matters, he appears.
Yes, yes. Either Sindhutva Pramana Patra
You have
kottidare.
the phone number?
I will call my.
No. you
The
take that
government,
number.
the government
Yes.
advocate can, here, my learned friend can verify.
I will My lords may kindly pass over, my lord. In the meantime, I will,
Yes,
I will get him.
and he can also look into, because the
To
verification,
inform him,
I will inform.
you
my-
can share the number with her also.
Please, my lord.
Please
also
collect
has
the
a-
number and apprise him.
he was there in the, when the High Court quashed it.
Pass over.
Serial number 9, hearing on IA, P. Sheshagiri Rao, Gopal Krishna Gowda, I.
Appear for the petitioner in this matter, my lord. Should kindly pass over this matter.
ಯಾಕೆ?
Senior ಇನ್ನೊಂದು ಕೋರ್ಟಲ್ಲಿ ಎಲ್ಡಪ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇದು ಸಿವಿಲ್ ಇನ್ ನೇಚರ್ ಇದೆ. PTCL ಆಕ್ಟ್ ಅಲ್ಲಿ.
ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಲ್ಲ, ಆಮೇಲೆ ಗೊತ್ತಾಗತ್ತಲ್ಲ ಸಿವಿಲ್ ನೇಚರ ಏನು ಅಂತ. Ready for argument?
Yes, my lord. Kindly pass over this matter, ma'am.
Number 10, Kiran N, P. Vijulata.
Yes, kindly pass over, I filed IA for amendment and impleading applications.
This is the matter where your lordships observing that allegations were made against a presiding officer for taking the party to custody since he had failed to pay my lord's maintenance ordered under section 125.
Yes.
Now he has filed an application to implead the presiding officer. And he has also filed a memo showing that orally the presiding officer had directed my lords if your lordships could recollect, this matter is settled between the parties. So my learned friend had undertaken before this honorable court that he'll withdraw the petition.
Where is the petitioner?
Petitioner is in the security cabinet, my lord. I will bring him, my lord. Kindly pass over, my lord.
Pass over.
One number. See, Jagdish.
ನಾನಕ್ ಬೇಡ, ಅವ್ನು
Further hearing, serial number.
ಅದ್ರಲ್ಲಿ crash ಆಗಿದೆ. ಮತ್ತೆ verification
Ishwara HH.
fresh orders ಆಗಿದೆ. ನೀವೇ submit ಮಾಡ್ಬೋದು. Why should he come? ನೀವೇ ನೋಡಿ sir.
ಬಂದಿಲ್ಲ. ಅದು further argument ಅಂತ. ಯಾಕೆ without TCR here?
Ishwar H.
When counsel for the petitioner and respondent, number 2 are absent, no representation. TCR is not yet received, released from party. Next, take that here.
Serial number 12, Mahesh S. R. Subramaniam.
For the petitioner.
Hmm.
Concluded our arguments last.
Hmm?
On last hearing date, our arguments were concluded, my lord.
You have already argued.
Please, ma'am.
Respondent yaru.
It was for
Subramaniam.
urgent to hear respond.
Review the materials on record. Then counsel for respondent number. Respondent number 2 has not addressed his argument in spite of giving sufficient opportunities. Hence, his argument is taken as mail. Next is review the materials, point for consideration. My answer to the point in the affirmative for the penalties. The complainant filed the private complaint in PCR 53324 of 2018 before the trial court against the accused, alleging commission of the offence punishable under section 506 and 420 of Ethics. The first contention taken by the petitioners who are accused number 1 to 5 that the direction issued by the Honorable Apex Court in Priyanka Srivatsav and another Supra is not followed. They stated that no affidavit whatsoever is filed for complaint for highlighting complaints of requirement of section 154T of CRPC. No materials are placed before the court to contend that there is compliance of such a direction. Next paragraph. The second contention raised by the learned counsel for the petitioner is that there is delay of more than 8 years in filing the complaint. The complainant referred to the agreement for sale and the subsequent sale deed entered into between the complainant and the accused, which are admittedly of the year 2010. Pursuant to the agreement to purchase 20,820 square feet of the land, it's a registered sale deed was executed on 21/5/2010. Later, when BBMP proposed to widen the road by acquiring some portion of the land, a memorandum of understanding was entered into on 22/6/2010. And even one more sale deed was executed by the complainants in favor of the petitioners on 4/10/2010. 4/10/2010. They stated that the complainant and his brothers have retained only 574 square feet of land. After a lapse of about 8 years, during 2018, the complainant and his brothers appears to have filed the suit was 6028 of 2018 before the trial, only seeking permanent injunction. They stated that the said suit was going to be dismissed for default, that is for non-prosecution. Later, the private complaint, in the meantime, the private complaint was came to be filed in 2018, alleging commission of offence punishable except making the next part. And the admitted documents, that is the agreement for sale and sale deeds, are taken into consideration. No offence of either 406 or 420 of IPC is made out by the complainant. The contentions taken by the complainants that the petitioners have promised to pay the market value of TDR to the complainant and others is not evidenced by any of the materials. It is stated that it is an oral understanding between the parties. If Under such circumstances, the complainant is required to prove his contention before a civil court regarding the oral understanding between the parties. But it will not give rise to filing of the criminal complaints alleging commission of the offence punishable under section 406 and 420 of IPC. When the contentions of the when the contention of the complainant is against the terms of the written documents, that is agreement to sell and the sale deed referred to above. Therefore, I am satisfied that the complainants have filed a criminal complaint based on the oral understanding between the parties, based on the alleged oral understanding between the parties, which is seriously disputed by the petitioners, giving it a color of criminal offense. Therefore, I am of the opinion that it is the initiation of criminal proceedings is clear abuse of process of law, and the same is to be quashed. Accordingly, I answer their point in the affirmative and proceed to pass the following. Question is allowed. Petition is allowed. Criminal proceedings quashed.
Published.
Serial number 30, Sanat Kumar KM.
Petitioner in case. Filing additional documents.
Sir,
13, 14. Additional.
Filing additional document. The last date of hearing, my lord.
1 minute, sir.
Yes. Last date of hearing, my lord. This number, the lordship have directed to produce the decree passed in OS number 1473 of 2012, which has been stated in the FIR and execution 246 of 2014.
That is the suit for permanent injunction.
Please, my lord. That has been, I've produced the additional document that has been set aside subsequently, one that has not been filed against the petitioner or his owner or his landlord. It is against some other persons. I produced the plaint also, my lord, in page number 10 of the additional document, wherein he has stated Mahadeva Swami DS, son of father name not known. Subsequently, the defendant number 4 in that suit has filed a miss petition in miss number 43 of 2014.
The suit was decreed.
Suit was decreed
Early there.
on annex, page number 2, my lord.
20.
It is not against the petitioner or his landlord. on 7th November 2013. On the defendant number 4, subsequently, defendant number 4 filed a miss petition in miss 43 of 2014 at page number 20.
20, man.
That has been allowed on 14th November 2017 itself. And OS has been restored. The decree has been set aside and OS has been restored.
Then
Subsequent to restoration, the suit against defendant number 1, 2, 3 has been dismissed for non-prosecution since they have not taken the steps by the complainant plaintiff. Now that the suit is pending against only defendant number 4, who is Jagdish.
it's still pending.
Still pending. Then subsequently, that my landlord has filed a suit against the complainant. That has been decreed. I have filed the decree passed in OS number 1665 of 2020 at page number 28.
This is filed by
The landlord, the Venkatesh, landlord of the petitioner.
for
On 9th February 2025.
what is the relief claim?
Suit for injunction, permanent injunction.
Permanent injection.
Permanent injunction.
That is decreed
They decreed on 9th February 2024. 24.
24, man.
Who is the defendant in this case?
That complainant, though I served, is remained absent. Both my landlord as well as the complainant claim the title in respect of the site in dispute. Therefore, when there is a dispute with regard to title, my lord, the criminal complaint not be survived. The dispute is civil in nature.
Who is for the complainant?
First matter, second matter,
Yaru?
4 connected ones, 13 and 14.
Sandesh TB. Yes, what do you say?
My lord, there is a civil,
Rival claim is there.
yes,
According to him, his owner has filed a suit for
Yes.
permanent injunction.
yes, he is the leasehold,
That is decreed.
that is decreed, means royal.
447 is alleged.
Yes,
Last time or ಇರ್ಲಿಲ್ವಾ? Respondent number 2.
ಬಂದಿಲ್ಲ, last time ಬರಲಿಲ್ಲ.
ತಗೊಳ್ಳಿ.
ಬರ್ತಾರ.
Petitioner. You are the sole accused?
Please,
Yes.
in one petition, the first petitioner is the accused, my lord. In second petitioner, the petitioner and his colleague, junior
number
advocate
one
is the
and
Junior
accused
advocate.
person, junior advocate.
For 1 and 2.
Please, ma'am, in second petition.
Sole accused in crime number 66 of 2020 of Alnandi Police Station. Registered for the offence punishable under section 447 504 of IPC. Has filed criminal petition number 9128 of 2021. 21. Come on. Case number 1 and 2 in crime number 69 of 2020 of Alnandi Police Station. Registered for the offence punishable under section 447, 427, 323, 504, 506, every section 34 of IPC. Have filed criminal petition number 9146 of 2021. requesting the police to register the FIR and to initiate legal action. Filed a criminal petition for the offence so and so, seeking to quash the criminal proceedings initiated against them. Three facts of the case are that respondent number 2 in both the cases, complainant is same in
Please.
both the cases.
Please.
Respondent number 2 being the complainant in crime number 66 of 2020 and 69 of 2020. All the first information with all the police station against petitioners alleging commission of offence as stated above. It is the contention of, where is the complaint?
Complaint at page number,
Yes, 1. It is the contention of the complainant that
page number 23 in first case, my lord.
on 4/8/2020. At about 4 PM in the evening, when he gone near his site,
I put is 25 month.
25 in second case.
Right.
yes, third cases,
That case.
he found that a car and 2 wheelers were
I
parked
put copy.
there without his permission. When he, on inquiry, he came to know that the vehicles belong to the accused. When the complainant questioned the accused
My lord,
as to why he had parked the vehicles in his land, accused abused him in filthy language.
Petition could have been marked.
The complainant filed the suit was 1473 of 2012 seeking permanent injunction and got the interim order of injunction, temporary injunction. Therefore, the complainant contended that the accused
That's all right.
illegally and criminally trespassed over his property, abused him in Hindi language, and also criminally intimidated. He is liable for prosecution. Accordingly, paid for initiation of criminal proceedings. Next part. The very same complainant has filed the first information date 2020
Really there. ಏನು ಮಾಡಿ
against accused number 1 and 2, alleging that on 6/8/2020, when he was digging the foundation in the site in question for the purpose of putting up the compound, accused number 1 and 2 came to the spot, picked up quarrel with the informant, demolished the half-built compound wall, abused the informant in filthy language, criminally intimidated him to cause his death, caused damages, and thereby committed the offence punishable under section 447, 427, so and so, so and so. The FIRs were came to the register.
R2
The investigation.
14 right.
Investigation were undertaken. In the meantime, the as I approached this court, seeking requires the criminal proceedings. Since interim order of stay was granted, further investigation was not undertaken. Third source. Learned counsel for the petitioners in both the petitions contended that site number 479 or 419/17. What is the disputed site number?
Site number according to petitioner, my lord.
175.
It is 479/419/7.
ಎಲ್ಲಿದೆ ಅದು? No, in the complaint it says
In complaint,
475/7.
he claimed the other number, my lord. In complaint, as claimed in 470,
75.
475.
475/7
Bar
is
seven.
claiming.
It is the contention of the learned counsel for the petitioner that in fact, the disputed site is bearing site number 479 bar. According to you, it is 479.
475/419/7.
4,
4. 479/419/7.
or 7 or
7,
17?
7.
7. Of,
Survey number,
ಅಲ್ಲ, which layout ಅದೇನೋ layout ಹೇಳಿದೆ.
Giridarshini layout.
ಗಿರಿದರ್ಶಿನಿ layout of all.
Alnalli.
Alnalli.
Alnalli village.
Extension.
Respondent number 2 is claiming the said site as site number 475/7 and claiming right over the same. The petitioners have taken the said site on lease for the purpose of parking the vehicle. Respondent number 2, without having any right, has raised the dispute. Next paragraph. One counsel submitted that even though the complainant respondent number 2 is claiming right over the property on the basis of the decree passed in his favor in OS 1473 of 2012, the said suit is only for permanent injunction. The petitioners are not parties to the said suit. Even though the said suit was came to be decreed initially, one of the defendant filed miscellaneous 43 of 2014 and as per order dated 14th November 2017, the miscellaneous case was allowed and the decree passed in decree dated 7/11/2013 passed in OS 1473 was set aside. Later, the suit was restored on file. And since steps were not taken against defendants 1, 2, 3, the suit against them was dismissed. Now the suit was 1473 of 2012 is pending only against defendant number 4, for which the petitioners are not parties. Next. Learned counsel also contended that the owner of the site by name S. Venkatesh. Venkatesh is the
Please,
S. Venkatesh, from whom the petitioner had taken the site on lease, had filed the suit was 1665 of 2020, bracket in old number 224 of 2020, against respondent number 2, seeking permanent injunction. The said suit was came to be decreed with a judgment dated 9th February 2024. Thus, it is clear that the disputed site belongs to S. Venkatesh, the plaintiff in OS 1665 of 2020, and not to respondent number 2. When respondent number 2 is not the owner of the site, he cannot allege any of the offense, including the trespass by the petitioner. Next paragraph. When counsel submitted that accused number 1 filed a complaint against respondent number 2 and others is registered in crime number 67 of 2020 of Alnalli Police Station for the offense punishable under section 447, 427, 323, final 4, read with section 34 of Advocacy. And the same is pending for investigation. Respondent number 2 has never challenged the registration of a criminal case against him. Under such circumstances, when counsel prays for quashing the criminal proceedings in both the cases in the interest of justice. Yes, what is your contention?
My lord,
What do you say?
my contention is, my lord, my lord, the investigation has to be done, my lord, only it is crime.
Under HCP for respondent number 1 submission that the FIR was registered on the basis of the first information. Investigation is not yet undertaken. Unless the investigation is undertaken, the contention of the petitioners cannot be accepted. Hence, he prays for passing appropriate orders. Yes, what do you say?
It's a civil nature matter. Kindly maybe.
You have to approach the civil court. Why you have filed 2 criminal cases? You are the complainant.
Please, ma'am.
You are not the accused.
Yes.
And you are saying, yes, it is of civil nature, right? I'll quash the criminal proceedings.
Please.
ಅದು ಮೇಲಿಂದು HGP ಮತ್ತೆ ಇವ್ರದ್ದು ಒಟ್ಟಿಗೆ learned counsel for respondent number, learned HGP for respondent number 1 and learned counsel for respondent number 2 submit. Very was point for consideration. My answer to the other point in the affirmative for the following reasons. Learned counsel for the petitioner produced the decree dated November 2013, as in invoice 1473 of 2012, wherein respondent number 2 as plaintiff filed the suit for permanent injunction against one Krishnamurthy and 3 others. The petitioners are not the defendants in the second suit. It is the specific contention of the complainant that in view of the decree passed in OS 1473 of 2012, he asserts his right. However, learned counsel for the petitioner produced order dated 14th November 2017, passed in miscellaneous case number 43 of 2014 on the file of learned second additional first civil judge in JMFC at Mysore, whereunder the miscellaneous case was allowed. Miscellaneous case filed under Order 9, Rule 13 of CPC was allowed. As a result, the judgment in decree dated 7/11/2013 passed in voice 1473 of 2012 was set aside. It is stated that the said suit is still pending against defendant number 4 alone, as steps were not taken against defendant number 1, 2, 3, and the suit was dismissed against them. Learned counsel for the petitioner has also produced copy of the judgment and decree dated 9th February 2024, passed in OS 1665 of 2020. On the file of the learned 11th additional civil judge in JMFC at Mysore, filed by one S. Venkatesh, represented by his GPA holder, against respondent number 2, who is none other than the respondent number 2 hearing. The suit was decreed ex parte, granting permanent injunction in favor of Venkatesh, who is said to be the owner of the disputed site. Even though the complainant is claiming site number 475 of 5/7 of Alnalli village, according to the petitioners, it bears site number 479/419/07. When there is serious dispute regarding the identity of the property, including the site number. It will be of the dispute will be of civil nature and the party to identify their respective sites by proving their title and possession for the same before the civil court. Instead, respondent number 2 filed 2 separate complaints registered in crime number 66 of 2020 and 69 of 2020 of Alnahally Police Station, which is in clear abuse of process of law. Hence, the criminal proceedings is liable to be quashed accordingly. Yes, allowed.
For final hearing, serial number 15, S.D. Bhagwan, M.M. Ashok.
Petitioner in this case.
In view of disposal of the criminal petitions, yes, so and so pending. Yes.
Lord, appear for the petitioner. Lord, the offence is 1 under 406 and 477 A, my lord. Lord, matter is settled between the parties.
Last time also you made the same.
Settle ಆಗಿದೆ.
Settle ಆಗಿದೆ.
Settle ಆಗಿದೆ. ಅವ್ರ memo ಹಾಕ್ತಾರೆ.
File the memo, my lord. TD.
ಕೊಡಿ memo. Petitioner agreed to pay rupees 2,25,000.
Please, my lord, I have handed over the DD, my lord. Please.
Yes, DD you have received for
Please.
2,25,000.
2,25,000.
ಅವ್ರ ಹೆಸರಿನಲ್ಲಿ ಇದೆಯಾ ಅದು?
ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇದೆ ಮೇಡಮ್.
ಆಶೀಶ್ ಶಿಲ್.
ಆಶೀಶ್.
ಆಶೀಶ್ ಶೈಲ್ ಬಂದಿದಲ್ಲ, ಡಿಡಿ ಬಂದಿದೆ. ನಿಮ್ದು ತಕರಾರು ಏನಿಲ್ಲ. ನಿಮ್ಮ ಕಂಪ್ಲೇಂಟ್ ಕ್ವಾಶ್ ಮಾಡೋದಕ್ಕೆ ಏನು ತಕರಾರು ಇಲ್ಲ. Yes, could be allowed.
Please.
Then counsel for the petitioner and respondent are present. Then counsel for the petitioner and then counsel for respondent are present. The respondent, he is the petitioner.
He is the representative of the petitioner company, my lord.
Parties. Petitioner and respondent are identified by the respective counsel. The counsel for the respondent complainant filed a memo reporting settlement. The same reads as under. Next. You have not signed the memo. What do you read? The respondent who signed the memo accepts the terms of the settlement and acknowledges receipt of the demand draft in his name for this 2,25,000 and submits that he has no objection to quash the criminal proceedings. Submissions are placed on the top. In view of the criminal proceeding initiated against the petitioner is liable to be accordingly, I proceed to pass the following. Criminal petition is allowed. Respondent sign ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿ order sheet. He has to sign and you have to identify.
Please.
Allowed.
Grateful.
Obliged.
Shanti Bhushan.
The petitioners in this petition have heard the order passed by the trial court on the application made by the prosecution. The application under section 319 of the CRPC was made by the prosecution to include this person as accused. There is no charge sheet, in the charge sheet, the accused, this person's name has not been included. Subsequently, my lord, the further statement made by the complainant, she has clearly stated, I produced the further statement in case the.
Shanti Bhushan idara, you are representing.
My lord.
Who is for, you are representing the respondent.
Yes,
number
my lord. And also Shanti Bhushan also
two.
represents.
ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
Yes, ma'am.
Who is respondent number 2?
Is the complainant.
Complainant,
Where is he?
she is the complainant
ಅವ್ರು ಎಲ್ಲಿದ್ದಾರೆ?
and
ಅವ್ರು ಬಂದಿಲ್ಲ.
it is,
Pass over the matter, let him come.
it may be called 27th or 28th, I will also. But it is, here I am told that subsequently the complaint has, there is a divorce has taken place between the herself and husband. The petitioners are relatives, that's why they have not instigated the her husband to their family members to acute harassment.
Let him come, I'll pass over the matter.
Please, ma'am.
I'll take up at 2:30.
Please,
Come at 2:30.
please.
Patient copy.
Order ಅಂತ ಮಾಡಿ ಅಷ್ಟೇ. ಅದರಲ್ಲಿ ಒಂದು ಇದು ಹೇಳಿ, ಇವೊಂದು 1 minute. Even the criminal petitions pertain to 2 different criminal cases. Parties subject matter of the dispute and the allegations are similar and common. Therefore, I propose to take up both the petitions for disposal under the common order. Yes, 17.
And for the
Yes. What?
petition in this case.
Petitioner is sole accused,
Yes, all are the accused.
only one accused. Illa, there are, how many accused?
Five accused.
6.
6. One of these third accused is died, petitioner. Already in recorded. 30/12/2022. On Chiningi Gowda, third petitions died.
Died, he
Died.
died, abate ಅಂತ ಆಗಿದ?
Yes.
ಆಗಿದಲ್ಲ.
Brief facts of case is that the first petitioner and the second respondent,
1 minute, 1 minute. Is it a private complaint or a police complaint?
private complaint. Private complaint filed by the second respondent.
What are the offense alleged?
420, 120 and
465,
465,
406 and
406.
468 and 471.
468 and 471.
In all, how many accused? 8 accused.
8 accused.
Please read.
7 and 8 are the
Huh?
accused number 7 and 8 are the witnesses in the documents.
Please read, investigation not yet complete.
Complete charge sheet at filed.
Sheet 5.
Charge sheet at filed.
Where is the charge sheet?
Charge sheet at
Page number 44, ma'am.
44.
Para 17.
Please read that.
ದೋಷಾರೋಪ ಪಟ್ಟಿ ಕಾಲಂ ನಂಬರ್ 12 ಹೆಸರು ವಿಳಾಸ ನಮೂದಿಸರ್ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಆರೋಪಿಗಳು ಎಂದರೆ ಇವರ ಪೈಕಿ ಒಂದನೇ ಆರೋಪಿ ಯವನು ಮತ್ತು ಚಾಸಾ ಒಂದರ ಒಟ್ಟು ಸೇರಿ ಮೆಜರ್ಸ್ ಪ್ರಾಜೆಕ್ಟ್ ಬೆಂಗಳೂರು ಎಂಬ ಪಾಲುದಾರಿಕೆ ಸಂಸ್ಥೆಯನ್ನು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ವ್ಯಾಪಾರ
Oh,
ಜಾಗ
charge sheet is only against accused number 1 to 6.
not only 1 to 6.
What
The first respondent and first petitioner and second respondent have formed the partnership firm.
charge sheet is filed against 8 accused or 6 accused?
Major is 6 accused.
Major ಅಲ್ಲ, ಇಲ್ಲಿ ಹೇಳೋದೇ 1 to 6 ಅಂತ ಹೇಳಿ. Charge sheet
The 7 and 8 are only the witnesses in the documents.
They are not the accused in the charge sheet.
Yes.
So charge sheet is only against accused numbers 1 to 6.
1 to 6.
To 6.
A petition filed by the 1 to 6 only.
Yes, yes, proceed.
The first petitioner and the second respondent have constituted
Sir, please read.
forum.
it.
What?
Please read it so
Yes,
that
I read it,
I will
yes.
understand the facts of
Yes,
the case.
yes.
Yes.
ಮೆಸರ್ಸ್ ಒಂದು ಮತ್ತು ಒಟ್ಟು ಸೇರಿ ಮೆಸರ್ ಪೊಲೋ ಪ್ರಾಜೆಕ್ಟ್ ಬೆಂಗಳೂರು ಎಂಬ ಪಾಲುದಾರಿಕೆ ಸಂಸ್ಥೆಯನ್ನು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ವ್ಯಾಪಾರ ಹಾಗೂ ಜಾಗ ಹಾಗೂ ಕಟ್ಟಡ ಮಾರಾಟ ಮತ್ತು ಖರೀದಿ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮತ್ತು ಅಭಿವೃದ್ಧಿ ಲೇಔಟ್ ಪ್ರಮೋಷನ್ಸ್ ಇತರ ವ್ಯವಹಾರ ನಡೆಸುವ ಉದ್ದೇಶದಿಂದ ಪ್ರಾರಂಭಿಸಿರುತ್ತಾರೆ. ಈ ಮೆಸರ್ಸ್ ಪೊಲೋ ಪ್ರಾಜೆಕ್ಟ್ ಬೆಂಗಳೂರು ಎಂಬ ಪಾಲುದಾರಿಕೆ ಸಂಸ್ಥೆಯ ಕರಾರು ಪತ್ರವನ್ನು ದಿನಾಂಕ 17/5/2006 ಚಾಸಾ 3 ಮತ್ತು 4 ಸಮಕ್ಷಮ ತಯಾರಿಸಿ ದಿನಾಂಕ 20/5/2006 ಬೆಂಗಳೂರು ವ್ಯಾಪಾರ ಸಂಸ್ಥೆಗಳ ನೋಂದಣಾಧಿಕಾರ ಕಚೇರಿ ಬೆಂಗಳೂರು ಇಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ನಂಬರ್ ಸೋನ್ಸೋರಂತೆ ನೋಂದಣಿ ಮಾಡಿರುತ್ತಾರೆ. ಮೆಸರ್ಸ್ ಪೊಲೋ ಪ್ರಾಜೆಕ್ಟ್ ಬೆಂಗಳೂರು ಎಂಬ ಪಾಲುದಾರಿಕೆ ಸಂಸ್ಥೆಯ ಕರಾರು ಪತ್ರದಂತೆ ಸಂಸ್ಥೆಯಲ್ಲಿ ಚಾಸಾ 1ನೇರವರು 1ನೇ ಪಾರ್ಟಿಯಾಗಿ ಈ ಸಂಸ್ಥೆಯ ವ್ಯವಸ್ಥಾಪಕ ಪಾಲುದಾರ ಮ್ಯಾನೇಜಿಂಗ್ ಪಾರ್ಟ್ನರ್ ಆಗಿ ಈ ಸಂಸ್ಥೆ ಎಲ್ಲ ನಡೆಸುತ್ತಾ ಪ್ರತಿದಿನ ವ್ಯವಹಾರಗಳನ್ನು ದಾಖಲಾತಿಗಳಲ್ಲಿ ನಮೂದಿಸುವ ಹಾಗೂ ಸಂಸ್ಥೆಯ ಬ್ಯಾಂಕ್ ಖಾತೆಯನ್ನು ಚಾಸಾ 1 ಮತ್ತು ಆರೋಪಿ 1ನೇರವರು ಒಟ್ಟುಗೂಡಿ ನಡೆಸುವಂತೆ ಎಲ್ಲ ವ್ಯವಹಾರಗಳು ಈ ಇಬ್ಬರು ಪಾಲುದಾರರ ಗಮನಕ್ಕೆ ಬರುವಂತೆ ನಡೆಸಲು ಕರಾರು ಆಗಿರುತ್ತದೆ. ಪ್ರೊಲೋಗ್ ಪ್ರಾಜೆಕ್ಟ್ ಬೆಂಗಳೂರು ಎಂಬ ಪಾಲುದಾರಿಕೆ ಸಂಸ್ಥೆಯು ಉಲ್ಲಾಳ ಪೊಲೀಸ್ ಠಾಣಾ ವ್ಯಾಪ್ತಿ ಹಾಗೂ ಘನ ನ್ಯಾಯಾಲಯದ ವ್ಯಾಪ್ತಿಯ ಮಂಗಳೂರು ತಾಲೂಕು ಉಲ್ಲಾಳ ಗ್ರಾಮದ 9 ಕೆರೆ ಎಂಬಲ್ಲಿ ಹೊಂದಿರುವ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋರಲ್ಲಿ ಒಟ್ಟು ಸೋನ್ಸೋರಂತೆ ಒಟ್ಟು 11 ಎಕರೆ 57 ಸೆಂಟ್ ಒಟ್ಟು ಒಳಗೆ ಸರ್ವೆ ನಂಬರ್ಗಳನ್ನು ಖರೀದಿಸಿರುತ್ತಾರೆ. ಚಾಸಾ 1ನೇರವರು ಗಮನಕ್ಕೆ ತಾರದೆ ಆರೋಪಿ 1ರಿಂದ 6ನೇವರೆಗಿನ ಒಳಸಂಚು ನಡೆಸಿ ದಿನಾಂಕ 18/10/2008 ಮಂಗಳೂರು ತಾಲೂಕು ಉಲ್ಲಾಳ ಗ್ರಾಮದ 9 ಕೆರೆ ಎಂಬಲ್ಲಿ ಸೋನ್ಸೋರಂತೆ 2 ಎಕರೆ 7 ಸೆಂಟ್ ಜಾಗವನ್ನು 29,80,800ಗೆ ಸದರಿ ಸಂಸ್ಥೆ ಪಾಲುದಾರ ಆರೋಪಿ 1ನೇರವರು ಆರೋಪಿ 2ನೇಯವರಿಗೆ ಸಂಖ್ಯೆ 2ನೇಯವರಿಗೆ ಮಾರಾಟ ಮಾಡಿ ಮಾರಾಟ ಪತ್ರ ಸೋನ್ಸೋ. Thus all the sale deeds up to 5 sale deeds executed as per their
In favor of accused number?
Accused number 2 to 6. Accused number 1 execute alleged sale deeds in favor of the accused number 2 to
Sale deeds 5.
5 sale deeds.
Yes.
ದಿನಾಂಕ 10 ಸೋನ್ಸೋ ಕ್ರಮಸಂಖ್ಯೆ 1 ಆರೋಪಿ ಒಳಸಂಚು ನಡೆಸಿ ಚಾಸಾ 1ನೇರವರಿಗೆ ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶನ ಸುಳ್ಳು ಹೇಳಿಕೆಯನ್ನು ಒಳಗೊಂಡ ಸೇಲ್ ಡೀಡ್ ಅನ್ನು ಅಪ್ರಾಮಾಣಿಕವಾಗಿ ಬರೆದುಕೊಟ್ಟು ಚಾಸಾ 1ನೇರವರಿಗೆ ಅಕ್ರಮ ನಷ್ಟವನ್ನು ಉಂಟು ಮಾಡಿ ನಂಬಿಕೆ ದ್ರೋಹ ಎಸಗಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಆರೋಪಿ ಸಂಖ್ಯೆ ಸೋನಿಬುರಲ್ಲಿ ದೋಷಾರೋಪ ಪತ್ರ.
Yes.
Complaint, private complaint under 200 filed by the second respondent at page number 27, document number 3. Para 3 of the complaint.
Yes.
The complaint is the managing partner of Mr. Pallava Project Registered Partnership Firm. Accused number 1, Lokesh, is the partner. The said firm was registered in 17/5/2006. Registered Partnership Firm documents. Next to para 4. The said firm was purchased non-agriculture land of 11 acres 57 cents on 18/1/2007 under the registered documents.
Yes.
In para 5, the complainant itself says that the managing partner of Malo Project Firm has entered into an agreement of sale dated 5/5/2007 with one Somashekara Gowda.
Yes.
Gowda, Asan district so and so, property sold by the firm, purchased as per this sale deed dated so and so, sale consideration 16 lakhs per acre and received advance sale consideration of rupees 11,50,000.
Yes.
Before alleged sale deed, 1810-2008, the complainant itself is one of the partner as an enter into a sale agreement with one Somshekhar Gowda on 5/5/2007. The said Somshekhar Gowda has filed suit for passive performance and declarations of sale deed executed in favor of the executed by the first petitioner in favor of the petitioner 2 to 6 is null and void. Other relief, the suit for 245 of 2006, the suit for passive performance is pending before the civil court.
Somshekhar Gowda filed this
Files
against
including a complainant and firm and all the 6 accused.
No, before that, what are the rights of accused number 2 to 6? 2 to 6. They are
Including
stages.
because of sale deed executed by the sale agreement executed by the firm represented by the complainant.
Maybe, but
Yes.
you have not executed the sale deed in.
Yeah, you are not executed the sale deed, but
Somshekhar Gowda.
we are not executed the sale agreement with the Somshekhar Gowda.
The allegation is that
Yes.
you sold the property in.
The second first petition sold the property in favor of the
Accused number 2 to 6.
2 to 6.
Without the consent or knowledge of.
Knowledge of the complainant, and the said Somshekhar Gowda is also made as a party to that suit for passive performance.
Let's forget about Somshekhar Gowda.
Yes.
What is your stand regarding the 5 sale deeds, 4 or 5 sale deeds referred to by the complainant?
Yes.
Sale deeds.
5 sale deeds because of he is one of the partner. The first petition is the one of the partner has a right to execute the sale deed. He is execute the sale deed on behalf of the firm in favor of the 1 to 2 to 6. That in addition to that, the complainant himself now sought for one more suit for declaration that sale deeds executed by the first petitioner in favor of the petitioner 2 to 6 is null and void. File a suit for OS 20 of 2021 for declaration of sale deed and position other consequences relief against the accused.
That declaration and for cancellation of
Sale deeds in twice in 245 also in 20 of 2021 also.
in respect of 5 sale deeds.
5 sale deeds.
That is pending consideration.
Say pending consultations. We have produced the
Where is the partnership deed? What is your right?
partnership deed. I produced along with the last date of hearing, I produced the documents.
You claim right under the registered partnership. deed.
Yes, yes. In the said,
You produce yearly.
I produced on 27/1/2025 with the documents. First documents. First documents. This is the partition deed.
Partnership deed.
Partnership, sorry. Partnership deed.
Only 2 are the partners.
Both are partners.
Yes.
Clause number 4. Para 4. All the disputes, differences arising amongst the partners herein shall be referred to the arbitration only. And-
Arbitration clause.
Yes,
What is your right under the partnership? deed?
regarding business. Para 4, second clause, that is the business class. That partners shall be,
All the partners shall.
all these partners, that all the partners shall be charge of business affairs of the firm and shall attend to the day-to-day functions of the firm and shall be entitled to receive and spend the funds of the firm and to account of the same.
ಆಯ್ತು. All
Yes.
partners together ಆಯ್ತು. ನಿಮಗೆ ಎಲ್ಲಿದೆ ಸರ್ ರೈಟು?
All the partners, that is, I am the one of the partner. Major investments made by me.
ಅಂತಾರೆ either of them ಅಂತ ಹೇಳಲ್ಲ.
ಇಲ್ಲ.
All the
But
partners.
yes, facts of the case is, I am the major investors.
ಅದು ಎಲ್ಲಿದೆ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡೀಡ್ ನಲ್ಲಿ ಅದು
ಇಲ್ಲ, but that is the statement of accounts will declare in addition to that, the first petition filed a one declaration suit also in 201 of 2019. OS 201 of 2019 filed by the,
we are not concerned now. ನಿಮ್ಗೆ you are claiming right under the registered partnership.
Number one,
deed.
that
Where
is-
the clause ಅಂತ
That is,
ಕೇಳ್ತಾ
that is the case. Next, my arguments and the,
In
before,
in partnership deed, there is no such clause
no such class.
authorizing you to sell the property belonging.
All
to the-
business, all the partners at the business is be doing.
So why you are seeking quashing of the agreement?
Hello, because of, before I going to alienate the, I alienate the property in 2008. 2007 itself, without my consent, he is entering into the sale agreement, received the amount. 5/5/2000 itself.
You should have initiated arbitration proceedings. You should
No,
have
I am
come
not,
to
because of their initiated arbitration proceedings.
simply because he executed.
They have already initiated,
Simply because he entered into agreement for sale.
yes, receive the amount.
The properties, that is your trend.
Not only all the properties, not only all the
Which properties,
only that total,
not justify your conduct.
none, total extent of properties purchased by the partnership firm is 16.5 acres, 16 acres, 73 cents in total extent of the land purchased by the firm.
Convinced with your stands.
We are, number one, 5/5/2007 itself is entered into agreement, sold the property in favor of the Somshekhar Gowda. In that, in addition to that, he has also, without the knowledge of the first petitioner partner, he has created one more partnership in the same office address to collude with other peoples.
What is, whether you have taken any steps?
You are already filed a suit for declaration.
You have filed
I am filed.
declaration.
There is a suit for declaration against the complainant and others.
What is the declaration?
Declaring that property in the name of the complainant is declared as a partnership firm property. The suit will be decreed. That filed the RFA, they filed the RFA, it is admitted.
Yes, what is?
So many civil suits, more than 10 to 12 suits.
Arbitration proceedings initiated.
Arbitration proceedings initiated by the complaint itself. They have filed the commercial arbitration before the commercial court.
Filed.
The petition, the first petitioner, the first respondent, second respondent, complainant. In documents, additional documents filed by me. In the same documents, that is second document.
Arbitral proceedings is pending.
Now, commercial arbitrations filed by the complainant representing the firm against the first respondent, first accused. That application for interim applications will be rejected by the commercial court. Then they file the appeal before the this court.
Arbitral proceedings is
Arbitration proceedings, they will issue notice, they file the arbitration proceedings before this court.
against accused number one.
Yes.
That is still pending.
That is, I think, I recently know that because of is withdrawn by the respondent.
When that was initiated?
Initiated on
ಅದೇ ನಮ್ದು ಏನು ಅಂದ್ರೆ ನಮ್ದು ಡಿಕ್ಲರೇಷನ್ಸ್ ಹಾಕಿದೆ ದಟ್ ಈಸ್ ಪೆಂಡಿಂಗ್.
Petition ಹಾಕಿದ್ದೀರಾ? Petition ಆಗಿದೆ.
ಪೆಂಡಿಂಗ್
ಯಾರ ಮುಂದೆ?
ಟೋಟಲ್ 57
date is not
declaration.
mentioned in the petition.
ಹಾಕಿಲ್ವಾ?
Arala.
ಹಾಕಿಲ್ವಾ?
2022.
You filed the suit for declaration.
Yes.
The suit number was
OS number 201 of 2019. That is judgment and decree produced along with the documents.
that was decreed.
Decreed.
RFA is pending.
RFA is pending.
Again, what is the suit relief in that case?
Whether the subject matter of these five sale deeds are subject matter in the.
No, because of their forum properties involved. Other survey numbers are involved in that.
Whether the subject matter of five sale deeds are subject matters in the arbitral proceeding.
Yes, because of arbitrations sought for the, as per the arbitrations clause, they'll sought for the arbitrations. Arbitration CMP number 451/2022 initiated by them, they subsequently they will.
Are also subject matter?
Yes.
Can't be taken in the court.
Yes.
Please, I beg to, sir. One, my lords, I beg to take the honorable court to the cause title itself of the petition. Kindly see the cause title of the petition. Cause title of the petition, my lords. Petition number 1. D. Lokesh, son of late Dasappa. Petition number 1. His brother is a second petitioner. Purchaser. Second petition is his brother. Our case is fictitious sale deed is executed to defraud the rightful ownership of the firm and the partner, complainant. Number 2 is his brother, petition number 1's brother. And also accused number 6, Sinappa. So 1, 2 and 6 are brothers. Are the staff of the bar and restaurant which accused number 1 is operating. Now I beg to take the honorable court to the complaint at,
What about others?
my lord, out of 6 persons, according to us, 1, 2 and 6 are brothers. My learned friend says 2 is not brother, but there's a pleading in the complaint, which is
Yes.
not denied till now. 1, 2, 6 and brothers. 3, 4 and 5 are the staff in the bar and restaurant of A1. What A1 does is, his intention is to knock off the properties of the firm. What he does is, even though he has no authorization, my lords, he claims himself that he is authorized and enters into a fictitious sale deed. Now kindly come to the complaint, page 27, it starts. I beg to take the honorable court to recital number para 5, that, my lord, with the consent of everybody, para 5, my lords, sale deed is already executed, my lords, in respect of very same properties for 16 lakhs.
Have you taken any steps on civil, before civil? court?
Yes, that I will come to that. We have taken steps, my lords, for the invalidating these deeds.
See, as per the terms of the registered partnership deed,
Please, my lords.
disputes are to be referred to the arbitration.
May I beg to submit on this aspect, my lords. Now I am informed, my lords, civil suits are filed for declaration that the sale deeds are bad in law, are not enforceable, my lords.
You filed it?
Yes, yes, my lords.
When?
Civil suits-
2021.
2021. Civil suits are filed, my lords. And also, earlier, my lord, 16 lakhs rupees have come to the bank account of the firm by virtue of an agreement entered into in favor of Somshekar. That account money has come to the firm. Para 5 recitals, my lord.
Consideration amount under 5 sale deeds?
ಬರ್ಲಿಲ್ಲ. ಇದು ಮೊದಲು ಒಂದು ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ. To defraud the sale deed executed in favor of Somshekar, our 16 lakhs has come to the firm.
Sale
Bank
agreement.
account of the firm it has come, my lords. To defraud that and defraud everybody, the complainant hatches criminal conspiracy with the brothers and staff. What he does is, my lord, fictitious sale deed he executes. Now, as far as this recital is concerned, my lords, I beg to take my lords directly to page 31. After stating that 5 fictitious sale deeds are executed, how it is fictitious, my lords? And kindly appreciate, this sale deed is executed, 5 sale deeds are executed after 16 lakhs rupees has come to the bank account by virtue of the sale made in favor of Somshekara.
What is the amount? 11 lakhs or 16 lakhs?
16 lakhs
Corporation.
total. Adrolage, sorry. 11 lakh 50,000 has come to the firm account, Corporation Bank, Rajarajeshwari Nagara, Bangalore. Adu document number 3, along with the complaint. Now, my lords, to defraud everybody, he says he executes unauthorizedly 5 sale deeds. Now, my lords, page 31, I beg to read. Of the,
Where the amount has gone?
In 2008, sale deeds executed
where
in
the amount has gone, the 5 sale deeds.
Let him make his position clear.
2008, sale deeds is executed.
5 sale deeds ಅನ್ನ ತಾವು ಕೇಳಿದ ಪ್ರಶ್ನೆ.
1 minute.
Yes.
Let him make his position clear.
In 2008, sale deeds was executed in favor of the others. That is the accused,
Accused number 2 to 6.
2 to 6.
Ah.
Is that, that facts known by the,
Sir, I am not on that.
I will
very
take it,
simple.
because of petition has taken the amount.
What is the consideration amount?
In
Which
the,
amount it has
first petition has taken the consideration amount. First petition has taken the consideration, as per the documents, First petitioner taken the consideration amount and execute the sale deed in favor of the person. In 2008,
When the registered partnership deed does not permit you to enter into, sell the properties.
with consent of the oral consent of the complainant itself, you are executing 2008. Is keep quiet. Is not taken any steps still from 2008. Still from he is a managing partner. Is not taken any. If at all, I'll execute the sale deed
You can
without.
take the defense, but not a case for quashing.
No, not only that, because of is not only that, instead of not, he says,
Cannot hold a mini trial here, whether you
not-
are justified or not. Prima facie, you sold the property without any authority.
in addition to that, the complaint filed by the complaint, that is the second respondent, without filed any affidavit, supporting affidavit, as per the judgment of the court,
Curable defense.
that is number one.
Great.
Number one. Number two is because of Babu Venkatesh's judgment, because of so many civil suits. Civil suit after civil suit, declaration suits,
ಅದೆಲ್ಲ ಇರ್ಲಿ.
that were pending before the trial courts.
But admittedly, you have no authority to sell the property under the registered partnership. deed.
Is in 2008, their complaint filed in 2019. If at all is in a partnership, is a managing partner, managing the affairs of the day-to-day affairs of the managing firm properties, why should he not take the issue?
On the
Is know that, is not that the whole things will be know that in the 2000 itself. In consent of this complaint itself, he sold the property. Is keep quiet up to 2019,
These sale deeds are of the year 2008.
year 2008.
Only on the ground of delay can the criminal proceedings quashed.
No, not only delay, it's circumstances in which,
Apex court has made it very clear.
yes, exactly.
Only on the ground of delay, you cannot quash the criminal.
Yes. Not only delay, even in midst of the case is concerned, they are not filing supporting affidavit.
Curable defect.
But that is, even then in the civil case, more than 10 civil disputes, counter suit and counter suits between the parties. In addition to that, arbitration clause is available in as per the arbitration clause. The first, the court, issue the process itself has no jurisdiction to entertain the complaint, because the arbitration clause is available at the time of filing the complaint. Along with the complaint, the arbitration, petition, copies of the arbitration.
The prima facie, there is cheating by one partner against the other.
No, because of is not cheating, because of his knowing.
There are
He is an investor, sir. He is an investor. He is only the nominal partner. So because of,
intentions are not supported by the terms of registered partnership deed. That is what I am saying.
that disputes, all disputes will go before the arbitrator. All disputes, only, that is a sentence used by the clause, all disputes and arbitrator only to conclude that is the thing, sir.
Quashing Baralas. Petitioners being accused numbers 1 to 6 are seeking to quash the criminal proceedings initiated against them. Initiated against them. Now pending in CC number 103 of 2020 on the file of first additional senior civil judge and CJM Mangalore, Dakshina Kannada. Registered for the offence punishable under section 120B, 418, 420, 465, 406, 468, 471. Bracket nalli arising out private complaint, EC number 27 of 2019. Brief facts of the case are that respondent number 2 as complainant filed the private complaint PCR number 27 of 2019 against accused numbers 1 to 8, alleging commission of the offences as stated above. It is the specific contention of respondent number 2 that he entered into a registered partnership deed with accused number 1, which is dated 17/5/2006. As per the terms of partnership deed, respondent number 2 was the managing partner. And both the partners were jointly agreed to operate the bank accounts. The grievance of the complainant is that accused number one, who had no authority to alienate the property belonging to the partnership, got executed the registered sale deeds in favor of accused number 2 to 6 without the knowledge or permission of accused number 1. The sale considerations were received by accused number 1 without crediting it to the bank account of the partnership firm. It is also the contention of the complainant that the accused numbers 1, 2, and 6 are the brothers. Accused number 3, 4, and 5 are the employees working under accused number 1. Therefore, it is the contention of the complainant that the sham documents are executed by accused number 1 in favor of his brothers and employees to defraud respondent number 2 and thereby committed the offense so and so. The trial court referred the matter for investigation. After investigation, charge sheet came to be filed. The trial court took cognizance of the offense and registered CC number so and so. The petitioners being mentioned. The investigation charge sheet came to be filed against accused numbers 1 to 6 for the aforesaid offences.
Offense change ಮಾಡಿದ್ದಾರೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಪೇಜ್ 35. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ offense ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಅದೇ ಚಾರ್ಜ್ ಶೀಟ್ offense ಬೇರೆ ಇದೆ.
Page 35 please. 120B, 417, 418, 406, 420, 423.
Charge sheet came to be filed against accused numbers 1 to 6 for the offense under section 120B, 417, 418, 406, 420, 423 of IPC. While dropping section 466, 468, 471, while including section 417 of IPC. The trial court took cognizance of the offense, registered CC number so and so. Petitioners being accused numbers 1 to 6 have approached this court seeking to quash the criminal proceedings. This of justice heard so and so. The counsel for the petitioner contended that admittedly respondent number 2 and accused number 1 are the partners of the partnership firm, registered partnership firm, and the partnership deed is dated 17/5/2006. Respondent number 2 admittedly entered into an agreement to sell with one Somshekhar Gowda on 5/5/07 without the knowledge and consent of accused number 1 and agreed to sell one of the properties of the firm for rupees 16 lakhs, out of which he received rupees 11,50,000 as advance. When respondent number 2 could enter into an agreement to sell with third parties to sell the property and accept the consideration amount without the consent and knowledge of accused number 1, respondent number 2 cannot have any grievance against the petitioner for the 5 sale deeds executed by him in favor of accused number 2 to 6. It is also the contention of the learned counsel for the petitioner that as per the terms of the registered partnership deed, there is an arbitration clause and the dispute between the parties is to be referred to the arbitration. Similarly, respondent number 2 has initiated arbitral proceedings which is pending consideration. Respondent number 1, respondent number 2 has also filed a suit for declaration. That is the suit OS 201 is filed by,
the first petitioner.
case number 1 filed the suit for declaration. Declaration of his title.
Declarations of the property stand in the name of the second respondent declared as a forum properties,
Whether the subject matter of the sale deeds.
not subject property, other properties, forum other properties.
Declaration in OS 201 of 2019, which was decreed, and respondent number 2 has preferred RFA, is pending consideration by this court. There are civil litigations between the parties, and therefore initiation of the criminal proceedings is in abuse of process of law, hence prays for allowing the petition and to quash the criminal proceedings. For contra, learned senior advocate for respondent number 2 and the learned HCP for respondent number 1 opposing the petition submitted that repeatedly registered partnership deed was entered into between respondent number 2 and accused number 1. No right is given to accused number 1 to alienate the properties belonging to the firm without joining hands with the petition, with the respondent number 2. Accused number 1, 2, and 6 are the brothers, and accused number 3, 4, 5 are the employees working under accused number 1. Under such circumstance, therefore, it is clear that accused number 1, without the knowledge of respondent number 2, sold several items of properties in favor of his kith and kin under 5 different sale deeds and appropriated the sale consideration, thereby committed the offences as next paragraph. A senior advocate contended that with regard to the agreement to sell referred to by the learned counsel for the petitioner, entered into between respondent number 2 with one Somashekar, agreeing to sell one item of the property and receiving the advance of rupees 11.50 lakhs. The said amount is credited to the bank account of partnership firm.
They are not produced any documents to show that
That
they
is his
deposited in bank.
This submission I am
Yes,
referring.
sorry.
Document sir.
He's not-
Credited to the bank account of partnership
Statement account.
firms. But the same was not misappropriated by respondent number 2. On the other hand, in respect of the sale consideration amount received by accused number 1 under 5 different sale deeds executed in favor of accused number 2 to 6, not even a single paisa was credited to the bank account of partnership firm. But on the other hand, the entire amount was misappropriated by accused number 1. Under such circumstances, it is a clear case of criminal breach of trust, criminal breach of trust to the cheating. Yes, cheating committed by accused number 1, and therefore the trial court was right in taking cognizance of the offence on the basis of the materials collected by the investigating officer while filing the charge sheet. No grounds are made out for quashing the criminal proceedings. Next paragraph. He further submitted that merely because we further submitted that even though arbitral proceedings were initiated by respondent number 2, the same was in respect of some other properties and not in respect of the subject matter of the sale deeds executed by accused number 1. Under such circumstances, he prays for dismissal of the petition. The petitioner contentionally mentioned says the counsel contended that the respondent number 2, while filing the private complaint, has not filed any affidavit in compliance of the directions issued by the Honorable Apex Court in Priyanka Srivastava, so and so. There is no ordinary delay in filing the suit, and therefore the petition is to be allowed. The league says.
SAS ಅಂತ ಇತ್ತೀಚೆಗೆ
Answer to the
kindly pardon me, SAS Infratech ಅಂತ 2024 Supreme Court distinguished that my lords, recently. May I pass on with your lords. Otherwise, in 482, that cannot be a ground. That's what Supreme Court says.
Even.
Distinguished it.
Even otherwise it is held, it
Yes.
is a curable
Cure,
defect.
460.
You
Oh.
can cure it.
Please, that's what Supreme Court distinguished.
My answer to the above point is in the negative for the following reasons. It is the specific contention of respondent number 2 that he entered into a registered partnership deed dated 17/5/2006 with accused number 1 and were carrying on the business under the name and style measures Parlok projects of so and so. This fact is not in dispute. Even accused number 1 admits that he is one of the partner with respondent number 2 under the registered partnerships at 17/5/2006. Then counsel for the petitioner fairly concedes that no terms of the registered partnership deed entitles accused number 1 to sell any portion of the properties belonging to the firm unilaterally. However, he justifies the stand of accused number 1 in executing 5 different sale deeds in favor of accused number 2 to 6 on the ground that respondent number 2 himself entered into an agreement to sell on 5/5/2007 with one Somashekar Gowda, agreeing to sell one of the properties for rupees 16 lakhs, and out of which he received rupees 11,50,000. It is the specific contention of the complainant that the advance amount of rupees 11,50,000 received by Somashekar Gowda was not taken away by respondent number 2, nor he misappropriated the same, but the entire amount was credited to the bank account of partnership firm. He relies on the statement of the bank produced with these objections in support of his contention. However, admittedly, the sale consideration amount under the 5 disputed sale deeds executed in favor of accused number 2 to 6, the sale consideration amount was never credited to the bank account of the partnership firm, but the same was taken by accused number 1. When the terms of the registered partnership deed dated 17/5/2006 does not authorize accused number 1 to sell the properties under the sale deed without bringing it to the notice of respondent number 2, and moreover, when admittedly accused number 1 appropriated the sale consideration amount under 5 different sale deeds, I am of the opinion that there are prima facie materials to support the contention of the complainant that he was cheated. Accused number 1 misappropriated the amount, and there is criminal breach of trust. Simply because there is delay in filing the complaint, the same cannot be the sole ground to quash the criminal proceedings. That's correct. Regarding the contention of the learned counsel for the petitioner that there is non-compliance of the directions issued by the Honorable Apex Court in Priyanka Srivatsal, and no affidavit is filed to suggest compliance of the requirements of section 154(3) of CRPC. It is the contention of the learned counsel for respondent number 2. Arpodi but
My lord, fast in protect, my lord. That number is.
ಅಲ್ಲ ಅದು ಕೇಸ್ ಇದನ್ನು ಕೊಡಿ ಅಷ್ಟೇ
ಕೊಡಿ
ಪಾರ್ಟೀಸ್ ನೇಮ್ ಕೊಡಿ ಇದನ್ನು ಕೊಡಿ
Fast in protect, my one paragraph to read, my lord. Subject of transfer land on Priyanka Srivatsal. To submit a complaint so was not supported by affidavit. In our opinion, that the observation has been made in the said case by way of abundant caution to see that frivolous complaints are avoided. So saying, on the Supreme Court says, my lord, this is not a ground under 480
Yes. No, it was in counsel for respect number 2 places reliance on so and so to contend that the same cannot be quash the criminal proceedings. If at all, it is a curable defect, the same can be cured by respondent number 2 if suggested by the learned magistrate.
It's a state of the law.
Next paragraph. Even though it is the contention of the learned counsel for the petitioner that arbitral proceedings was initiated and pending consideration, admittedly, the subject matter of the sale deeds which are in dispute are not the subject matter of the arbitral proceedings or the suit for declaration filed by respondent number 2, filed by number 1. Under such circumstances, I am of the opinion that there are prima facie materials to proceed against the petitioners, and it is not a fit case for quashing the criminal proceedings. Hence, I answer the above point in the negative and proceed to pass the following. Question is dismissed.
Yes, great. I'll pass on the copy immediately. One few moments.
Number 18,
Of them.
Gaurav G K, B.N. Balasubramanian.
I appear for the petitioner, my lord. The matter is settled.
Settled.
But I have no objection to filing affidavit through petition respondent.
What do you have to do?
Good.
ಏನಿದು?
Four petitioners, my lord. Petitioner number 1 is present before this honorable court. Filed an application under 320 and the affidavit of.
1 minute.
Please.
Who are present now? Accused
Petitioner
number 1.
number 1 and respondent number 2, my lord, the de facto complaint.
They are the husband and wife.
Yes, ma'am. Now the divorce has been. Okay.
Rahul, Somanna,
Please.
ನೀವು, Mrs. Pavitra. Is this filed jointly?
It is filed jointly, my lord. There are 4 accused. 4 petitioners before this honorable court.
Learned counsel for the petitioner and respondent number 2 submit in unison that the parties have settled their dispute amicably. Petition number 1 and respondent number 2 are present before the court and they are identified by their respective counsels. Learned counsel for the petitioner filed application under section 320 of CRPC seeking permission of the court to compound the offense. The offense alleged against accused number 1, petition number 1, against the accused number 1 to 3, 1 to 4, being the petitioner's hearing, for the offense under section 498A, 323, 504, 506, with section 34 of IPC and under section 4 and 3 and 4 of BP. Next paragraph. The respondent who is present before the court personally filed the affidavit while admitting the compromise entered into between parties and seeking compounding of the offense. Else. Application under section 320 of CRPC reads as under. Next, the affidavit sworn to by respondent number 2 reads as under. Next paragraph. Petitioner number 1 and respondent number 2 admit the terms of the application as well as the affidavit. And respondent number 2 specifically state that she has no objection to allow the petition. You have no objection to allow the.
No, I have no objection.
Party.
Please, ma'am.
Satisfied with the terms of compromise? in view of the criminal proceedings initiated against the petitioners is liable to be quashed. Accordingly, I proceed to pass the following. Petition is allowed, criminal proceedings so and so quashed. They have to sign the order sheet.
Please.
Right.
You have to identify them.
Please.
Serial number 19 for admission, C.A. Karambaya, Bhargavji.
Petitioners are accused number 1 to 5 in crime number 91 of 2019, madam.
There are only 5 accused.
Yes,
What are the offense alleged?
under section 323, 504, 506 and 34 of IPC. Section 31 RS 32, 5A and 8 of SC/ST Atrocities Act. The petitioners are working in PWD office at Medicare division, madam. The second respondent is a contractor.
Yes.
Your Lordship may kindly see page number 17 is the complaint.
No investigation was undertaken.
No, no.
No, my lord.
But there was
Not
stay.
yet complete.
According to the second respondent, my lord, on 30/11/2019 at 11 a.m., he went to the office of the PWD.
Date of complaint?
Complaint is after 1 month, 30/12/19.
2000.
The alleged allegation incident took place on 30/11/2019 at 11 a.m.
11 a.m.
Whereas the complaint is made on 30/12/2019 at 5:30 p.m.
No, as per FIR,
Yes,
the date of offense is from 30/11/19 to 23/12/2019.
yes, yes,
Yes, what is the allegation? Please read it.
yes, complaint, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯ ಮಡಿಕೇರಿ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆ ಕೆಪಿ ಪ್ರಕಾಶ್ ಮತ್ತು ಪಿಕೆ ವಿನೋದ್ ರವರು ಜಾತಿ ನಿಂದನೆ, ಕೊಲೆ ಬೆದರಿಕೆ ಮತ್ತು ಮಾನಹಾನಿಯಾಗುವ ಬಗ್ಗೆ ಪುಕಾರು. ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ಕಾಯಂ ನಿವಾಸಿಯಾಗಿದ್ದು 3ನೇ ದರ್ಜೆ ಸಿವಿಲ್ ಗುತ್ತಿಗೆದಾರನಾಗಿ 15 ವರ್ಷಗಳಿಂದ ಗುತ್ತಿಗೆ ವೃತ್ತಿ ಮಾಡಿಕೊಂಡು ನೆಮ್ಮದಿಯಿಂದ ಜೀವನ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿದ್ದೇನೆ. ನಾನು ಆದಿ ಕರ್ನಾಟಕ ಹೊಲೆಯ ಜಾತಿಗೆ ಸೇರಿದವನಾಗಿದ್ದು ಗೌರವಿತನಾಗಿ ಬದುಕು ಸಾಗಿಸುತ್ತಿದ್ದೇನೆ. ಇತ್ತೀಚೆಗೆ ನಾನು ಟೆಂಡರ್ ಗುತ್ತಿಗೆ ಕಾಮಗಾರಿಯನ್ನು ನಿರ್ವಹಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದು ಗುತ್ತಿಗೆ ವಹಿಸಿದ ಕಾಮಗಾರಿಗಳನ್ನು ಪೂರ್ಣಗೊಳಿಸಿದ್ದು ಬಿಲ್ಲು ಕೇಳಲು ಈ ಮೇಲೆ ಹೇಳಿದ ವ್ಯಕ್ತಿಯ ಬಳಿಗೆ ಹೋದಾಗ, ನೀನು ಹೆಬ್ಬೆಟ್ಟು, ನಿನಗೆ ಈ ಕೆಲಸಗಳೆಲ್ಲ ನಿನಗೆ ಸರಿಯಲ್ಲ, ನೀನು ಜೀತಾಳಾಗಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಇರಬೇಕಾಗಿತ್ತು, ನೀನೇನು ಬಿಲ್ಲು ಕೇಳುತ್ತೀಯಾ ಎಂದು ನನ್ನ ಮನಸ್ಸಿಗೆ ತುಂಬಾ ನೋವು ಉಂಟಾಗಿ ಮಾಡಿರುತ್ತಾರೆ. ದಿನಾಂಕ 30/11/2019 ಬೆಳಿಗ್ಗೆ 11 ಗಂಟೆಗೆ PWD ಕಾರ್ಯಾಲಯಕ್ಕೆ ಅಭಿಯಂತಕರ ಕಚೇರಿಗೆ ತೆರಳಿದಾಗ ಬಿಲ್ಲಿನ ಬಾಬ್ತು ಚೆಕ್ ಅನ್ನು ಕೇಳುತ್ತೇನೆ ಎಂದು ಆ ಸಂದರ್ಭದಲ್ಲಿ ಏಕಾಏಕಿಯಾಗಿ 2 ವ್ಯಕ್ತಿಗಳು ನನ್ನನ್ನು ಉದ್ದೇಶಿಸಿ ನೀನು ಹೊಲೆಯ ಜಾತಿಗೆ ಸೇರಿದವನಾಗಿದ್ದು ನೀನು ಜೀತಾಳಾಗಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿರಬೇಕಾಗಿತ್ತು, ನೀನು ನನ್ನಲ್ಲಿ ಬಿಲ್ಲು ಕೇಳುವ ಸಮಯಕ್ಕೆ ಬಂದಿದ್ದೀಯಾ, ನಿನ್ನ ಮೇಲೆ ಕೃತ್ಯಲೋಪದ ಕೇಸು ದಾಖಲು ಮಾಡಿ ನಿನ್ನನ್ನು ಜೈಲಿಗೆ ಕಳುಹಿಸ್ತೀನಿ ಎಂದು ಧಮಕಿ ಹಾಕಿರುತ್ತೇನೆ. ನೀನು ಹೆಂಡ ಕುಡಿದುಕೊಂಡು ರಸ್ತೆಯಲ್ಲಿ ತಿರುಗಾಡಬೇಕಾಗಿರುವ ನಿನಗೆ ಈ ಕೆಲಸ ಯೋಗ್ಯವಲ್ಲ ಎಂದು ಅವ್ಯಾಚ ಶಬ್ದಗಳಿಂದ ಹೇಳಿ, ನೀನು ಇನ್ನು ಮುಂದೆ ನನಗೆ ಮರ್ಯಾದೆ ಕೊಟ್ಟು ಮಾತಾಡು ಎಂದು ದಬಾಯಿಸಿ ಕೇಳಿದ್ದು ಕೆಪಿ ಪ್ರಕಾಶ್ ಪ್ರಥಮ ದರ್ಜೆ ಲೆಕ್ಕ ಸಹಾಯಕನವರು ನನ್ನ ಕುತ್ತಿಗೆಗೆ ಕೈ ಹಾಕಿ ಎಡ ಕೈಯಿಂದ ಕುತ್ತಿಗೆ ಹಿಡಿದುಕೊಂಡು ಆತ ಬಲಗೈಯಿಂದ ನನ್ನ ಮುಖಕ್ಕೆ ಹೊಡೆದಿರುತ್ತಾನೆ. ಕಚೇರಿ ಬಾಗಿಲಿನ ಹೊರ ಬರುತ್ತಿದ್ದಾಗೆ 10% ಹಣವನ್ನು ನನಗೆ ಒತ್ತಾಯಪೂರ್ವಕವಾಗಿ ಕೇಳಿರುತ್ತಾನೆ. ನಾನು ಈ ವಿಷಯ ಬಗ್ಗೆ ಮೇಲಾಧಿಕಾರಿಗಳ ಗಮನಕ್ಕೆ ತಂದಿರುತ್ತೇನೆ. ತಿಳಿಸಿದರೂ ಸಹ ಅವರು ಈವರೆಗೆ ಯಾವುದೇ ಕ್ರಮ ಕೈಗೊಂಡಿರುವುದಿಲ್ಲ. ಆದ ನಂತರ ದಿನಾಂಕ 23/12/2019 ಮತ್ತೆ ಬಿಲ್ಲಿನ ಬಗ್ಗೆ ವಿಚಾರಿಸಿದಾಗ ಪುನಃ ಅದೇ ರೀತಿ ದುರ್ವರ್ತನೆ ವರ್ತಿಸಿರುತ್ತಾರೆ ಹಾಗೂ ಕೆಲವು ಪತ್ರಗಳನ್ನು ಒತ್ತಾಯಪೂರ್ವಕವಾಗಿ ಸಹಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಹೊರಗುತ್ತಿಗೆ ನೌಕರರಾದಂತಹ ಅನಿತಾ ಹಾಗೂ ದೀಕ್ಷಾರವರು ಕೂಡ ಶಾಮೀಲಾಗಿರುತ್ತಾರೆ. ಹಾಗೆಯೇ ಲೆಕ್ಕ ಸಂಶೋಧಕಾಧಿಕಾರಿ ರಮೇಶರವರು ಬಳಿ ಹೇಳಿದಾಗ ನೀನು ಅವನನ್ನು ನಿಷ್ಠುರ ಮಾಡಿಕೊಳ್ಳುತ್ತೀಯಾ, ಅವನು ನಿನ್ನನ್ನು ಕೊಲೆ ಮಾಡಿ ಬಿಡುತ್ತಾನೆ ಎಂದು ಇವರು ಎದುರಿಸಿರುತ್ತಾರೆ. ಇವರುಗಳ ಮುಂದೆ ತಗ್ಗಿ ಬಗ್ಗೆ ನಡೆಯಬೇಕೆಂದು ಬೆದರಿಕೆ ನೀಡಿರುತ್ತಾರೆ. ಈಗಾಗಲೇ ಸದರಿ ಲೆಕ್ಕ ಸಹಾಯಕರುಗಳು ಕಚೇರಿಯಿಂದ ವರ್ಗಾವಣೆಯಾಗಿದ್ದು ಅಧಿಕಾರಿ ದಹದಿಂದ ಬೇರೆಡೆಗೆ ಹೋಗದೆ ಕೆಲಸವನ್ನು ದುರುಪಯೋಗಪಡಿಸುತ್ತಿದ್ದಾನೆ ಹಾಗೂ ಇಂತಹ ದುರ್ವರ್ತನೆ ನಡೆಯುತ್ತಿರುವ ಅಧಿಕಾರಿಗಳು ಬೇರೆಡೆಗೆ ವರ್ಗಾಯಿಸಿ ಗುತ್ತಿಗೆದಾರರ ಕಾರ್ಯಕಾರಿ ನಿರ್ವಹಿಸಲು ಅನುವು ಮಾಡಬೇಕಾಗಿದೆ ಮತ್ತು ನನ್ನ ಮೇಲೆ ದೌರ್ಜನ್ಯ ನಡೆಸಿದ ಇಂತಹ ಸಿಬ್ಬಂದಿಗಳ ಬಗ್ಗೆ ನನ್ನ ಸಮುದಾಯದ ಗುತ್ತಿಗೆ ನಿರ್ವಹಿಸಲು ಅನುವು ಮಾಡಿಕೊಳ್ಳಬೇಕು ಹಾಗೂ ದಿನಾಂಕ 17/12/19 ಕಚೇರಿಗೆ ಹೋಗಿ ಬಿಲ್ಲು ಕೇಳಿದಾಗ ಯಾವ ಬಿಲ್ಲು ಕೊಡಬೇಕು ಎಂದು ಸಹ ಅದೇ ರೀತಿ ವರ್ತನೆ ಮಾಡಿರುತ್ತಾರೆ. ಈ ಎಲ್ಲ ಪ್ರಕರಣಗಳಿಗೆ ಸಾಕ್ಷಿಯಾಗಿ ಮಂಜುನಾಥೇಗೌಡ, ಕುಮಾರ HL ಹಾಗೂ ಕೆಂಚೇಗೌಡ ಅವರು ಇರುತ್ತಾರೆ. ಕೆಪಿ ಪ್ರಕಾಶ್ ಮತ್ತು PK ವಿನೋದ್ ಕುಮಾರ್ ಇವರಿಗೆ ನನ್ನ ಜಾತಿಯ ಪೂರ್ಣ ಅರಿವಿದ್ದುದರಿಂದ ಈ ರೀತಿ ಜಾತಿ ನಿಂದನೆ ಮಾಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ನನಗೆ ಆತ್ಮಹತ್ಯೆ ಮಾಡಿಕೊಳ್ಳಬೇಕೆಂದು ಸಂದರ್ಭದಲ್ಲಿ ನನ್ನ ಕುಟುಂಬದವರು ನನ್ನ ಮನವೊಲಿಸಿ ಕಚೇರಿಯಿಂದ ನ್ಯಾಯ ಸಿಗಬಹುದೆಂದು ಈ ದಿನದಿಂದ ಕಾದಿರುತ್ತೇನೆ. ನನಗೆ ಬದುಕಲು ಅನ್ಯಾಯವಾದ ಕಾರಣ ಈ ಮೇಲ್ ಕಾಣಿಸಿದ ವ್ಯಕ್ತಿಗಳು ನಿರ್ಮಾಣ ಮಾಡಿದ ಇವರಿಗೆ ಇಷ್ಟು ದಿನವಾದರೂ ನ್ಯಾಯ ಸಿಗಲಿಲ್ಲ. ಕಾರಣ ಈ ದಿನ ತಡವಾಗಿ ದೂರು ಸಲ್ಲಿಸುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ವ್ಯಕ್ತಿಗಳ ಮೇಲೆ ಜಾತಿ ನಿಂದನೆ ಪ್ರಕರಣ ಮಾಡಿಸಿಕೊಡಬೇಕೆಂದು ನನ್ನ ರಕ್ಷಣೆ ನೀಡಬೇಕಾಗಿ ಈ ಮೂಲಕ ಕೇಳುತ್ತೇನೆ.
Yes.
This is the allegation. Your Lordship may kindly see the next annexure C, my lord, at page number 20. On 30/11/2019, these petitioners have made a complaint to the executive engineer PWD. May I read one?
Yes.
ವಿಷಯ CP ಸಿದ್ದೇಶ್ವರ ಗುತ್ತಿಗೆದಾರರು ಇವರು ಕಚೇರಿ ವೇಳೆಯಲ್ಲಿ ಮದ್ಯ ಸೇವಿಸಿ ಕರ್ತವ್ಯಕ್ಕೆ ಅಳವಡಿಸಿರೋ ಬಗ್ಗೆ ಮೇಲೆ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಲೆಕ್ಕ ಶಾಖೆಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಈ ಕೆಳಕಂಡ ಸಿಬ್ಬಂದಿಗಳಾದ ನಾವು ತಮ್ಮಲ್ಲಿ ನಿವೇದಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ CP ಸಿದ್ದೇಶ್ವರ ಗುತ್ತಿಗೆದಾರರು ಕಚೇರಿ ವೇಳೆಯಲ್ಲಿ ಮದ್ಯ ಸೇವಿಸಿ ಬಿಲ್ಲಿನ ವಿಚಾರದಲ್ಲಿ ಅನವಶ್ಯಕವಾಗಿ ನಮ್ಮಗಳ ಮೇಲೆ ಬೈಯಲಿರದೆ ನಿಮ್ಮಗಳ ಮೇಲೆ ಜಾತಿ ನಿಂದನೆ ಹಾಗೂ ಕ್ರಿಮಿನಲ್ ಕೇಸು ಹಾಕುವುದಾಗಿ ಬೆದರಿಕೆ ಹೊಡೆಯುವುದಲ್ಲದೆ ಕರ್ತವ್ಯಕ್ಕೆ ಅಡಿಪಡಿಸಿರುತ್ತಾರೆ. ಇದರಿಂದ ನಾವುಗಳು ಭಯದ ವಾತಾವರಣದಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಬೇಕಾದ ಪರಿಸ್ಥಿತಿ ಆಗಿದೆ. ಇವರಿಗೆ ಸರ್ಕಾರಿ ಕೆಲಸಗಳನ್ನು ಸುಸೂತ್ರವಾಗಿ ನಿರ್ವಹಿಸಲು ಈ ಮೇಲ್ಕಂಡ ಗುತ್ತಿಗೆದಾರರು ಅಡ್ಡಿಪಡಿಸುತ್ತಿದ್ದಾರೆ. ಆದ್ದರಿಂದ ಈ ಬಗ್ಗೆ ಅಗತ್ಯವಾದ ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕು ಎಂದು ಕೋರಿದ್ದಾರೆ. This is the complaint made by these petitioners to their superiors. Now
On the same day?
On the same day of the alleged incident on 30/11. According to the second respondent, my lord, he has completed his contract work and he submitted a bill for encashment. Now there is no question of these petitioners are making any help or indirect. Now all the payments are made by online, my lord. There is no question of issuing check or anything. It is only if he submits the bill, my lord, if the superior officers, the executive engineer is the authority, and it will be transferred to his own account. There is no question of we paying or we are demanding anything, does not arise at all.
Yes.
And the Honorable Supreme Court, my lord, in one of the judgments held that public office, government office is not a public view place.
Really?
Case of Hiteshwar Verma versus State of Uttaranchal.
ಎಲ್ಲಿದೆ?
Madam, my lord?
ಕೊಡಿ.
I'll get to the comment. Just now we got it, my lord. 2020 case, 2020 10 SEC 710, my lord. And in the similar circumstances, the proceedings are quashed by the under 482, my lord. And my respectful submission to your lordship
ಎಲ್ಲಿದೆ
is
ಕೊಡಿ ನನಗೆ relevant portion ನೋಡ್ಬೇಕು ನಾನು. 2020-10 SEC.
yes. And SEC 710, my lord.
ತಗೊಳ್ಳಿಲ್ವ ನೀವು ಇನ್ನು?
Madam?
ತಗೊಂಡಿಲ್ಲ ಇನ್ನು?
ಇಲ್ಲ ಅಲ್ಲ ಇವಾಗ ನೋಡಿದೀವಿ.
SEC 2020-10. Yeah, yes.
And according to the petitioners, my lord, there is delay in filing the complaint. And on the alleged incident, my lord, this Prakash, the accused number 1, petitioner number 1, was on leave on 17. I have produced the attendance certificate at annexure D, my lord.
On 17/11.
17/12. He alleged that again the incident was occurred. On that day, page number 22, my lord. Page number 23 is the relevant page. 23.
Copy of the attendance.
Attendance registered December 2019. And 17th is the date alleged. On that day, he was on leave.
Yes.
Similarly, respondent number, petition number 2 also, Ramesh. And petitioners 3 and 4 were temporary employees who were, there is no allegation against, they was supported the accused. That was the allegation, man. And they are all temporary employees. This petition number 3, Anita, Diksha and Ramesh.
Yes,
Under these
what is said.
circumstances, my lord,
Your Lordship, my lord, in this matter, investigation is not yet completed, my lord. They are the public servants, Your Lordship, and they will not only meet, they will be meeting hundreds of people in a day-to-day basis. So when this incident can happen to a contractor, even a layman they can make the same thing to the layman, Your Lordship. So if the investigation continues.
Repeat his arguments. What do you say regarding the delay? There is delay of about 1 month in filing the
Yes, Your
complaint.
Lordship.
Yes.
30/11/2019, the incident taken place. But you have not lodged the complaint immediately. On
Yes.
the other hand, the petitioners have filed the complaint with the higher officers regarding your conduct.
Yes, Your Lordship.
Where do you stand?
So here, the incident has not happened in a single day. It happened multiple times.
What is your explanation regarding their complaint? Immediately, within no time, they filed the complaint with the higher officer, executive engineer.
Yes.
About your conduct. You, under the influence of alcohol, came to the office, threatened them, abused them, and also threatened that I will invoke the provisions of special enactment, as if it is a weapon in your hand. What is your explanation?
No, Your Lordship, because this incident happened, just to cover up that incident, they've given a complaint.
Why you have not filed? They were cautious enough to file the complaint immediately.
Yes, Your Lordship, because.
What prevented you from filing?
Yes, because I am a contractor and I have business with they have upper hand on me. They have upper hand on me. They cannot give, not business, but they have upper hand on me because I will be having day-to-day business with them. That is, I'll be filing contract and they have to sanction the bill as well, Your Lordship. So I took time and I have also complained in my
They pay the amount by cash,
No, Your Lordship.
online payments.
But they are the one who do the quality check and other things. They have
to
upper
do-
hand
they
on
can
me.
Dispense with that. They have to do all those things.
Yes.
They have to comply with that.
Since they have upper hand on me, so I took back and I thought about it, like, should I complain or not? And then I gave a complaint, Lordship.
Yes.
My lord. Only my lord, he went to settle the bills ಅಂತ ಇದ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ
Bill ಎಲ್ಲಿ ಬರುತ್ತೆ sir? Online payments.
ಆನ್ಲೈನ್ ಪೇಮೆಂಟ್ ಮಾಡಿ.
Then. And inside the office.
Yes, inside the office, my.
And there is delay.
There is delay, my lord.
And moreover, added to that, they have filed the complaint at the
They are
first instance.
Saying that they are in bad environment, they are unable to work, man. Then that is the
All
case.
these together.
Yes, ma'am.
Your Lordship, investigation might continue, Your Lordship, because if it gets quashed, it
If
can
I
happen
permit
to others as well.
investigation in these type of cases, it is clear abuse of process of law. Clear abuse. Respondent number 2 is using the the provisions of the beneficial legislation as weapon, not for his protection. That is not permitted. ಎಲ್ಲಿದೆ citation ಎಲ್ಲಿದೆ? ಕೂಡ್ಲಿ ಕೂತ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆಯ್ತಾ?
Now only you would get it. I will get the copy.
ನಿಮ್ಮ colleague should be very quick. She should get it.
She only found out.
ಕಾಪಿ ಬೇಕಲ್ಲ? ಸುಮ್ನೆ
I'll get-
ಮೊಬೈಲ್ ನಲ್ಲಿ ತೋರಿಸ್ಬಿಟ್ಟು.
Sorry.
ಮೊಬೈಲ್ ನಲ್ಲಿ 101 ಬರ್ತವೆ. Then how I have to believe it?
No. I'll get it, well.
Otherwise I will not refer to it.
Yes.
ನೀವು ಕೂಡ್ಲೆ ತಗೊಂಡ್ಬರ್ಬೇಕು ಹೋಗಿ. ತಗೊಳ್ಳಿ. ಬಂತ? ಎಲ್ಲಿದೆ ಇದು? ಇದು ಕೊಡಿ ಅವ್ರಿಗೆ. ಎಲ್ಲಿದೆ ನೋಡಿ ಮಾರ್ಕ್ ಮಾಡಿಕೊಡಿ. ತಗೊಳ್ಳಿ. Petitioners being accused under 1 to 5. In crime number 91 of 2019 of Madikeri Town Police Station, registered for the offence punishable under section 323, 504, 506, read with section 34 of IPC and under section 31R S 325A 7 of SCS to Prevention of Atrocities Act. Now pending before the learned additional district and sessions judge, Madikeri Kodagu district, seeking to quash the criminal proceedings initiated against them. The facts of the case are that respondent number 2 as informant filed the first information with so-and-so police against accused numbers 1 to 5 alleging commission of the offence as stated above. It is the contention of respondent number 2 that he is a civil contractor working for PWD on he filed a tender and completed the work and approached the accused on 30/11/2019 at 11 a.m. in their office at in the PWD office in the office of Executive Engineer PWD. When respondent number 2 asked for issuance of the check to clear his accused number 1 and 2 abused him in film language by referring to his caste with an intention to defame him and criminally intimidated to send him to the jail. Accused number 2, accused number 1 got hold of respondent number 2 and slapped him. On 23/12/2019, the accused have committed similar offense once again. Accused number 3 and 4 being the contract workers have supported accused number 1. Therefore, he requested the police to register the case and to initiate a legal action against all the accused. Accordingly, the FIR in crime number 91 of 2019 was registered and the investigation was undertaken. In the meantime, the petitioners have approached this court seeking to quash the criminal proceedings. Since interim order of stay was granted, further investigation was not undertaken. Heard learned so and so, so and so. Counsel for the petitioner contended that the petitioners are arrayed as accused numbers 1 to 5. According to the informant, the incident had taken place on 30/11/2019 at 11 a.m. But the first information came to be filed on 30/12/2019 at 5:30 p.m. There is absolutely no reasonable grounds for the delay caused in filing the complaint. Learned counsel submitted that Annexure B, Annexure C is the copy of the complaint lodged by accused numbers 1 to 5 with the executive engineer PWD Madikeri on 30/11/2011 itself regarding the conduct of the petition, conduct of respondent number 2 in coming to the office fully drunk and abusing the employees in filthy language and criminally intimidating that he will file a complaint against them, invoking the provisions of SC Prevention of Atrocities Act. This complaint discloses that on the said date, it was respondent number 2 who abused the petitioners under the influence of alcohol and threatened them for filing the false complaint by invoking the provisions of SC Prevention of Atrocities Act and using it as a weapon is not permitted under law. Counsel submits that the respondent number 2 is a civil contractor. Immediately after completing his work, he has to upload all the required documents online, and the payment will also be done online. There was no necessity for respondent number 2 to approach the petitioners in the office. Next, Learned counsel also submitted. Learned counsel placed reliance on the decision of the tax court in so and so 2020 Part 10 SEC 710 to contend that public office is distinguishable by the word public view used in this special enactment. It is not the contention of respondent number 2 that the incident had taken place within the public view. Under such circumstances, he prays for allowing the petition and to quash the criminal proceedings. Per contra, HCGP for respondent number 1 and Learned counsel for respondent number 2 submit in unison that there are prima facie materials to proceed against the petition. The investigation is not undertaken. Under such circumstances, the criminal proceedings is not required to be quashed. Accordingly, pray for dismissal of the petition. Period. Materials point for consideration. Answer to the point in the affirmative for the following reasons. Is the contention of respondent number 2 that on 30/11/2019, when he approached the petitioner number 1 and 2 in their office, they abused him in filthy language by referring to his caste with an intention to defame him. When again he went to their office on 23/12/2019, they again abused respondent number 2 and committed the offense. It is also stated that accused number 1 slapped him by holding him and criminally intimidated. It stated that accused number 4 and 5 of the contract workers have supported accused numbers 1 to 3. With these allegations, respondent number 2 filed the first information on 30/12/2019 at 5:30 p.m. The incident is said to have taken place on 30/11/2019 at 11 a.m. and again on 23/12/2019. There is delay of about 1 month in filing the first information. The delay is not satisfactorily explained. Moreover, petitioner have produced an XSC, a copy of the complaint dated 30/11/2019, filed by all the employees of the office of PWD at Madikeri, Kodagu division, against complaining about the conduct of the respondent number 2, who is a civil contractor. They stated that he came to the office fully drunk and started abusing all the employees in filthy language and criminally intimidated of filing criminal complaint against them by invoking the provisions of Authorized Prevention of Atrocities Act. Then counsel for respondent number 2 has no explanation whatsoever regarding this complaint, which was promptly filed on the date of incident, that is on 30/11/2019 itself, with the executive engineer PWD by all the employees of the office. Moreover, it is the specific contention of the petitioners that on completing the contract work, respondent number 2 is required to upload all the documents online, seeking clearance of the bill, and the bill will be cleared by paying the amount online and by transferring the amount to the account of respondent number 2. This fact is also not disputed by learned counsel for respondent number 2. Respondent number 2. All these facts and circumstances prima facie leads to the conclusion that respondent number 2, who committed 500 acts on 30/11/2019, as complained by the employees of the office of PWD, Madikeri, with their higher officer against respondent number 2, taken advantage of the beneficial provisions under special enactment, forgetting about the purpose for which the same was enacted. The beneficial legislation was enacted to support and protect the interest of the helpless persons belonging to scheduled caste and scheduled tribe. It was never intended to use as a weapon to threaten the public servants who are discharging their official duty in the office. It is yet another classic case of misusing the provisions of Authorized Prevention of Atrocities Act by a member of the community. Next one. The learned counsel for the petitioner placed reliance on the Sir.
It was inside the house, so.
Para 14 of the judgment.
public view.
The Honorable Apex Court refer to any place, refer to the provisions under special enactment and discussed about the key ingredients of the provisions, that is to insult or intimidate it in any place within public view and refer to its earlier decision in Swaran Singh versus State, 2008, Part 8, SCC 435, where the court has drawn distinctions between the expressions public place and in any place within public view, public place inverted comma, in any place within public view, within inverted comma, to hold that the offense is committed outside building where, which could be seen by someone from the road the same could be said it is a place within public view. Per contra, if the offense is committed inside the building where some members of public are there, and then it would not be an offense since it is not in the public view. In the present case, even according to respondent number 2, the offense in question was committed inside the office where the accused 1 to 5 were working, and all of them have committed the offense, which is not supported by any materials. I do not find any prima facie materials to support such contention. Again, not supported albeit, not supported by any prima facie materials, but on the contrary, the copy of the complaint produced by petitioners go against the petitioner himself, which shows his conduct in misusing the provisions of the special enactment. Hence, I'm of opinion that initiation of criminal proceedings is in clear abuse of process of law, and hence the same is liable to question. Accordingly, I answer they were find in the affirmative and proceed to pass the following. Petition is allowed.
Number 20 adjourned, 21 Dinesh Kumar Rao, plus Vardarajan.
Petition. Yes. Yaru, respondent Yaru. Vardarajan. Yes,
Vardarajan is,
huh?
he has not appeared, but
Not appear.
Offenses under section, my lord, 143, 144.
Who is the petitioner? Who are the petitioners?
Petition number 123, my lordship, that the accused number
Accused number
123.
In all, how many accused? Only 3?
3, my lordship. Charge sheet has been filed.
What are the offense?
My lordship, 143, 144, 148, 324, 307, read with 149 of IPC. The allegation is that, my lord, the petitioner assaulted the respondent number 2's laborers with iron rod, and he has poured a kerosene, as there is a dispute between, there is a dispute regarding land.
Be the complaint. Charge sheet is also filed.
Please, my
Please
lordship.
file.
As per the complaint governments, my lordship, page number 29.
1 minute, 1 minute.
29.
You know, crime number, ಯಾವ್ದು? 6
Crime
of
number
9.
it is, my lord,
Of which police station? Madiwala.
6 of 2009.
19.
Yes, please read column
My
number
lordship.
7. Column number 7 of the charge.
Please, my lordship. My lordship, before that, my lordship, I just want to read 2 lines of complaint, my lordship.
Yes.
My lordship, as per the complaint governments, my lord, the subject, laborers injured has been attacked. So
Okay.
respondent number 2 in
Where is the complaint?
in the page number 29 ಅಲ್ಲಿ starting ಅಲ್ಲಿ subject ಅಲ್ಲಿ laborers injured as attacked. So respondent number 2 complainant ಅವ್ರೇನ್ injury ಆಗಿಲ್ಲ. So ಅವ್ರು laborers ಗೆ ಆಗಿದ್ದು. Then my lordship, on the next page ಅಲ್ಲಿ 30.
You are referring to page number
30, my lordship.
30 ಆಯ್ತು, ಅದು ಮೊದಲಿಂದ ಏನೋ ಹೇಳಿದ್ರಲ್ಲ.
ಇಲ್ಲ, what I submit.
Laborers injured.
ಹೌದು. Respondent number 2 complainant ಅವ್ರು ಅಲ್ಲ. Respondent number 2 is the landowner. ಅವರು laborers were injured. ಗಲಾಟೆ ಆಗಿರೋದು petitioners ಮತ್ತೆ laborers ಮಧ್ಯದಲ್ಲಿ. And in the page number 30, my lordship, today evening by 9:30, first paragraph itself, today evening by 9:30 PM approximately, my labor Prema Anil Kumar were attacked with an iron rod and by pouring petrol on them by petitioners. Now, my lordship, may I read the charge sheet gist, my lordship?
Yes.
ಬೆಂಗಳೂರು ನಗರದ ಮಡಿವಾಳ್ ಠಾಣಾ ಸರದಿನ ವೆಂಕಟಾಪುರ 8ನೇ ಕ್ರಾಸ್ 28ರಲ್ಲಿ ಸಾಕ್ಷಿ 1ನೇ ಅವರು ವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದು, ಅವರ ಕುಟುಂಬಕ್ಕೆ ಸೇರಿದ ಆಸ್ತಿ ಜಕ್ಕಸಂದ್ರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋಯನ್ಸೋರಲ್ಲಿರುವ ಗುಂಟೆ ಜಾಗವು ಲ್ಯಾಂಡ್ ಟ್ರೈಬ್ಯುನಲ್ ನಲ್ಲಿ ಕೇಸ್ ನಡೆದು ದಿನಾಂಕ ಸೋಯನ್ಸೋರಂದು ಸಾಕ್ಷಿ 1ನೇ ಅವರವರು ಕುಟುಂಬದ ಪರವಾಗಿ ತೀರ್ಪು ಬಂದಿದ್ದು, ಈ ವಿಚಾರ ತಿಳಿದು ಕಾಲಂ ನಂಬರ್ 4ರಲ್ಲಿ ನಮೂದಿಸಿರುವ A1 ರಿಂದ A3 ಆರೋಪಿತರು ಸದರಿ ಸ್ವತ್ತನ್ನು ತಮ್ಮ ಸ್ವಾಧೀನಕ್ಕೆ ಪಡೆದುಕೊಳ್ಳಲು ಪ್ರಯತ್ನಿಸುತ್ತಿರುವಾಗ ಸಾಕ್ಷಿ 1ನೇ ಅವರವರು ಸದರಿ ಸ್ವತ್ತನ್ನು ನೋಡಿಕೊಳ್ಳಲು ದಿನಾಂಕ ಸೋಯನ್ಸೋ ಸಾಕ್ಷಿ 4ನೇವರಿಂದ ಸಾಕ್ಷಿ 7ನೇ ಅವರುಗಳನ್ನು ಬಿಟ್ಟಿದ್ದು, ರಾತ್ರಿ 9:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಕಾಲಂ ನಂಬರ್ 4ನಲ್ಲಿ ನಮೂದಿಸಿರುವ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1ರಿಂದ 3 ಆರೋಪಿತರು ಏಕಾಏಕಿ ಜಕ್ಕಸಂದ್ರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋಯನ್ಸೋ ಸಾಕ್ಷಿ 1ನೇ ಅವರ ಶೆಡ್ ಹತ್ತಿರ ಬಂದು ಸಾಕ್ಷಿ 1, ಸಾಕ್ಷಿ 4ರವರಿಗೆ A1 ಆರೋಪಿತ ಸೀಮೆ ಎಣ್ಣೆ ಎರಚಿದ್ದು, ಆ ಸಮಯದಲ್ಲಿ A2 ಆರೋಪಿತ ಕಬ್ಬಿಣ ರಾಡಿನಿಂದ ಸಾಕ್ಷಿ 1ನೇ ಅವರ ಹಣೆಯ ಮೇಲೆ ಹೊಡೆದು ರಕ್ತ ಗಾಯಪಡಿಸಿ, ಸಾಕ್ಷಿ 5ನೇ ಅವರಿಗೆ A1 ಆರೋಪಿತ ಕಬ್ಬಿಣದ ಪೈಪಿನಿಂದ ಹೊಡೆದು ನೋವನ್ನುಂಟು ಮಾಡಿ, A3 ಆರೋಪಿತ ಲಾಂಗ್ ಅನ್ನು ಹಿಡಿದುಕೊಂಡು ಸಾಕ್ಷಿ 4ರಿಂದ ಸಾಕ್ಷಿ 7ರವರೆಗೆ ಅಟ್ಟಾಡಿಸಿಕೊಂಡು ಕೊಲೆ ಬೆದರಿಕೆ ಹಾಕಿ ಸಾಕ್ಷಿ 4 ಮತ್ತು 5 ಅವರಿಗೆ ಸಾಧಾರಣ ಗಾಯಪಡಿಸಿ ಸೀಮೆ ಎಣ್ಣೆಯನ್ನು ಎರಚಿ ಬೆಂಕಿ ಹಚ್ಚಿ ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿರುವುದು ತನಿಖೆಯಿಂದ ದೃಢಪಟ್ಟಿರುತ್ತದೆ. So they have sustained simple injuries, my lordship.
CW 4 and 5.
Please, my lordship. My humble submission is that, my lord,
Wound certificate ಏನಿದೆ?
ಅದರಲ್ಲಿ simple injuries ಇದೆ.
Then it here documents
Yes.
This is CW, Rema, CW.
CW 2 and CW 1 Anil Kumar.
Rema ಅನ್ನೋರು ಯಾರು ಅಂತ.
Shar, my lordship.
Prema
head
is
counsel.
CW4, madam. ಎಲ್ಲನೂ ಇದೆ.
ಏನು, what is the nature of injury? Where is the injury?
ಮೇಡಮ್
ಏನು injury ಬಗ್ಗೆ ಏನು, there is no mention.
ಎಲ್ಲನೂ ಸಿಂಪಲ್ ಇಂಜಿನ್.
ಇನ್ನೊಬ್ರು ಅನಿಲ್ ಕುಮಾರ್,
ಅನಿಲ್ ಕುಮಾರ್.
CW5.
ಎಸ್ ಮ್ಯಾಮ್. ಚಂದ್ರಪ್ಪ CW6 ಮ್ಯಾಮ್.
ಇವ್ರದ್ದು ಹಾಗೆ ಏನೂ ಇಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ಶಾರದಾ ಸಿ ಮೇಡಮ್.
ಎಲ್ಲಿದೆ ಶಾರದಾ ಸಿ? ಇಲ್ಲ ಅಲ್ಲಿ.
ಶಾಂತಮ್ಮ CW8 ಎಲ್ಲನೂ
ಏನಿಲ್ಲ, injuries ಏನಿಲ್ಲ. Whether any clothes are recovered? Kerosene ಇದು ಮಾಡಿದ್ದು.
ಕ್ಲೋತ್ಸ್ ಏನು ರಿಕವರ್ ಮಾಡಿದ್ದಾರೆ. ಓನ್ಲಿ ಕಿರೋಸಿನ್ ಅವರು ಗುಡಿಸಲ್ ಮೇಲೆ ಇದು ಹಾಕಿದ್ದಾರೆ ಅನ್ನೋದು.
ಫೈರ್ ಲಿಟ್ಟು ಮಾಡಿಲ್ಲ.
ಫೈರ್ ಲಿಟ್ ಮಾಡಿಲ್ಲ, ಕಿರೋಸಿನ್ ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತು, ಅದೇನಾರು ಅಟ್ಲೀಸ್ಟ್ ಮಡ್ಗಾದ್ರೂ ಹಾಕಿರ್ಬೇಕಿತ್ತು, ಬಟ್ಟೆಗಾದ್ರೂ ಹಾಕಿರ್ಬೇಕಿತ್ತು, ಎಲ್ಲಾದ್ರೂ ಒಂದ್ ಕಡೆ ಇರ್ಬೇಕಲ್ಲ ಅದು.
ಇಲ್ಲ ಅದ್ಯಾವುದು
ಕೆರೋಸಿನ್, ಸೀಮೆ ಎಣ್ಣೆ ಎರಚಿದ್ದು.
Yes.
Where are the materials? ಏನಿಲ್ಲ. ತಗೊಳ್ಳಿ. Petitioners being accused numbers 1 to 3. In SC 298 of 2022.
May I seek for hand delivery, my lordship, because trial, may I seek for order of the hand delivery ಅಲ್ಲಿ, ಯಾಕಂದ್ರೆ ಇವತ್ತು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇವತ್ತೇ ಮ್ಯಾಟರ್ ಇದೆ.
22 ಒಂದ್ ನಿಮಿಷ ನಾನು ಡಿಕ್ಟೇಷನ್ ಮುಗಿಸ್ಬೇಕಲ್ಲ, ಆಮೇಲೆ ಅಲ್ವಾ?
ಪ್ಲೀಸ್ ಮ್ಯಾಮ್.
ಒಂದು ಫೈಲ್ ಆಫ್ ಸೋ ಅಂಡ್ ಸೋ ಅಷ್ಟೆಲ್ಲ ಅರ್ಜೆಂಟ್ ಆಗಲ್ಲ, ಅವರೆಲ್ಲ ಮಾಡ್ಬೇಕು, ನಾನು
Please, madam,
ಕರೆಕ್ಷನ್
please.
ಆಗಬೇಕು. It will take some time. City Civil, so and so additional City Civil and Sessions Judge Bengaluru. Bracket ನಲ್ಲಿ arising out of crime number 6 of 2019, Madabal Police Station. Bracket complete. For the offence under section 323, 324, 506, B, 307, read with section 34 of Advocacy, are seeking to quash the criminal proceedings initiated against them. Brief facts of the case are that respondent number 2, being the informant, filed the first information against accused numbers 1 to 3, alleging that on 8/1/2019 at 9:30 p.m. the accused 1 to 3 came near the shed put up in his land, abused the laborers in Hindi language, thrown kerosene on them, thrown petrol with an intention to cause their death, assaulted the laborers, Prema and Anil Kumar, with the iron rod, with an intention to cause their death, and committed the offense. The laborers were shifted to hospital immediately. One of the injured by name Prema was treated in ICU. He stated that the land tribunal granted the land in question in favor of the complainant, but accused numbers 1 to 3 with an intention to grab the land committed the offense. Therefore, he requested the police to register the case Any weapons are recovered? Iron rod or pipe?
Iron rod are recovered, madam,
Pipe.
my lord. That I will submit, madam.
ಅದು ಇರ್ಲಿ, ನೀವು ಹೇಳಿದ್ರೆ ಸಾಕು, ತೋರಿಸ್ಬೇಡ. ಐರನ್ ರಾಡ್, only iron rod.
Iron rod recover, one iron rod, one iron pipe, one iron long also.
From the scene of occurrence.
Yes, my lord. They have sent to the forensic also, my lord. And also one.
Medical report.
Yes, my lord.
ಏನಿದೆ?
ಏನಂತ ಇದೆ?
Plain blood ಬಿದ್ದ ಏನಿದೆ?
The cut. ಏನು ಒಪಿನಿಯನ್ ಅಂತ ಇಲ್ಲ. ಇದರಲ್ಲಿ ರಿಪೋರ್ಟ್ ಇದು ಬಂದಿಲ್ಲ ಮೇಡಮ್, ಬಟ್ ಕಿರೋಸಿನ್ ಟಿನ್ ಇದೆ ಅಲ್ಲ ಮೇಡಮ್, ಕಿರೋಸಿನ್ ಟಿನ್, ವ್ಯಾಕ್ಸ್, ಮ್ಯಾಚ್ ಬಾಕ್ಸ್ ಸಿಕ್ಕಿದೆ, ಅಲ್ಲಿ ಒಪಿನಿಯನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವು ಪೆಟ್ರೋಲಿಯಂ ರೆಸಿಡ್ಯೂಸ್ ಆರ್ ಡಿಟೆಕ್ಟೆಡ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾವ್ದ್ರಲ್ಲಿ? ಟಿನ್ ಅಲ್ಲಿ?
ಟಿನ್ ಇದರಲ್ಲಿ.
ನೆಲದ ಮೇಲೆ ಇಲ್ಲ,
ಅದ್ರ ಮೇಲೆ.
ಶೆಡ್ ಅಲ್ಲಿ ಇಲ್ಲ,
ಇಲ್ಲ.
ಅವರು ವಿಕ್ಟಿಮ್ ಮೈ ಮೇಲೆ ಇಲ್ಲ.
ಮೈ ಮೇಲೆ. ಎಸ್,
ಟಿನ್ ಅಲ್ಲಿ ಇದ್ದೇ ಇರುತ್ತೆ, ಕೆರೋಸಿನ್ ಟಿನ್ ಅಂದ್ಮೇಲೆ ಟಿನ್
ಅಷ್ಟೇ ಇದು.
To initiate legal action. Accordingly, the police have registered the FIR in crime number 6 of 2019 and investigated in the matter. The investigation charge sheet came to be filed for the aforesaid offences. The petitioners are before this, being accused numbers 1 to 3, are before this court seeking to quash the criminal proceedings initiated against them. So there is the materials, point for consideration. My answer to the other point in the affirmative for the following reasons. Is the specific contention of respondent number 2 that is the owner of the land in question. Petitioners being petitioners, accused numbers 1 to 3, came near the shed in the disputed land on 8/1/2019 at 9:30 p.m. abused the laborers, thrown kerosene, and assaulted them with a iron rod, pipe, and a long. As a result of which, CW4 and 5 sustained injuries. One of the injured taken treatment in ICU in a hospital. Copy of the wound certificates produced for perusal of the court discloses that even though CW4 and 5 were taken to the hospital, there is no reference to any injuries sustained by them. The documents also did not disclose that they were treated as inpatient or in ICU. Admittedly, no materials are produced and no materials were seized from the scene of occurrence to support the contention of the prosecution that the accused have thrown the kerosene or the petrol either on the ground or on the shed or on the person of the injured. They stated that only the kerosene tin, rod, pipe, and long were recovered from the scene of occurrence. even though such deadly weapons were recovered from the scene of occurrence, CW 4 and 5 appears to have not sustained any injuries. Even though serious allegations are made, including the offense under section 324 and 307 of Advocacy. Not even an iota of evidence is available in the case. In such circumstances, I am of the opinion that it is a fit case for quashing the criminal proceedings which was initiated in abuse of process of law. Accordingly, I answer the in the affirmative and proceed. Petition is allowed.
Much obliged.
Yes.
Serial number 22, Rakshita R. Ravi.
But for the petitioner, this matter, my lord, is settled. Before the family court, my lord, the petitioners have deposited a sum of 20 lakhs. They acknowledged, my lord, the respondent also has acknowledged the receipt of the amount. They were supposed to come today, but my lord, due to some medical emergency, my lord, the other party, that is respondent number 2, could not come. That's what has been instructed. My lord, kindly have it on 28 minutes.
No, who is for respondent number 2? Ravi,
We tried to contact him also. ದುಡ್ಡು ಕೊಟ್ಟಾಗಿದೆ.
who are present? Who are the parties?
They are petitioners. Petitioner number 1 to 3. Husband,
Accused.
father-in-law, mother-in-law. Accused number 1 to 3.
What is the amount paid by you?
25 lakhs.
ಏನಕ್ಕೆ?
ಅಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತು. MC ಕೇಸ್ ಅಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್
Final settlement?
ಆಗಿದೆ ಕಂಪ್ಲೀಟ್.
ಏನು compromise petition ಏನಿಲ್ವಾ?
ಫೈಲ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ ಅಲ್ಲಿ ಡಿಗ್ರಿ ಇನ್ನೂ ಡ್ರಾ ಆಗಿಲ್ಲ. ದಿ
ಇಲ್ಲಿ ಕಾಪಿಯಲ್ಲಿದೆ, ಕಾಪಿ ಆರ್ ಪ್ರೊಡ್ಯೂಸ್.
MC case is disposed of. It was disposed of on the Wednesday.
As compromised?
Yes.
ಬೇರೆ ಅದು ಎಲ್ಲಿದೆ compromise
28th
petition?
I will produce the copy. ಕಾಪಿ ಇನ್ನ ರೆಡಿ ಆಗಿಲ್ಲ ಅದು.
Compromise petition ಆದ್ರೂ ನಿಮ್ ಕೈನಲ್ಲಿ ಇರುತ್ತಲ್ವಾ?
ನಂತರ ಆಫೀಸ್ ಕಾಪಿ ಇದೆ. ಅದೇ ಕೊಡಿ.
ಏನು what is the difficulty in producing that?
That I will produce. That I will.
ನಾನು ಕೇಳ್ಬೇಕಾ ನಿಮಗೆ ರಿಪೀಟೆಡ್ಲಿ?
ಅಲ್ಲ that I will produce.
ಏನು ಬೇಸಿಸ್ ಇಲ್ಲ, ಸುಮ್ಮನೆ ಏನೋ ಒಂದು ಹೇಳೋದು ಸಬ್ಮಿಷನ್ಸ್. ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. Who moved the matter? ನೀವೇ move ಮಾಡಿದ್ರಿ.
Please, now move ಮಾಡಿ.
Why you moved the matter?
The other side
Without
was,
getting the documents.
the other side was supposed to come.
Without getting the document, why you moved the matter?
They were not going to be present. That is what.
Why you moved the matter?
They told my lord they would be present. That is the reason, my lord, I moved.
Don't be funky, sir. You should have some responsibility. You are an advocate representing the petitioner. ಅವ್ರು ಹೇಳಿದ್ರು ನಾನು ಮೂವ್ ಮಾಡಿದೆ. What is this? Counsel for the petitioner, prays for time. It is noticed that when counsel for the petitioner himself has moved the matter for listing, and in spite of that, he submits that he do not have the supporting documents to address his arguments. This after 4 weeks. Next.
Serial number 23, Chetan Desai, Venkatesh Murthy.
For the respondent in this case.
Really. Obviously, no internet. Yes, who is the petitioner?
The petition. The party
Is the petitioner?
Yes, one of the petition.
Yes, what is this matter?
This matter pertains to forgery.
Who are the petitioners?
The petitioner are the accused before the trial court.
Case number 1 and 2.
Yes, ma'am.
Only 2 accused.
Yes, yes.
Private complaint,
Yes, my lord. Initially, B report was filed.
PCR number,
Please.
12163 of 2012, my lord.
what are the offense alleged?
From offense are 463, 64, 65, 466, 468, 470, and 420, my lord. Lord, it is a family dispute, my lord, between the family members. There is a suit for partition,
Investigation was undertaken,
my lord.
investigation,
Investigation, as the court has referred the matter for investigation, my lord. After investigation, the police have filed a B report.
B report,
B report.
then
Then B report has been challenged. Cognizance has been taken, my lord.
any witnesses were examined?
Witness have not been examined. Only complainant has been examined. Facts of the case I will explain. Lord, the respondent herein is the,
Where is the order taking cognizance?
my lord,
Where is the order taking cognizance?
page number 89, my lord.
You have not challenged that order,
That order has not been challenged, my lord,
then
previously.
a detailed order is passed, that is not.
Detailed
challenged.
order, my lord. I maybe read the order, my lord. Page number 89, my lord. Therefore, I am of the view that at this stage there are sufficient materials. Only it is said that it is only sufficient materials, my lord, but it is not clearly stated that there is materials.
Clearly ಅಂದ್ರೆ ಅಲ್ಲೇ proof beyond reasonable doubt ಬೇಕಾ? Initial stage, sir, sufficient materials are sufficient to take
ಅಲ್ಲ.
cognizance.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, see there was a partition.
ಆಗ್ಲಿ,
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಒಂದು ನಿಮಿಷ. There was a partition took place in the year 12/9/1993, my lord, between the family members. That is the father of
which are the
respondent.
disputed documents?
Madam, disputed documents are not here, my lord. ಆ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಏನಂದ್ರೆ ಅವರು ಲವೆನಿ ಸ್ಕೆಚ್ ಮಾಡಕ್ ಬಂದ್ರು, ಅಪೋಡಿ ದುರಸ್ತಿ ಮಾಡಕ್ ಬಂದ್ರು. ಆವಾಗ ಆ ಸ್ಕೆಚ್ಗೆ ನಾವು ಸೈನ್ ಮಾಡಿಲ್ಲ, ಅದನ್ನ ಇವರು ಫೋರ್ಜರಿ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದೇ ಇಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್.
ಇದು ಸರ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಆಫ್ ದ ಕೇಸ್. What is the complaint?
My lord, complaint. Page number 18, my lord.
What is the allegation? Either of you should tell.
Allegation is that in the year 2007, my lord, gift deed has been executed by my father to me. So after the execution of the gift deed, there is a
Registered gift deed?
registered gift deed. Based on that, I applied for Podi Durasti.
In
For the
favor
no,
of-
my lord,
Gift deed in favor of.
gift deed in favor of petitioner number 2, my lord. Petitioner number 1 has executed in favor of petitioner number 2. So when I applied for Podi Durasti, when the survey authorities appeared before the property, the allegation is that by the respondent that our father has not been signed the application.
Relationship with.
Brother, respondent number 2 is petitioner number 1's brother's daughter.
Complainant.
Complainant. Complainant is the petitioner's brother's daughter, own brother's daughter.
ನನ್ನ ಮಗಳು.
ಅಣ್ಣನ ಮಗಳು.
Complaint.
ಹೌದು, ಇಲ್ಲಿ 12/9/93 ಸ್ವಾಮಿ ಪಾರ್ಟಿಷನ್ ಎಂಟ್ರಿ ಆಗ್ತಾರೆ ಪಂಚಾಯತ್ ಪಾಲುಪಟ್ಟಿ. Based on in that palupatti, there are 4 schedules have been executed. One is for Munshamappa, that is the father of respondent herein.
Partition ಯಾವಾಗ?
12/9/1993. Between the father of respondent number 1, petitioner herein, petitioner number 1,
and one one more brother of petitioner Ramaya, and respondent number one, respondent's husband. ಅಳಿಯನಿಗೂ ಇಲ್ಲೊಂದು ಭಾಗ ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ. ಮುನ್ಶಾಮಪ್ಪ, ರಾಮಯ್ಯ, ದ್ಯಾವಪ್ಪ, ವೆಂಕಟೇಶ್.
Memo dated 7/9/22. I have produced the documents, my lord.
That was the partition in registered.
ಅಲ್ಲ ಪಾಲು ಪಟ್ಟಿ ಮಾಡ್ಕೊಂಡು.
Whether it is.
Based on that, it is acted upon, my lord.
How?
Revenue entries have been changed. Based on this partition, my petitioner number one, my father has executed in favor of petitioner number two, gifted.
Registered gift.
Registered gifted.
Yes.
So ಅದಾದ ನಂತರ ಇವ್ರನ್ನ ಪೋಡಿ ದುರಸ್ತಿ ಕಟ್ಟಿದಾಗ sketch.
Gift deed dated.
2007, my lord. Eight 6/2007, my lord. 18/6/2007.
18/6.
Okay.
Date of complaint.
Date of complaint is in there 2012, my lord, PCR. 4/7/2012.
Yes, you applied for Podi Durasti.
Podi Durasti.
What happened?
So the allegation is by the respondent is that during the Podi Durasti, his father has not been signed in the application of Podi Durasti. Respondent's father. One of the brother of petitioner here.
Not signed Podi Durasti or Palupatti?
Podi Durasti.
Yes, what do you say?
May I please? Your lordship may kindly see the memo which I have filed, my lord. The documents which they are relying.
Between the parties, you admit?
Yes, it's admitted. The Panchayati Parikat, so-called Panchayati Parikat itself is forged. Based on that forged document, the petitioner number one has executed a gift in favor of the petitioner number two. That itself is forged.
Filed any suit?
Yeah, a suit is been filed by one of the brothers, in which I have, yes, no suit has been filed. In which suit I have sought declaration. In fact, my children, one of my son has filed a suit for seeking declaration of that to set aside that gift deed.
Page number 57, my lord. Kindly see page number 57.
That suit is pending.
ಅದರಲ್ಲಿ
ಇಲ್ಲ ಈ ಸೂಟ್
ಅಲ್ಲ ಇದು there are two suits pending. See, one Ramaya, who is the brother of petitioner herein, has filed a suit. Please.
A suit has been filed. It's pending before the Devanhalli court.
How many suits are pending?
Two suits are pending.
OS number?
OS number 434 of 2015, my lord.
Filed by?
Filed by Ramaya, my lord. One Ramaya, who is the brother of petitioner number one, my lord, and uncle of respondent.
Ian, what is the relief claimed?
Partition. Relief is claimed for relief of partition and separation of the plaintiff's legitimate share in the suit held property, and also put the plaintiff of his share as per the unregistered Panchayat partition dated 12/9/93 entered into between the plaintiff. Page number 57. For the relief of partition and separate position of the plaintiff's legitimate share in the scheduled properties, and also to put the plaintiff of his share as per the unregistered Panchayat partition dated 12/9/93 entered into between the plaintiff and the defendants 1 to 3, and also transfer the revenue records in the name of
Petition deed dated?
12/9/1993. That is the unregistered Palupatti Panchayat part.
So he asserts partition.
He
deed.
asserts partition.
Which is the other suit?
Other suit is filed by 276 of 2018, which is filed by respondent's father.
What is the relief?
In that he disputes this
What
partition.
is the relief claim?
Really, that the document I have not produced.
What is the relief claim?
That document even I am not.
Then, see, brother of the petition number 1 asserts that there was a partition deed.
Yes. At the same time, the respondent's father specifically alleges there was no partition in the year 1993.
ಅದು ಸೂಟ್ ಡೀಟೇಲ್ಸ್ ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅದು ಏನಾಯ್ತು ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲ.
ಇಲ್ಲ, that all the suits are
They are
pending.
pending for consideration.
What is the relief claim by?
I will produce it. Your lordship, 28 ಹಾಕೊಂಡ್ರೆ
Date ಆಗಲ್ಲ.
ಇಲ್ಲ 27th ಗೆ ಹಾಕ್ತೀನಿ.
ಇಬ್ರಿಗೂ ಗೊತ್ತಿಲ್ಲ, ಸುಮ್ಮನೆ ಏನೋ ಒಂದು place for time. Counsel for the petitioner. Counsel for respondent number 2 place for time to produce additional documents. This time. Okay. Yes.
ಯಾವತ್ತು date?
Produce the documents.
ಅಲ್ಲ, ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ. ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್.
Date ಅದೇ ಮಾರ್ಚ್ ನಲ್ಲಿ.
ಡೇಟ್ ಯಾವುದು?
ಡೇಟ್ ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆಗುತ್ತೆ ಸರ್. ನಾವು ಡೇಟ್ ಕೊಟ್ಟು ಅವ್ರು ಹೋಗಿ ಮತ್ತೆ ಯಾರು ಬರೋರು ಡೋ ನಾಟ್ ನೋ. ನೋಡಿ ಡೇಟ್ ಕೊಡೋದಾದ್ರೆ ಕೊಡಿ, ಕೊಡೋದು ಕೊಡಿ.
I'll move them.
ಎಸ್, ಇಲ್ಲ ಡೇಟ್ ಕೊಟ್ರೆ ಸೆಕೆಂಡ್ ವೀಕ್ ಅಂದ್ರೆ ಬರಲ್ಲ ಅಂತ ಅವರದ್ದು. 12.
Please.
ಎಸ್.
Serial number 24 adjourned, 25 Prasanna VR.
Complainant's petition.
ಇದೇ ಪ್ರಶ್ನೆ ನಮಗೆ ಬಂತು. Why this matter is listed before this?
But earlier, the accused have filed a complaint seeking quashing of proceedings in private complaint. That was dismissed as withdrawn by before the honorable court notes. Therefore, the matter is placed before this.
Now, why this petition?
But this petition was not challenging the order of dismissal of my complaint for non-prosecution as
You are the complainant.
I am the complainant.
Earlier petition by the accused.
By the accused. They have challenged the initiation of proceedings on based on the private complaint. There was an interim order of stay passed by this honorable court in their petition. And without noticing the said factum of granting interim order, the trial court has proceeded with the matter. And we have sought for time to give sworn statement after rejecting the B report. Then, my lords, the trial court has rejected the complaint on the ground that the complainant has not tendered sworn statement. Virtually, there was an interim order of
Just
stay.
for default.
How? Yes. Without noticing the factum of interim stay granted by this honorable court. There was an interim order passed by this honorable court in the previous proceedings.
ಎಲ್ಲಿದೆ order sheet?
Please, notes, order sheet, not annexure E, page number 62. That is the computer generated copy from, obtained from the official website. Down below, notes dated 20th-2/2018. Issue notice to R2, stay till next date of hearing. That was continued. And on 5/6/2024, also the same has been extended.
ಎಲ್ಲಿದೆ?
Page number 62 itself, no stop of dated 5/6/2024. Middle portion, notes. Issue fresh notice to respond number 2. Interim order granted on 20th/2/2018 shall continue till the next date of hearing. Then the
Thereafter, when it was listed?
Lord, thereafter it was not listed. Lord, trial court, Lord, on 21/9/2024, while by refusing to refusing adjournment for recording statement, dismiss the complaint. Kindly see, my lords, page number 43. It is a typed copy. The certified copy, my lord, page number 33. Typed copy is at page number 43.
21/9/2024 for sworn statement. Finally, complainant absent. Srimati ISK advocate prays time for sworn statement. In spite of sufficient opportunity, complainant failed
You
to.
have produced.
Please. Entire order sheet I have produced, notes.
ಎಲ್ಲಿದೆ? 5/6/2024 ಇದೆ.
ಹೌದು
24 ಇದೆ.
ಹೌದು ಅದರಿಂದ ಪ್ರೀವಿಯಸ್ ಇದ್ದು ಇದೆ ಫ್ರಮ್
Subsequently ಎಲ್ಲಿ?
ಪ್ಲೀಸ್ 21/9/2024
6/24 ಆದ್ಮೇಲೆ 10/9/2024 ಇದೆ. 21/9/2024 ಇದೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಹೌದು ಅದರ ಹಿಂದಿದ್ದು ಇದೆ. ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್. ಅದು ಸ್ಪ್ಲಿಟ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 31. ಯುವರ್ ಲಾಸ್ಟ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ನೋಟ್ಸ್. ಪೇಜ್ ನಂಬರ್ 31 3/8/2024 ಇಂದ ಕಮೆನ್ಸ್ ಆಗುತ್ತೆ. ಪೇಜ್ ನಂಬರ್ 30 ಡೌನ್ ಬಿಲೋ 3/8/2024 ಫಾರ್ ಸ್ವೋನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತ ಇದೆ ಮ್ಯಾನ್ಯುಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲಿ.
ಕೇಳ್ತಾ
Please.
ಇರೋದು. You have produced the order sheet of this court
ಪ್ಲೀಸ್.
till 5/6/2024.
Yes, notes.
Thereafter, when the matter was listed.
Thereafter matter was not listed. This is the
Okay.
ಇಲ್ಲ ಲೀಸ್ಟ್ ಆಗ್ಲಿಲ್ಲ. ಇಟ್ ಈಸ್ ಎ ಕಂಪ್ಯೂಟರ್ ಜನರೇಟೆಡ್
ಹೌದು.
ಇದು. ಆಮೇಲೆ ಲೀಸ್ಟ್ ಆಗಿರೋದು ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ಯುವರ್ ಲಾಸ್ಟ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 64 ಫೈನಲ್ ಆರ್ಡರ್ ಇನ್ ದಿ ಸೆಡ್ ಪಿಟಿಷನ್.
That is withdrawn.
ಹೌದು ವಿಡ್ರಾ ಮಾಡಿರೋದು ಯಾತಕ್ಕಂದ್ರೆ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ರಿಜೆಕ್ಟ್ ಆಯ್ತು.
Yes.
ದೇರ್ ಫೋರ್
Infructuous.
ಇನ್ಫ್ರಕ್ಚಸ್ ಅಂತ ಆಯ್ತು ಅಂತ. ಬಟ್ ಮೈ ಕಂಪ್ಲೇಂಟ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ಡ್ ಆನ್ ದಿ ಮಿಸ್ಟೇಕನ್ ನೋಷನ್.
What was the interim order granted?
ಇಂಟ್ರೀಮ್ ಆರ್ಡರ್ ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ವಾಸ್ ಸ್ಟೇಡ್. ಅದು ಇಲ್ಲಿ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 65 ಅಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಸಾಟ್ ಫಾರ್ ಕ್ವಾಶಿಂಗ್ ಆಫ್ ದ ಎಂಟೈರ್ ಪ್ರೊಸೀಡಿಂಗ್.
It is the interim order granted.
ಇಂಟರಿಮ್ ಆರ್ಡರ್ ಇದರಲ್ಲಿ ಸ್ಟೇ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಂತ ಮಾತ್ರ ಇದೆ. ಬಟ್ ಐ ಮೇ ಹ್ಯಾವ್ ಟು ಗೆಟ್ ದಿ ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ ಇನ್ ದಿ.
Is it not necessary?
But it is recorded in the order sheet also by the trial court.
ಅದೆಲ್ಲಿದೆ?
ಅದು ಪೇಜ್ ನಂಬರ್ 6.
ಮಧ್ಯಾಹ್ನ
ಬಟ್ ಅದು ಯಾವುದು ಆರ್ಡರ್ ಅಂತ ಬರ್ದಿಲ್ಲ ಅಲ್ಲಿ. I will produce, get it and I will place it on record.
Counsel for the petitioner.
10 days, you lost me kindly.
Please for 10 days time. ಇಲ್ಲ. Next.
Please.
ಒಂದು ಪಾಸ್ವರ್ಡ್ ಯಾವುದೋ ಇದೆಯಲ್ಲ.
Submission, my lord.
Ah.
Serial number 6 is passed over. My client has agreed to pay rupees 4,000 per month. And he will file I will file necessary affidavit regarding that, my lord. Undertaking affidavit. I will file a fresh undertaking affidavit.
What do you say?
Yeah.
4,000 for 6 months.
Yeah.
Till 30th June.
June. Yes. It's one submission, my lord. Why I'm objecting is 2 years. Plus benefit of 25 days till
ಆಯ್ತು,
today.
ಇವಾಗ ಡಬಲ್ ದಿ ರೆಂಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
10 minutes may at least seek for enhancement in that damages at least minutes. Because minutes.
Enhancement
ಹೌದು ಅಂದ್ರೆ ಅದ್ರ 2,000 ಕೊಡ್ತಾ ಇದ್ರೆ at least ಒಂದು 5,000 10,000 ಆದ್ರೂ ಒಂದು ಹೇಳಿದ್ರೆ ಅರ್ಥ.
ಸಜೆಸ್ಟ್ ಮಾಡಿದೆ. ಅವಾಗ ನೀವೇನು ಹೇಳಿಲ್ಲ.
ಅಲ್ಲ ಅದು ಹೌದು ಗೊತ್ತಾಯ್ತು.
ನೀವು ಅವಾಗ ಯು ಕೆಪ್
because means I have to.
Because expecting you into intervene. 4,000 ಆಗಲ್ಲ 10,000 ಕೊಡಿ ಅಂತ ನೀವು ಕೇಳ್ತೀರಿ ಅಂತ ಅನ್ಕೊಂಡೆ. ಏನು ಹೇಳಿಲ್ಲ ನೀವು.
Please,
Then I kept quiet.
Because when it's 2 years, it was now
now
is
he is
again
ready.
seeking for 6 months is unreasonable. What I
ಆಯ್ತು, ಅವತ್ತು ಅಫಿಡವಿಟ್ ಹಾಕ್ತಾರಲ್ಲ. ಅಫಿಡವಿಟ್ ಹಾಕದೇ ಇದ್ರೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಯು ಆರ್ ಲಯಬಲ್ ಫಾರ್ ಇವಿಕ್ಷನ್ ಅಷ್ಟೇ.
Please.
ತಗೊಳ್ಳಿ. 6 ಅಲ್ವಾ?
7 man. 7 sir. Serial number 7.
Learned counsel for the petitioner filed the affidavit undertaking to affidavit sworn by the petitioner undertaking to vacate the premises on or before 30th June 2025. 25. Learned counsel for respondent numbers 1 to 5 opposes granting of further time of 6 months. However, learned counsel for the petitioner undertakes to pay double the amount of rent that is rent, and submits that the petitioner is ready to pay rupees 4,000 as monthly rent from January,
February,
February, because
February.
30th they were supposed to
From-
vacate.
1st of February.
from 1/2/2025 till 30th June 2025, or till the date of vacating the premises, whichever is earlier. Counsel for the petitioner or appellant undertakes to file an affidavit in that regard. List on. Yes. ಯಾವಾಗ ಅವ್ರ convenient date ಕೊಡಿ.
Can it be on 3rd minutes?
Huh?
Can it be on 3rd minutes?
ಏನು?
3rd of March minutes?
Split ನಲ್ಲಿ ಕೊಡಿ. ಇಲ್ಲ ಕೊಡಿ. ಅಷ್ಟು ಮಂದಿ ಬೇಡ, ಅವ್ರು affidavit ಹಾಕ್ಬೇಕು. ಇಲ್ಲ ಅಂದ್ರೆ ಮಾಡ್ತಾರೆ, ನಾವು ಅಗ್ರಿ ಆಗಿಲ್ಲ ಅಂತಾರೆ. ಹಾ, 6th March.
6th March, please.
6th March. Yes.
Serial number 8.
Hmm?
Sorry, serial number 8.
Ah,
I was held up in it.
yes.
That may be allowed, my lord. Subsequently, they have issued a validity certificate.
ನಾನು 2:30.
Yes.
2:30.
ಕೊಡ್ತೀವಿ ಮೇಡಮ್.
ಪಾಸ್ ಓವರ್ ನಿಮ್ಗೆ ಇರ್ಬೇಕಾ ಎಲ್ಲ ಪಾಸ್ ಓವರ್ ಅಲ್ಲ ಇರೋದು ಬರೀ ಪಾಸ್ ಓವರ್ ನಿಮ್ಗಿರೋ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಪಾಸ್ ಓವರ್ ಕೊಡಪ್ಪ ಅವ್ರಿಗೆ ಅವ್ರಿಗೆ ಆಗಿದೆ ಈಗಿರೋವೆಲ್ಲ ಒರ್ಲಿ ಪಾಸ್ ಓವರ್ ಸರ್ ಯಾವುದು ಸರ್ ಸೀರಿಯಲ್ ನಂಬರು
ಅದೇನು TCR ಬರ್ಬೇಕಂತ
ರಿಲೀಸ್ ಫ್ರಮ್ ಪಾಟಡ್
ರಿಲೀಸ್ ಫ್ರಮ್ ಪಾರ್ಟೆಡ್ ಆಗಿದೆ. ಇಲ್ಲ ಸರ್ ನಾನು ಅದಕ್ಕೆ ಇಲ್ಲ ಸರ್
ನೀವು ರೌಂಡ್ ಹಾಕಿದ್ರಿ TCR ಇದೆ
ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ಬೋದು. ಪಾರ್ಟಿ ಬರುತ್ತೆ ಪೇ ಮಾಡಿದ್ದೀನಂತೆ
ಈ ತಿಂಗಳರ್ಧ ಆ ತಿಂಗಳರ್ಧ ಎಕ್ಸಾಮ್ PS ಮಗನ ಮಗಳದ ಅವ್ರು ನೋಡಿದಾಗ ಅವ್ರಿದ್ರು ಹೋದ್ರು ಏನು ಲಾಸ್ಟ್ ಇಲ್ಲ ಸರ್ ದುಡ್ಡು ಬರುತ್ತೆ ಕರೆಕ್ಟ್ ಇವಾಗ ಮಕ್ಳು ಯಾವ್ಯಾವ ಇರ್ತಂದ್ರೆ
Last door matter, list one, serial number 2, Hanumantarayappa.
Also, the petitioner submits that needful is done. Office to verify. If PF with the annexures are produced, issue notice.
Serial number 5, Harisha AS.
Petition, my lord. PF has been paid, my lord.
Acknowledgement.
Acknowledgement.
Paid.
In short, it will be given to petitioners na appear ಮಾಡಕ್ಕೆ ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಸ್ವಾಮಿ ಅದು ಔಟ್ಸೈಡ್ ಸೆಟ್ಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಇದು ಮ್ಯಾಟರ್ ಅದು ಅವ್ರಿಗೆ ಹುಷಾರಿಲ್ಲ ಹಾಗಾಗಿ ಬರ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
After listing for 7th time now, today you
My
have
lord,
paid
yeah.
what is that?
No, my
Let's
lord.
see.
In the last hearing also I have submitted.
Serial number 6, Petri Mohammed Ismail.
Okay, no. Counsel for the petitioner is absent, no representation. Order sheet dated so and so reads as sender. In spite of that, PF for issuance of notice to respond in number 2 is not paid. It appears the petitioner is not interested in prosecuting the petition. Petition dismissed.
Serial number 8, BB Vidyulata, C Jagdish.
Appear.
Look, the petitioners have challenged the first information report, my lords, at annexure G, page 66. Which was filed, my lords.
1 minute.
Ah.
66 is the FIR.
Yes, yes, please. We have challenged the FIR itself, my lord. 68 is the relevant portion.
Portion of the FIR.
Last portion, my lords. ಆದುದರಿಂದ ಸುಳ್ಳು ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಪಡೆದು ಪರಿಶಿಷ್ಟ ಜಾತಿಯ ಜನಾಂಗಕ್ಕೆ ಮತ್ತು ಸರ್ಕಾರಕ್ಕೆ ವಂಚನೆ ಮಾಡಿರುವ ಮೇಲ್ಕಂಡ ಆರೋಪಿಯ ವಿರುದ್ಧ ಸೂಕ್ತ ಕಾನೂನು ಕ್ರಮಕ್ಕಾಗಿ ನೀಡಿದ ದೂರು ಇತ್ಯಾದಿ. So the allegation, my lords, was that the petitioner had obtained a false caste certificate.
He got the caste certificate as he belongs to scheduled tribe.
Scheduled tribe. That was the allegation. This, my lords, was based on annexure F, which was the proceedings of, my lords, the district caste verification committee. The lordships will get that at page 62. This is dated, my lords, 22/12/2021. ಆದೇಶ ಮೇಲಿನ ಖಂಡಿಕೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳಿಗೆ ಶ್ರೀ ಎಂ ಪ್ರತಾಪ್ ಬಿನ್ ಸೋನ್ಸೋ So and so, ಇವರು ಮೂಲತಃ ಹಿಂದುಳಿದ ವರ್ಗ ಜಾತಿಗೆ ಸೇರಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ 15/7/2015 ತಹಸೀಲ್ದಾರ್ ಅವರು ದಕ್ಷಿಣ ತಾಲೂಕರವರು ನೀಡಿರುವ ಪರಿಶಿಷ್ಟ ವರ್ಗದ ಕಣಿಯನ್ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ರದ್ದುಪಡಿಸಲು ಸಮಿತಿಯು ತೀರ್ಮಾನಿಸಿ ಆದೇಶಿಸಿದೆ.
So that caste certificate is
Was
cancelled.
quashed. Yes, my lords. So we challenged, my lords, this order before this honorable court. Your lordships, if your lordships would kindly take a memo, my lords have filed on 23/6/2023. Along with the memo,
Petition 13/709 of 20.
your lordships got the memo, my lords?
Yes.
In that, I have produced, my lords, the order of this honorable court at page 3, that is WP number 13709 of 2022.
Yes.
Dated 31/1/2023, my lords. If your lordships would go to page 14 of the said order, my lords, para 14, page 14,
This order of the caste verification committee was challenged.
challenged. Lords, it was quashed by this honorable court and at page 14, para 14, my lords. Your lordships got para 14, my lords. Page 14.
No, para 14 is page
14,
number
11.
16.
16, correct. Page, in the light of the aforesaid, the petition is allowed and the third respondent's order dated 22/12/2021 and the fourth respondent's order dated so and so were quashed. Fourth respondent was the bank, my lords. They had terminated the services. That and the caste verification committee order were quashed, my lords.
He was a bank employee.
He was a bank employee. Thereafter, my lords,
Order
the,
to be reinstated.
yeah, the bank, he was reinstated, but the bank went on an appeal, my lords. The next order, if your lordships would see, they went on an appeal. The appeal was dismissed, my lords. So the order of the learned single judge, my lords, remains even today. Thereafter, my lords, the bank sought, my lords, for a verification certificate from the caste verification committee. So now, my lords, another memo, my lords, I have produced on 18th February 2025. Again, fresh inquiry was held. And a validity certificate, my lords, is issued, my lords, on 23/12/2024 by the District Caste Verification Committee, holding, my lords, that he belongs to Kanyan scheduled tribe category. Page 3, my lords, is the validity certificate that is issued. Page 3 of my memo, my lords.
Yes.
So in this view, my lords, the allegation that he has obtained a false caste certificate, my lords.
Counsel, the petitioner being the accused in a crime number 43 of 2022 of Halsu Gate Police Station, registered for the offense punishable under sections 177, 181, 196, 198, 420 of IPC and under section 31Q of HCST Prevention of Atrocities Act, is seeking to quash the criminal proceedings initiated against him. Brief facts of the case is that respondent number 2. Who is the complainant?
The complainant was a sister
Sister
of the petitioner.
okay. Sister of the petitioner filed the first information It also got
This
cons-
FIR, my lords, is by the Directorate of Civil Rights Enforcement, my lords. The complaint which led to the first information report, my lords, is that by the Directorate of Civil Enforcement. The inspector gives.
Now, what
The
was
original
basis?
complaint for caste verification, my lords, is given by the sister.
Sister of the petitioner filed first information against the petitioner, contending that he obtained caste certificate by making false representation that he belongs to scheduled caste. Belongs to Kanian and noted caste, which is a scheduled tribe. On the basis of the same, the District Caste Verification Committee held inquiry and cancelled the caste certificate obtained by the petitioner as per order dated 22/12/2021. Cancellation of the caste certificate by District Caste Verification Committee was challenged by the petitioner by filing petition number cancelled by the District Caste Verification Committee. Therefore, the Directorate has filed the first information against the petitioner, alleging that he obtained caste certificate proclaiming that he belongs to Kanian community, which is a scheduled tribe, and thereby committed the offences so and so. Accordingly, the FIR in crime number 43 of 2022 was came to be registered and the investigation was undertaken. In the meantime, the petitioner has approached this court seeking to quash the FIR and the criminal proceedings initiated against him. Heard so and so. Peruse the materials, point for consideration. Earlier heard learned counsel for the petitioner, learned executive for respondent number 1, and learned special counsel Sri so and so, Jagadish Antani and Bharat for respondent number 2. Peruse the materials, point for consideration. My answer to the other point in the affirmative for the following reasons. Is the specific contention of this prosecution complaining that the accused, even though does not belong to Kanian caste, a scheduled tribe, managed to get the caste certificate as he belongs to such caste and thereby committed the offense. On the basis of the complaint lodged by the sister of the petitioner, the District Caste Verification Committee verified the caste certificate and passed the order dated 22/12/2021, cancelling the caste certificate obtained by the petitioner. The said order dated 22/12/2021 passed as per Annexure F was challenged by the petitioner before this court by filing WP number 13709 of 2022. As per order dated 22/12/2021. As per order dated 31/1/2023. The coordinate bench of this court allowed the petition state the petition forthwith. So it is stated that the order passed by the learned single judge in WP 13709 of 2022 was challenged by the bank by preferring a writ appeal in WA 449 of 2023. The division bench of this court today order dated 14th June 2023 dismissed the appeal and upheld the order passed by the learned single judge. Next. The materials on record discloses that the District Caste Verification Committee once again held an inquiry and issued a valid caste certificate to the effect that the petitioner belongs to Kanyan caste, which is a scheduled tribe, as per its order dated 23/12/2024. The said caste certificate is produced as document number 1 with the memo dated 18/2/2025. None of these facts are disputed by the learned HCGP or learned counsel for respondent number 2. In view of the above, it is clear that even though it is alleged that the petitioner does not belong to Kanyan caste, which is a scheduled tribe, but managed to obtain a caste certificate, the same was not accepted by the coordinate bench of this court, which allowed the writ petition and quashed the order passed by the District Caste Verification Committee. The division bench of this court has also not interfered with the order passed by the learned single judge. Moreover, the District Caste Verification Committee subsequently issued a fresh caste certificate to the effect that the petitioner belongs to Kanyan caste, a scheduled tribe. Under these circumstances, the contention of the complainant that the petitioner has obtained false caste certificate making a misrepresentation and committed the offence as stated above cannot be accepted. Therefore, initiation and continuation of the criminal proceedings is in abuse of process of law, and hence the same is liable to be quashed. Accordingly, the answer they will find out. Allowed.
Bill number 9, P. Sheshagiri Rao, Gopal Krishna Gowda.
Kindly pass over this matter, my lord.
Next sala pass over. Next sala pass over.
Kindly have it on day after tomorrow, my lord.
Huh?
Not the case for me.
ಏನು?
Day after tomorrow on date fix.
22 ಸಲ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಯಾಕೆ? ನೀವೇ ಹೇಳಿದ್ದಲ್ವಾ ನಾವು ರೆಡಿ ಇದ್ದೀವಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ.
So personal inconvenience ಇದೆ ಸ್ವಾಮಿ ಆದ್ರಿಂದ.
ಮತ್ತೆ ಪಾಸ್ ಓವರ್ ಯಾಕೆ ಕೇಳಿದ್ರಿ ಬೆಳಗ್ಗೆನೆ? ಕೇಳಿದ್ನಲ್ವಾ ನಾನು ರೆಡಿ ಇದ್ದೀರಾ ಅಂತ. ಹೌದೌದು ಅಂದ್ರಿ.
Sorry, madam.
Counsel for the petitioner prays for time. Petition is of the year 2022. The respondent filed application I-1 of 2023 seeking vacating of the stay, as the petitioner is enjoying the benefit of the interim order. The counsel for the petitioner undertakes to address his arguments on merits. Hence, I-1 of 2023 is ordered to be considered along with merits of the case, subject to the condition that the learned counsel for the petitioner shall address his arguments on merits on the next date of hearing. Interim order is extended. Just finally as the last one.
So lordship.
It's posted finally.
My lordship. Interim order is this.
Interim order ade, subject to condition.
Serial number 10, Kiran D.C. Vidyulata.
Petition is present before this court, madam. Petition.
Yes, so the petition allow ಆಗಿದೆ ಅವರು ಜಗದೀಶ್. Yes.
Petitioner is present before.
ಇಲ್ಲ ಆಯ್ತು ಅಷ್ಟೇ. ಎಷ್ಟು ಈಗ ಅಮೌಂಟ್ ಎಷ್ಟಿದೆ ಮೇಂಟೆನೆನ್ಸ್ ಅಪ್ ಟು ಡೇಟ್?
Settled in the compromise, my lord. Execution petition is withdrawn
ಯಾವಾಗ?
on 12/11/2022. Page number 12, my lord. Page number 12 of the memo, separate memo, my lord.
There is a compromise between the husband and wife.
Yes.
ಆಗಿದೆ sir.
ಆಮೇಲೆ
They have arrived for a compromise and they have withdrawn the execution petition, recovery petition. Now the divorce has been, decree has been passed in favor of the petitioner, madam.
Decree of divorce ಯಾರ್ ಪರನೂ ಇಲ್ಲ.
ಮತ್ತೆ ಈ ಪಿಟಿಷನ್ ಹೌ ಇಟ್ ಈಸ್ ಮೇಂಟೈನಬಲ್? ಇದು ಯಾವಾಗ 2021 ನಲ್ಲಿ ಹಾಕಿದ್ದು?
ಹೌದು sir. During the
This is
pendency of the,
Huh?
during the pendency of the criminal maintenance proceeding, the petition has been filed.
ಆಯ್ತು, ಆಫ್ಟರ್ ಕಾಂಪ್ರಮೈಸ್ ಇದನ್ನ ವಿಡ್ರಾ ಮಾಡ್ಬೇಕಿತ್ತಲ್ವಾ? Why it is kept pending all these years?
But after taking, after this incident, they have taken the NOC wakalat from my side, mala. Trail case papers nella ಅವ್ರು ಬೇರೆ
ನಿಮ್ಮನ್ನ ಕೇಳ್ತಾ ಇಲ್ಲ. You means petitioner ಅಂತ.
petitioner.
You always represent petitioner. ನಾನ್ ನಿಮ್ಗೆ ಏನ್ ಹೇಳ್ತೀನೋ ಅದೆಲ್ಲ petitionerಗೆ.
I'm representing this petition before this court, my lord. The trial court was petition was.
So I am asking the petitioner, after compromising the matter, why this petition was kept pending for long?
Other prayers of the petition, my lord.
ನೀವು ಗಂಡ ಹೆಂಡತಿ ಒಟ್ಟಿಗೆ ಆದ್ಮೇಲೆ ಮತ್ತಿನ್ನೇನು ಪ್ರೇಯರ್? ಡೈವೋರ್ಸ್ ಆಯ್ತಾ?
Divorce ಆಗಿದೆ.
ಹ್ಯಾಪಿಲಿ ಯು ಆರ್ ಸೆಪರೇಟೆಡ್. ಮತ್ತಿನ್ನೇನು? ಈಗ ಜಡ್ಜ್ ಟಾರ್ಗೆಟ್. ಹೆಂಡತಿದು ಮುಗೀತು, ಈಗ ಜಡ್ಜ್.
ಅವನ್ನ ಟಾರ್ಗೆಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅವತ್ತು ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ಅವರ್ ಸಬ್ಮಿಷನ್ಸ್ ಅವರು
ಯಾವ ಕೋರ್ಟ್ ನಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋರು ನೀವು?
ಟ್ರಯಲ್
ಎಲ್ಲಿ? ಬೆಂಗಳೂರು
ಮಾಡ್ತೀವಿ ಸರ್. ಇಲ್ಲೂ
ಬೆಂಗಳೂರಲ್ಲಿ. ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಸರ್ವಿಸ್?
9 years.
9 years. ಈ ರೀತಿ ಎಷ್ಟು ಜಡ್ಜಸ್ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿದ್ದೀರಿ? ಎಷ್ಟನೇ ಕೇಸ್ ಇದು?
ಯಾರ ಮೇಲೂ ಆಗಲ್ಲ, ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ. ಎಲ್ಲ ಮಾಡಿಲ್ಲ. ಇದೇ ಫಸ್ಟ್ ಟ್ರಯಲ್ ಅಂಡ್ ಎರರ್. ಟ್ರಯಲ್ ಅಂಡ್ ಎರರ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅವತ್ತು ನಡೆದಿರೋ ಇನ್ಸಿಡೆಂಟ್ಗೆ ಅವ್ರ ಫೋಟೋ ಎಲ್ಲ ತಗೊಂಡು ಅವ್ರ ಫ್ಯಾಮಿಲಿ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ, ಲಾಕಪ್ ಅಲ್ಲಿರೋ ಫೋಟೋಸ್.
ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಹಿ ಹ್ಯಾಸ್ ನಾಟ್ ಪೇಡ್ ದಿ ಮೇಂಟೆನೆನ್ಸ್. ಇಲ್ಲಾಂದ್ರೆ ಜಡ್ಜಸ್ ಏನ್ ತಲೆ ಕೆಟ್ಟಿದ? ವಾರೆಂಟ್ ಇತ್ತು ತಾನೆ?
ವಾರೆಂಟ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ
It was
you appeared before the court.
Appeared before the trial court.
Orally, he has, the instruction is you keep him. If they don't pay by the end of the day, he will be, warrant will be issued. So if they pay
I have filed
10,000.
a memo today given by the report given by the circle inspector of the Bangarpete police station, KGF police station. The concerned court of police has given a clear statement with the oral orders of the presiding officer.
Why
He
would
has taken the petition.
Why would he? We have put it in the statement of objections only. The learned judge himself has put.
Do you mean to say magistrate is not authorized to direct the police to take him into custody?
Not that day the case was.
Do you mean to say the magistrate is not having the power to direct?
Certainly their powers are vested with the
Then-
magistrate, my lord.
Then he has exercised that power.
That
where
time,
is
my
the
lord,
wrong?
only the objection was about, the case was set down for filing of the objection. First day appear ಆಗಿದೆ ಸ್ವಾಮಿ. Actually objection ಗೆ ಡೇಟ್ ಇತ್ತು ಅವತ್ತು.
ನೀವು ಇದನ್ನ ಇದೇ ಪರ್ಸೂ ಮಾಡಿದ್ರೆ I will take him into custody. You file a complaint against me. Take it to Supreme Court. Let me see. ಬಹಳ ಚೈಲ್ಡಿಶ್ ಆಗಿ ಆಡ್ತಾ ಇದ್ದೀರಿ. Even in spite of my advice. You take it from me
But
as
all
a
these
warning.
allegation we have filed before this court, and after if I withdraw by withdrawing all these
I will
allegations.
simply record, I heard you and direct the petitioner to be taken into custody. I will call the police. Challenge the order. Let me see. I can support with my with reasons. The conduct shows, conduct of the advocate shows. I will record it in my order. ಅದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರಲ್ಲ? ಹಾ.
As
I
date
will
of
refer
hearing,
it to the bar associate, bar council. ಹೋಗ್ಲಿ. ಎಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಏನೋ ಹಾಕಿ? Have you filed the application? Impleading ಗೆ?
last date ಅಲ್ಲಿ order sheet
ಎಲ್ಲಿದೆ
ಅಲ್ಲಿ
ಅದು? ಈಗ ಕೊಟ್ಟಿದೆ. ಎಲ್ಲಿದೆ ಅದು?
Withdraw ಮಾಡಿ sir, application. ಬೇಡ ಅದು.
madam.
Withdraw ಮಾಡಿ application. Press ಮಾಡಬೇಡಿ. Press ಮಾಡಬೇಡಿ, withdraw ಮಾಡಿ. ನಾನು ಅವತ್ತೇ ಹೇಳಿದ್ದೀನಿ 1 hour spend ಮಾಡಿದ್ದೀನಿ. Withdraw ಮಾಡಿ application.
Yes, argue on merits. ಇದೇನಿದೆ? Yes, on merits. Tell. Who is the petitioner?
Sri Lakshmi is the wife of petitioner, madam. Wife of respondent, petitioner in this case.
Sri Lakshmi is the respondent number 1. I am asking who is the petitioner?
Srikant is.
Why he is the petitioner?
He was a respondent in the trial court, madam.
First tell me the facts, sir.
The facts of the case is, my lord. The respondent number 1 is a wife of the petitioner, my lord. She has filed a criminal miss under section 1.
When they married?
They are married in the year 7/6/2017, my lord. 6th June 2017.
6/6. Then
Out of their wedlock, respondent number 1 has given
out of ಅಂದ್ರೆ ಮದುವೆಯಿಂದ ಹೊರಗಡೆ ಅಂತ ಆಗುತ್ತೆ.
From the,
ಮದುವೆ ಆಗಿದೆ from the
ಹಾ.
wedlock.
from the,
ಮದುವೆ ಗಂಡ ಹೆಂಡತಿಯಾಗೆ ಮಕ್ಕಳು ಹುಟ್ಟಿದ್ದು ತಾನೆ? ಔಟ್ ಆಫ್ ಅಂತ ಬರಲ್ಲ ಅದು.
Petitioner 2, number 2 is a daughter of.
How
the
many
petitioner.
children?
Only one
One daughter.
daughter.
Then
My lord, due to some family dispute, she got separated from the petitioner, my lord.
Hmm.
And she started living in her parental home.
Yes.
And she has filed a criminal miss petition seeking compensation, seeking maintenance under section 125 of CRPC.
How much?
My lord, that is for 15,000 for petition number 1 and 10,000 for petition number 2.
What is the order passed?
The interim
Petition
order,
was allowed.
interim order was, as on the date of filing, the petition was, interim order as was passed, my lord.
What was the amount awarded?
Amount awarded is
3,500. 3,500.
3,500 per month.
In all,
Not.
No,
3,500 per month
per month, my lord.
for both wife and daughter.
Yes, my lord.
From the which date?
My lord,
From which date that
from
amount
the
is
date of
due?
petition, my lord.
When the petition was filed?
Petition was filed in the month of 24/11/2018, my lord.
So from 24/11/2018, you have to pay 3,500 per month.
Yes, my lord.
Have you challenged that order?
We have challenged that order by way of revision petition before the district court, my lord.
Criminal revision petition number?
45 of 2019. 102.
45 of 2019, my lord. The order of the revision, the trial court was upheld by the revision court, my lord.
That was dismissed.
It was dismissed.
Order dated?
It is on the 13th September 2019, my lord.
Then have you challenged that order?
No, my lord.
So it has reached finality.
My lord, interim order is, we have not challenged the order of the criminal revision petition, my lord. After the disposal of the main petition filed by
Whether
the,
you have paid the maintenance,
we have paid it.
how much? All how much you have paid?
As of today, my lord. Since the date of petition, my lord, we have paid 38,000, my lord. 30. Just a minute. Yeah, my lord, it's it. DD ಕೊಟ್ವಲ್ಲ DD ಅಲ್ಲಿ Oh, 20,000 before the order of the, before interim order, my
No,
lord.
in all, how much you have paid?
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಇದು?
ಅವ್ರಿಗೇನ್ ಗೊತ್ತಿರುತ್ತೆ, ನಿಮಗ್ ಗೊತ್ತಿರ್ಬೇಕು.
My lord,
ಕಾರ್ಡ್ ಇಟ್ಕೊಂಡಿರೋರು ನೀವು
as on the date of petition, we have paid 30,000, my lord.
30,000.
As on the date of so incident, 30,000. That is 2,000.
No, till the date of compromise, what is the amount paid by you? In terms of the order passed by the learned magistrate.
1.2 lakhs.
ಅದು ಕಾಂಪ್ರಮೈಸ್ ಟರ್ಮ್ಸ್ ಆಯ್ತು, ಅದಲ್ಲ ನಾನು ಕೇಳ್ತಾ ಇರೋದು. As maintenance ordered in the miscellaneous case.
The maintenance, the recovery proceedings, they have sought a 68,000 of recovery, my lord.
Sir, ನಿಮ್ಮನ್ನ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, how much is paid by you?
My lord, as on the date of filing this petition, we have paid 30,000, my lord.
ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ ಅವರನ್ನ ಕಸ್ಟಡಿಗೆ ತಗೊಳ್ಳಿದ್ದು ಓರಲ್ಲಿ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ,
ಹೌದು sir.
ಅವತ್ತಿನವರೆಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರಿ?
20,000 ಕೊಟ್ಟಿದ್ದೀವಿ sir.
20,000.
DD ಅಷ್ಟೇ 20,000.
ಅದು ಯಾವಾಗದು?
Highlight ಮಾಡಿದ್ವಲ್ರಿ. On 2/11/2019. Page number 176 ಅಲ್ಲಿ ಇದೆ sir.
ನಿಮ್ಮನ್ನ ಕಸ್ಟಡಿಗೆ ತಗೊಳ್ಳೋದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದೆ ಯಾವಾಗ?
2021 ನಲ್ಲಿ sir.
ಯಾವ ಡೇಟು?
31st July 2021.
That is in execution case.
Yes, my lord. It is in execution case, my lord.
Number ಎಷ್ಟು?
146 of 2020.
What was the amount due?
60,000 was 68,000 was recovery, recovery amount. 10,000 was paid on the date of taking the custody of the petitioner, my lord.
After taking custody. As on the date, the claim was 68,000. As on 17/12/2020, she claimed that he has not paid any maintenance and the maintenance amount was 68,000.
This 20,000 was also not paid.
That's what they say. They say only 20,000 was paid in the year November 2019. Remaining balance of 67,500 is not paid.
So 67,500 was
500.
due.
So for 68,000, along with 500 rupees miscellaneous charges, she seeks for 68,000
68,000.
as on 17/12/2020.
Yes. What is your grievance now? Tell me.
My lord, as on that day, my lord, in 31st July 2021, my lord, we have been represented, the petitioner has been represented by the council and the case was set down for objection to main petition.
Yes.
On that day, my lord, the case was called out around 11/11/15, my lord.
That is on 31/7.
That is 31/7/2021, my lord.
Huh.
The case was called out at 11/11/15, my lord. And 3 cases were simultaneously called, my lord.
Yes.
One is, my lord, CMIS 146 of 2019. Another CMIS 146 of 2020. Another one is 181 of 2018. 181 of 2018 is a case petition filed by the respondent number 1 and 2 against the present petitioner. And CMC 146 2020 filed by the petitioner respondent number 1 and 2 against the present petitioner. And 146 of 2019 filed by another Sri Lakshmi. She was also a Sri Lakshmi, and another Sri Lakshmi against her husband, Mr. Manjunath. But while calling out this case, the case with so-and-so 146 of 2019 has been called. And even the 146 of 2020 has been called. Malad.
Yes.
The counsel for appearing before, appearing for 146 of 2019, he urged the court to take the custody of the petitioner.
Who?
To Honorable Court. Malad.
Yes. Advocate for wife.
Advocate for husband, Malad. A wife, Malad. In CMC 146 of 2019, which is not our case, Malad.
Yes.
That time, my lord, I made my submission. This case was not relating to me, and my petition is pending for objection to main petition. In the first hour itself, he has the petitioner has been sent to lock up and for detaining him to pay the maintenance, my lord.
Yes.
Later on, the mother of sum of rupees 10,000 to the respondent number 1 and 2. And subsequently, he has been released from the custody.
Is the amount paid by your mother?
10,000.
When?
On the same day.
On the same day, 31st July 2021.
Paid to the wife, your wife.
Yes,
Then when he was released?
After payment of the amount, he has been released after 1 hour.
Same day?
Same day, Mala.
Then?
Later on, I filed a detailed memo stating that narrating the incident of the so-and-so particular day, Mala.
When you filed?
The same day, Mala, afternoon 3 p.m.
Where is the memo?
The memo is in page number 213, Mala.
There is not 213.
213.
213, Mala.
Read that memo.
The undersigned counsel for the respondent humbly submits as follows. The above case is filed against the respondent under section 125 of CRPC, seeking maintenance along with IA for an interim maintenance. Upon hearing the interim application, this court has ordered to pay the monthly maintenance of rupees 3,500. The petitioner filed another petition under section 125 subclass 3 of CRPC for the recovery of the outstanding amount payable to the petitioner. The same is registered in CMC 146/2020. The above stated CMC number 181 of 2018 is listed on today for arguments on main petition, and CMC number 146/2020 is listed on today for filing of objection by the respondent. Today, the above stated CMC number 181 of 2018 was called out at 12:30 p.m. and the counsels for both the parties appeared and were ready to address their argument. Case got passed over. Very next to that case, 146 CMC 146 has been called out, and the name of the petitioner was Mrs. Sri Lakshmi. Hearing the name of the petitioner, the counsel for the petitioner and the respondent appeared before the honorable court. The respondent was asked to pay the maintenance as per the interim order. The counsel for the petitioner pressed for the balance of money. Then the counsel for the respondent submitted the facts of the case and IA. Since the petition is pending for objection, without hearing the submission of the counsel for the respondent, the court has directed the police to take the custody of the respondent. Immediately, the respondent was sent to court lockup. Immediately, the mother of the respondent paid a sum of rupees 10,000 as part payment. Then the respondent was released from the custody. The petitioner, by taking the said money, left the court premises without affixing her signature in the order sheet. It is pertinent to note that CMC 146/2019 is filed by one Sri Lakshmi against her husband, Mr. Manjunath. The respondent was compelled to pay the maintenance based on the merits of that case, and he was detained in the lockup for no fault of him. Now, the counsel for the respondent adjusts before this court, before this honorable court, to record the above incident in detail and provide the opportunity to the respondent to file his objection and to direct the petitioner to return the money received by oversight. This is the incident taken place on the particular day.
How you are entitled for recovery of the amount? Order to pay interim maintenance of rupees 3,500 per month has reached finality. You are liable to pay. How you are entitled to recover that?
the question was not pay.
When that order has reached finality, what objections you can have?
My lord, we were ready to pay the amount, my lord.
Ready, you are not, ready is not the concern of you have not paid it. Admittedly, you have not paid till 2021. Simply saying, I was ready, I was ready. How the wife and child, the daughter should live? You are not doing any charity. They are your wife and children.
Yes, my lord,
And the order granting interim maintenance has reached finality. You cannot have any objection thereafter. Simply you have to pay the amount.
Even payment of the amount is not been, opportunity has not been afforded by the trial court, my
That
lord.
miscellaneous petition for recovery was filed in 2020.
Yes, my lord.
And this order, this memo was filed in the, 31/7/2021.
Subsequent to 7 months of the,
Till that date, you are not ready to pay the amount.
my lord, I have entered the appearance in the so-and-so recovery
I am
case.
not concerned about that. Why you have not paid the amount? I am ready to pay the amount.
But since the
And
case
that is
was,
to be heard by the wife and daughter, then they have to make a living out of it, is it?
the full and final settlement was, there were negotiation between the petitioner and the,
What was your defense? Why you have not paid the amount?
my lord, the defense is, my lord, only they were in the negotiation between for settling the
Is
dispute
then
out.
how they have to make living? Who will feed them?
She was working, my lord,
As,
as a college lecturer.
have you produced any
Yes, my lord, in
document?
page number 123,
What is the avocation of the petitioner?
she's a double master graduate, my lord.
ಇವರು ನಿಮ್ಮ petitioner ಕೇಳ್ತಾ
He's
ಇದ್ದಾರೆ.
an engineer, my lord.
He is an engineer. So considering all those things, the magistrate has ordered 3,500. District judge has dismissed your revision. Then why are you repeating the same thing without paying the amount?
That day, circumstance was different, my lord. We were ready to pay, but we are making the humble submission before the court. And if the case would have passed over for at least for afternoon, we could have made some.
See, I am hearing you. I am seeing your conduct even before this court. I can imagine what had happened before the learned magistrate. I can just imagine. Yes, proceed.
My grievance is, my lord.
When the order granting interim maintenance has reached finality, and when admittedly you have not paid the balance amount of maintenance till 2021, what is the wrong with the order of the learned magistrate?
Lord, in their objection, they have only clearly stated that after exhausting the provision of 421 of CRPC, the last.
Show me one section in the CRPC which bars the learned magistrate from directing the police to take him into custody. Which law says magistrate is not authorized?
But even though magistrate is vested with ample powers.
Admittedly, even according to you, the learned magistrate is authorized. Then why you are aggrieved by that order?
My lord, no warrant has been issued, my lord.
Why? Where is the question of issuing warrant, sir? Show me. That is why I am asking you.
My lord, in 125(3) of CRPC, in their objection, they have mentioned clearly, my lord, I may be permitted to read out it.
Read it.
If any person so ordered fails to without sufficient cause to comply with the order, any such magistrate may, for every breach of the order, issue a warrant of levying amount due in the manner provided for the levying fines, and may sentence such person for the whole or in part of each month for allowance of the maintenance or interim maintenance and expenses of the proceeding as the case may be, remaining unpaid after execution of the warrant to imprisonment for a term which may extend it to 1 month or until payment if sooner made, provided that no warrant shall be issued for the recovery of the money, any amount due under this section, unless the application is made to the court to levy such amount within a period of 1 year from the date on which it became due, provided further that if
ಅದಾಯ್ತು ರೆಲೆವೆಂಟ್ ಓದಾಯ್ತಲ್ಲ ಮತ್ತಿನ್ನೇನು. So you
Alright,
mean to say.
you would have not escaped.
Mean to say, even though you have not paid the amount, even though the petitioner was present before the learned magistrate, the magistrate was helpless. He has to issue warrant in accordance with 126 and wait for recovery of the amount. Till then, your wife and daughter, they have to starve. Is it the spirit of 125?
No, my lord.
Why 125 was enacted?
For the benefit.
What was the purpose behind that?
For the benefits of the
Then
petitioners, my lord.
how can you defeat that object? On technicalities.
My lord, my submission before this court is I have been deprived of my making the submission before the trial court, my lord. We were ready to pay the maintenance on the same day.
Sir, ready to pay will not inure to the benefit of the wife and daughter. I am repeating this for the second time. They cannot make a living out of that. My husband is ready to pay the maintenance amount, so myself and my daughter can make a living out of that.
My lord, be much prior to the passing of the interim order, we have
Part of the petitioner and the counsel representing the petitioner speaks louder. It is nothing but arm twisting, nothing but threatening the magistrate. Now, what do you want? That application is to be allowed. The magistrate is to be impleaded as one of the respondent. Then what next? What is the reason assigned? Why he should be impleaded?
last date of hearing in CAS, it has shown that impleading of the.
He is necessary to be impleaded as a party in the proceedings. What for? He is to be taken into custody.
None.
Why he is to be impleaded?
The petition was last, I will read out my affidavit. The reasons quoted in the affidavit, I maybe read out one.
Yes, what is that?
The petition was lastly heard on 25/2/2025. The Honorable Court has observed the non-jointer of the judicial officer to the proceedings. Since the reliefs are sought against him, it is.
Where is such observation?
Orally.
I asked you whether you are intending to join array the magistrate also. You said yes. I will implead him. Order sheet. That was your submission. Further, learned counsel submits that since judicial officer is not made as a party, he will file necessary application to implead him. For what for? I am asking you.
Since the other relief was against the respondent.
What was the relief?
To consider the representation of the petitioner in page number annexure N of the petition.
Whether the same magistrate consider that?
No, my lord, it has been addressed to Registrar General.
Then make him as a party.
He's already respondent number.
Make the Registrar General as a party, since he has not considered your memo.
No, my lord, the Registrar General is a respondent number 3, my lord, in this case.
Oh, he is already a party. Who is respondent number 2? Daughter.
Daughter, the minor daughter.
Now respondent number 4 will be the magistrate.
Magistrate.
Yes, what is to be done?
My lords, I have, I mean, off the record, my lords, I took almost 1 hour telling him, you're a very young advocate. Don't enter into all these things.
No, you see,
My lords, what had happened on that day, my lords, I have clearly stated, my lords, at para 10 of the statement of objections. There was a huge allocation. There was a loud speaking by the.
your objection statement.
Yes, my objections.
You are representing respondent number 3.
The Registrar General.
Yes.
And we've also stated, my lords, that his representation is considered and we have conducted an inquiry in this regard. Para 6, my lords, speaks of. Para 6, my lords, speaks of.
So now the memo, which is the representation he is referring to?
He's referring to one representation given to
Yes,
the Registrar General, annexure.
Against the learned magistrate.
Yes, my lords.
Ah.
We have stated that we have inquired into the matter and a suitable explanation was given.
Yes.
My lords, para 6, my lords, is what happened on that day. My lords, it's not in dispute, my lords, that 68,000 was what was unpaid. So here, my lords, page 4, para 7, the presiding officer on an inquiry also found that the interim order dated 24/5/2019 had become
Only
final.
which is that you are.
Para 7, my lords, of my statement of objections. From the first line, my lords, the presiding officer perused the order sheet and found that from 24/5/2019, that is date of interim order, the petitioner had not paid any interim maintenance to respondent numbers 1 and 2. Hence, he asked the petitioner in open court to pay the interim maintenance, who refused to pay maintenance. The presiding officer on an inquiry also found that the interim order dated so-and-so had become final since it was not challenged by way of an appeal. Since the petitioner herein was reluctant to pay the interim maintenance as awarded, and also since the matter involved payment of maintenance not only to the wife but also to the minor child, the presiding officer orally directed the court police to take the petitioner under custody and further warned him that if he does not pay the interim maintenance to respondent numbers 1 and 2, he would be forced to send him to prison. Para 8, my lords, that is only of 125 CRPC, my lords. The next page, my lords, para 10. The matter was then passed over, and when the matter was called after some time, the petitioner paid sum of rupees 10,000 to respondent numbers 1 and 2, and hence he was not sent to prison. On 31/7/2021, both counsels for petitioner and respondent numbers 1 and 2 exchanged words to each other very loudly in open court. Counsel for writ petitioner made very arrogant submissions. In spite of all this, since the learned presiding officer wanted smooth functioning of the court and justice being done to the parties, none of these aspects were recorded in the order sheet. And it was the first day the presiding officer had taken charge in that court, my lords. It was the first day.
Yes, that is my question, my lord. First day ಬಂದಿದ್ದೀರಾ ಸ್ವಾಮಿ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಅಂತ ಹೇಳಿ.
Order sheet ನೋಡಿನೇ ಮಾಡಿರೋದು. And now, my lords, if your lordships could kindly see page 21.
My lord,
When CMC 181 of 18 was filed, my lords, his daughter was 30 days old. 30 ದಿನದ ಮಗುನ ಒಂದು ತಾಯಿ ಕೋರ್ಟಿಗೆ ಕರ್ಕೊಂಡು ಬರ್ತಾರೆ, ನನಗೆ ಮೇಂಟೆನೆನ್ಸ್ ಇಲ್ಲ. 125 ಅಲ್ಲಿ ಪೇಜ್ 121 ಅಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ. ಫಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರಲ್ಲ, ದೇರ್ ಪೆಟಿಷನ್, ಮೈ ಲಾರ್ಡ್ಸ್. ಆ ಮಗು ವಯಸ್ಸು 30 ದಿನ, ಎಲ್ಲೋ ಹೊರಟೋಗ್ಬಿಟ್ರು ಇವರಿಬ್ರು ನಮ್ಮನ್ನ ಬಿಟ್ಬಿಟ್ಟು ಅಂತ ಹೇಳ್ತಾರೆ. 30 ದಿನದ ಮಗುನ್ ತಗೊಂಡು ಹೆಣ್ಮಗು ಎಲ್ಲೋ ಹೋಗಿರತ್ತೆ. ಪೇಜ್ 21, my lords.
121.
No, only 21, my lords. 21.
It is page number 172, my lord.
21. 21. Petition. Kindly see the age of Kumari, the child. It is 30 days.
21 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
21 ನನಗೆ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ 20.
Order sheet 21.
Order sheet ಅಲ್ಲ.
Petition number.
It is 23.
23 my lord.
ಮಗು 30 ದಿನದ್ದು. kindly see, my lords, page, this could be 121, my lords, 119 in the particular. 146 of 2020. Then kindly see page 146 of 2020, my lords. ಮಗುಗೆ 2 ವರ್ಷ.
ಆಯ್ತು.
ಅವಾಗ
Filing the petition, the age was 30 days.
30 days. And now the child 2 ವರ್ಷನೂ ಕೊಡೋದಿಲ್ಲ. ಅದಕ್ಕೆ she files 146 of 2020 when the child is 2 years old. And they say she was gainfully employed. Where would she go leaving a 30 days baby? And kindly see, my lords, page 159. This is order sheet of 146 of 2020. I don't know if it is Yeshnedidu, 158 or 169.
159.
159. The petition, my lords, is filed on 18/12/2020. 2020.
2020 is in
Order sheet.
page number.
They appear in the file wakalat, my lords, on 7/4/2021. ಅದಾದ್ಮೇಲೂ ಏನ್ ಪೇ ಮಾಡಲ್ಲ ಇವರು. ಆರ್ಡರ್ ಶೀಟ್ ನಾನು ನೋಡಿ ಸ್ವಾಮಿ, ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಸ್ವಾಮಿ ಅಂತ ಏನ್ ತೋರಿಸ್ತಾರೆ? ಪೇ ಮಾಡಿದೀವಿ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ. 7/4/2021 ದೇ ಎಂಟರ್ ಇನ್ ಟು ಅಪಿಯರೆನ್ಸ್. ದ ಮ್ಯಾಟರ್ ಇಸ್ 31/7/2021. ಅವತ್ತಿಗೂ ಪೇಮೆಂಟ್ ಆಗಿಲ್ಲ. It is admitted, my lords, they had not made any payment. And there was no confusion of the cases. The learned magistrate knew clearly well that this was the case that was being called.
It had taken place on
31st July
7/2021. They enter appearance on 7/4/2021. ಗೊತ್ತಿಲ್ಲ ಅಂತಂದ್ರು, ಕೊಡಬೇಕು ಅಂತ ಆರ್ಡರ್ ಆದ್ರೂ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೋರ್ಗು ಕೊಡೋದು ಬೇಡ ಅಂತಿದ್ರು at least execution ಹಾಕಿ they enter appearance ಅವಾಗ್ಲೂ ಗೊತ್ತಿರ್ಬೋದಲ್ವಾ?
Before the interim order itself, we have paid voluntarily 20,000 rupees, my lord.
ಅದನ್ನ ಕೊಟ್ಟು ವಾಲಂಟ್ರಿ ಏನಿಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಸರಿ, ತಗೊಳ್ಳಿ.
My lord, one submission, my lord. My lord, in the statement of objection, my lord, yes, it is clearly stated, further warned him that if he does not pay the interim maintenance, respondent number 1 and 2, he will be forced to send him to jail. My lord,
ಏನು ಓದ್ತಾ ಇದ್ದೀರಿ?
ನಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್
objection ಅವ್ರು ಹೇಳ್ತಾರೆ ಜೈಲಿಗೆ ಕಳಿಸ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಏನ್ ತಪ್ಪಿದೆ ಅಂತ ಕೇಳ್ತೀನಿ, ಇವತ್ತಿಗೂ ನಾನು ಹೇಳ್ತೀನಿ. After passing the order, I am going to send him into the custody. Be warned.
Lord, I have promised him that we will ಅಲ್ಲಿ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ರಿಲೀಫ್ ಸಿಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಕರ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ.
ಈಗ ಹೇಳಿ, ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇನ್ನೊಂದಿದೆ, ಅಲ್ಲಿಗೆ ಪ್ರಾಮಿಸ್ ಮಾಡಿ. Petition has approached this court. Seeking an order to transfer civil criminal miscellaneous case 181 of 2018 pending on the file of the learned civil judge and JMFC at Bangarpet to the court of the learned civil judge and JMFC Kolar for disposal. To direct respondent number 8 to consider
petitioner
representation. ಕೂತ್ಕೊಳ್ಳಿ ಸರ್, ಒಂದಿಷ್ಟು ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬೇಡಿ. ಐ ಆಮ್ ಡಿಕ್ಟೇಟಿಂಗ್ ದಿ ಆರ್ಡರ್. ಡೋಂಟ್ ಇಂಟರ್ವ್ಯೂನ್ ಇನ್ ದ ಮಿಡಲ್.
He has petition is filed by me, my lord, because of as per course of relief, my lord.
You are his advocate.
But he is illiterate in the legal aspects, my lord.
He has to suffer. Not only he.
Yes.
You will also suffer. I am directing the bar council to initiate action against you.
I may be, my lord, I may be subjected to.
ಹೆಸರು enrollment number ಕೊಡಿ ದಯವಿಟ್ಟು.
My lord, I may be subjected, my lord. We cannot be victimized, my lord. He is an.
I understood. Wait for some time.
Can I speak?
Yes.
Ma'am, I was told that we'll get relief here, so I acted on whatever he advised. That's all.
You are not entitled for any relief. I am telling you. You are not entitled for any relief, but the order will be passed against you. Who is she?
My
mother.
Mother.
Yes.
Yes, I am not concerned about her.
Madam, on that day, we were really hurt and then we discussed. So, advice was given by him. So we acted upon, whatever he said.
Yes.
Otherwise, I don't have any idea about legal terms or whatever it is, madam. I am an engineer by graduate, so I don't have any idea.
Then why you made such allegations against the judicial officer?
Whatever happened on that
You should
day,
understand
no,
the
whatever,
seriousness.
whatever happened on that day, we went home, without, thinking what happened.
Huh.
And then the
Who
respondent.
advised you?
No. The respondent took photos and then circulated it in our relatives. So we asked him. So he said that let's go to High Court and get the relief, whatever
I'm
it is.
advised, my lord, I'm advised.
Otherwise,
Why you made allegations against the judicial officer?
I just said whatever happened. That's all. On that day, whatever happened, I didn't say anything. The events, whatever happened, and I definitely say that it happened. I went through that pain. And I didn't have any intentions of getting into the court of legal proceedings, but still because of this one particular incident, that lady pulled me into the court, who is my ex-wife. She pulled me into the court and I had to come to the court. Otherwise, I don't have any idea of coming into legal proceedings.
Yes.
So
You should understand the order granting maintenance to your wife as well as the child aged 30 days as on the date of application has reached finality and you are bound to obey the order of the court.
Yes, respectfully, I will agree that I have to abide by that. But I had also filed a case for rejoining conjugal rights. I said, come and join me in my maternity.
We are not concerned about that.
So she didn't attend
You
the
should
case
have
at all.
obtained an order for conjugal rights.
Case, madam.
That cannot be the ground for denying the maintenance.
No, I was not denying, ma'am. I don't even have job even today. I'm being an ISO consultant. I'm working day and night.
Now, what do you want to say now?
Ma'am, we don't want to press any charges against him. Whatever events happened, we submitted. So please give me some, whatever relief that you think is the best. That's
No,
all.
I am not going to give you any relief.
Okay.
I am dismissing your petition and the consequences will follow.
No, I'm leaving it to your best knowledge that you please decide whatever has to happen, but I have acted on advice of my lawyer. Otherwise, I don't have any intention.
Should I record that?
Certainly, he has taken the advice of, as per acted upon my advice, my lord. I'll take the burden of that.
Yes, so good. You write it, file a memo, paper code every. Petitioner.
ವಿಡ್ರಾ ಮಾಡಿ ಸರ್ ಪೆಟಿಷನ್ ವಿಡ್ರಾ ಮಾಡಿ ಯಾಕೆ ಬೇಕಿದೆಲ್ಲ ವಿಡ್ರಾ ಮಾಡಿ
Submitted by the petitioner seeking disciplinary action against the presiding officer of the trial court and to direct the presiding officer of the trial court to pay a sum of ₹500 as compensation to the petitioner for sustaining mental agony out of abusive power, mental agony due to abuse of the power of the presiding officer. The facts in the case are that
ಅವರಿಗೆ ಕರೆಕ್ಟ್ ಅಡ್ವೈಸ್ ಕೊಡಿ ವಿಡ್ರಾ ಮಾಡಿ ಯಾಕೆ
let him write what he has now just now stated. You write it. The respondent number 2. Respondent number 1 and 2 being the wife and child of the petitioner. While criminal miscellaneous number 181 of 2018 claiming maintenance under section 125 of CRPC. It is the contention of respondent number 1 and 2 that respondent number 1 married hearing on 6/6/2017 and in the marriage they have begotten a daughter. The daughter was aged 30 years. The respondent number 2 daughter was aged 30 years. Then criminal miscellaneous 181 of 2018 was filed. Considering the plight of the petitioners, the trial court passed an order. The petitioners have also sought for grant of interim maintenance of ₹10,000 per month to petition number 1 and ₹6,000 per month to petition number 2. petitioner hearing being the respondent in criminal miscellaneous 181 of 2018 filed his objection statement. After considering the objections, the trial court proceeded to pass the order awarding maintenance of rupees 3,500 to be paid to respondent number 1 and 2 hearing as monthly interior maintenance. And the matter was set down for evidence. Next part, it is stated that the petitioner husband had not paid the, it is stated that the petitioner husband has challenged the order granting interim maintenance before the learned sessions judge by preferring criminal revision petition number 45 of 2019. The said petition was came to be dismissed with a order dated 13/9/2019 and confirmed the order of the learned magistrate granting interim maintenance of rupees 3,500. Thus, the order granting interim maintenance reached finality. Next part. It is the contention of the wife that the petitioner herein had not paid the interim maintenance as directed. Therefore, she filed criminal miscellaneous
Spoil your career.
146 of 2020
I don't know why you people.
seeking recovery of the maintenance amount. The petitioner hearing was summoned before the trial court. Accordingly, he appeared to the learned counsel and sought for time to file objections. Since the arrears of maintenance was not paid by the petitioner hearing, the learned magistrate seems to have directed the petitioner hearing to be taken into custody unless he pays the arrears of maintenance. He stated that the mother of the petitioner, petitioner paid rupees 10,000. And later, the matter was adjourned to some other date, towards some other date, next date of hearing. Next part. Now it is the contention of the petitioner that the learned magistrate could not have threatened the petitioner that he will be taken into custody, since there was no warrant issued against him and the learned magistrate was not authorized to direct remanding the petitioner to custody. Therefore, a representation was submitted to respondent number 3, that is the learned Registrar General, High Court of Karnataka, to initiate disciplinary action against the presiding officer of the trial court. The petitioner also insists for compensation of rupees 500 from the learned presiding officer. Heard so and so. Reuse the materials on record. Learned counsel for the petitioner submits that when it was closed, criminal miscellaneous 146 of 2020.
No. Recent document ಇದೆಲ್ಲ ಕೊಡಿ. ಗೊತ್ತಿದೆ.
12/11/2022.
When?
12/11/2022. 12th November 2022.
Why it was closed? ಏನು ಪೇಮೆಂಟ್ ಆಯ್ತಾ?
ಡಿವೋರ್ಸ್ ಆಗಿದೆ ಅನ್ಸುತ್ತೆ ಪಾರ್ಟೀಸ್ಗೆ. ಡಿವೋರ್ಸ್ ಆಗಿದೆ, ಸೊ ದೇ ವಿಡ್ರಾನ್ ಎವ್ರಿಥಿಂಗ್. ಪೇಮೆಂಟ್
ಯಾವ್ದ್ರಲ್ಲಿ ಆಗಿದ್ದು?
ಯಾವ್ದ್ರಲ್ಲಿ ಆಗಿದೆ?
MC petition.
ಅಲ್ಲ, ಡಿವೋರ್ಸ್ ಯಾವಾಗ?
MC number?
MC number ಹೇಳಿ.
ಯಾವಾಗ ಡೈವರ್ಸ್ ಆಯ್ತು?
MC ಅವನ ಕೇಳ್ರಿ. MC divorce ಆಗಿಲ್ಲ. A22 MC number ಇದೆ.
MC number ಗೊತ್ತು.
Divorce by mutual consent or by contest?
Mutual ಆಯ್ತಾ?
He didn't contest properly, he got not mutual consent. So.
On merits, my lord.
No, you filed the petition
Yes, ma'am.
and she has not contested it.
Appeared when he.
ಈ ಬಲ್ರಿ ಇಲ್ಲಿ.
So it was based on merits and.
ಇಲ್ಲಿ ಬಂದು ನಿಂತ್ಕೊಂಡು ಹೇಳಿ.
She has not challenged that order.
She challenged, madam, and she appeared very less number of times, but after sufficient time provided by the magistrate, then they ruled it out in favor of me due to cruelty.
Whether that order was challenged?
See, divorce petition challenge ಮಾಡಿದಾರಾ?
Or no, not high court, no, she has not challenged it in high court, no.
ಯಾವಾಗ ಅದು ಡೈವರ್ಸ್ ಆಗಿದ್ದು?
Madam, 3rd August 2024.
ಏನಾಯ್ತು? ಅದೆಲ್ಲ It is brought to the notice of the court by the petitioner who is present before the court that he had filed a matrimonial case seeking divorce against respondent number 1 on the ground of cruelty, and on merits the said petition was came to be allowed, and the marriage was dissolved on 3/8/2024. And the said order reached finality as none of the parties have challenged the same. What happened to this 181 of 18?
That is allowed. 9,000 rupees maintenance is ordered, my lords.
When
From the date of application, it is allowed on 9th June 2022. 9,000 to the first applicant, 9,000 to the second applicant. That is to the wife and child, 9,000 each, my lords. Page 8 of his memo.
it is also stated that criminal miscellaneous number 181 of 2018 was pending before the trial court is already allowed with a order dated 9/6/2022 awarding maintenance of rupees 9,000 each to the petitioner to respondent number 1 and 2.
15,000
Really?
15,000. Lord. Lord, the original petition was
The
challenged in appeal, my lord. 15,000 rupees has been ordered by the appellate court, my lord.
Yaudri,
181 of 2018.
Huh.
The order has been revised and the monthly maintenance of 15,000 for petition number 2 is allowed, my lord. In page number 29 of the separate memo, my lord.
ಏನು revision petition,
ಹೌದು ಸ್ವಾಮಿ.
revision petition number?
32 of 2022
It challenge agilla. Didn't challenge.
That was allowed
on 5th April 2023.
April 2020.
2023.
What was the amount ordered?
15,000 for petition number 2.
15,000.
15,000 petition number house.
Nothing to the wife.
Nothing to the wife.
Nothing to do.
We're not sure whether this order is challenged or not, my lords. This is 5th April
ಇಲ್ಲಿ
2020.
ಆರ್ಡರ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
Order
Separate
ಹಾಕಿದ್ದೆ.
memo ಹಾಕಿದೀನಿ sir.
Criminal RP
Separate
32.
memo, I filed it, madam.
Dated, memo dated,
Memo dated 3/2/2025, madam.
3/2/2020,
5,
page number,
29, page number 29.
Petitioner hearing challenge the said order. By preparing the revision in criminal revision petition number 32 of 2022. The learned session here. With a order dated 5/4/2022. Partly allowed the petition. Set aside the order granting maintenance through the vide. However, awarded maintenance, monthly maintenance of rupees 15,000. Respondent number 2, the daughter. This order has reached finality. Therefore, it is clear that criminal misdemeanor number 181 of 2018 before the trial court was disposed of on 9/6/2022, and even the revision petition is disposed of on 5/4/2023. Under such circumstances, the prayer number 1 made by the petitioner seeking transfer of the trial, transfer of criminal misdemeanors 181 of 2018 to the court of the learned civil judge in JMSC Kolar does not survive for consideration. Next part. The second prayer made by the petitioner is with regard to consideration of the representation submitted by the petitioner to respondent number 3 seeking disciplinary action against the learned magistrate. Respondent number 3, represented by the advocate, submits that an inquiry was held and it is found. What is the result of the inquiry? Respondent number 3 hold an inquiry.
They took the explanation and they
Held an inquiry. And being satisfied with the explanation given by the learned, no action was initiated against him.
at para 12 of my objection statement, I have stated, my lord.
Under such circumstances. Once again, directing respondent number 3 to initiate a disciplinary action against the presiding officer does not rise. Next. Now the third prayer made by the petitioner assumes importance. He seeks a direction to the learned magistrate to pay compensation of 500 to the petitioner for the mental agony and abuse of his power. Abuse of his power. Yes, ಏನ ಅವ್ರೇನ ಹಾಕಿದ್ರ? The petitioner, who is personally present before the court and claims to be an engineer by profession, filed a memo, made the oral submission before this court. When he is asked to file the, made the oral submission before this court, saying that some painful incidents have occurred before the trial court on 31st July 2021. But when he discussed, but his advocate advised him to approach this court to get justice, and therefore he followed his advice and filed the petition. But he is not aware of the consequences and the legal procedure involved in this case. He also states that he is paying rupees 15,000 to petition number, respondent number 2, as directed by the court as monthly maintenance. The maintenance. When he was asked to file a memo in that regard, he filed the memo which reads as under the next statement. When the learned counsel for the petitioner was asked as to whether he pursue his prayer made at serial number 3, then counsel was bent upon seeking action against the judicial officer and awarding of maintenance on the ground that the learned magistrate had no authority to direct the police to take the petitioner hearing to custody when no warrant was pending and when the matter was posted for filing objections. Next paragraph. The materials on record disclose that the interim maintenance was awarded by the learned magistrate in a criminal miscellaneous number 181 of 2018 at the rate of rupees 3,500 per month. Respondent number 2 hearing was held only 30 days when the petition was filed. In spite of that, sufficient opportunity was given to the husband to file his objection, and after considering the same, the order granting interim maintenance was passed. Even though said order was challenged by the husband before the revisional court in the criminal revision petition 32 of 2022. Even though same was criminal revision petition 45 of 2019, the same was dismissed today, order dated 13/9/2019. Admittedly, the said order reached finality. Therefore, the petitioner herein was bound to pay rupees 3,500 per month as maintenance to respondent number 1 and 2 hearing. It is also admitted that the said amount was not paid regularly. According to the learned counsel for the petitioner, only an amount of rupees 20,000 was paid till 31/7/2021. The 3,500 to be paid mailer in the miscellaneous 181 of 2018, 3,500 interim maintenance from the date of petition, that is 24/11/2018. Again, paid only rupees 20,000 till 31/7/2021. According to the learned counsel for respondent number 3, an amount of rupees 68,000 was due from the petitioner as on 17/12/2020. It is also pertinent to note that the petitioner hearing entered his appearance in a criminal miscellaneous 146 of 2020 on when he entered appearance in criminal miscellaneous 146.
46.
He entered appearance on 7/4/2021.
7/4/2021. On 31/7/2021, when the matter was listed for filing objections, it conspired that the
submission by-
petitioner hearing had not paid the maintenance amount as awarded.
My lord,
Considering the plight of
in between two dates for PO was on leave, my lord.
simply because PO was on leave, the wife and child should survive. Leave ಆದ ಕೂಡಲೇ ಹೊಟ್ಟೆಗೆ ತಿನ್ನೋದು ನಿಲ್ಲೋದಿಲ್ಲಲ್ಲ.
She was earning, my lord, and moreover,
ಆಯ್ತು. Yes. Considering the plight of the wife and child, the learned magistrate directed the petitioner hearing to pay the maintenance or else threaten to take him into custody. It is stated that the mother of the petitioner arranged for ₹10,000 and paid the same to respondent number 1, which is still under dispute. However, as per the order sheet, the petitioner was not remanded to custody. Even if the contention of the petitioner, learned counsel for the petitioner is to be accepted, the petitioner at the most may be ordered to be taken into custody till he makes payment, which is only to compel him to make some payment to the wife and child for their survival. The same cannot be stretched to contend that the learned magistrate has misused his authority in directing the petitioner to make payment or else to remand him into custody. Next para. The contention of the learned counsel for the petitioner that under section 126(3), ఎంత వారెంట్
125.
120
1
ಅದೇನು ವಾರೆಂಟ್ ಎಂತದೋ ಹೇಳ್ತಾರಲ್ಲ ಅದಕ್ಕೆ ಏನು ವಾರೆಂಟ್
subsection 3 of section 125.
into 125(3) of CRPC. If the petitioner fails to comply with the order, he can only issue a warrant for levying the amount due in the matter and cannot threaten the petitioner to take him into custody without there being any warrant, cannot be accepted under the facts and circumstances of the case. Moreover, when the petitioner himself admits that he had not paid the maintenance amount as ordered by the learned magistrate, which has already reached finality, the petitioner cannot have any justification to make such allegations against the learned magistrate. Moreover, respondent number 3, the Registrar General of this court, has held an inquiry and is satisfied with the explanation given by the judicial officer. Next. In the present case, even though the petitioner is physically present before the court, he submits in the open court that he is not interested in prosecuting the petition. However, as per the advice of the learned counsel, he is made to filed this petition and also filed a memo to that effect. Learned counsel for the petitioner is bent upon to allow the petition and to order for payment of compensation. The learned counsel for the petitioner has also filed a IA-1 of 2025 seeking impleadment of the learned judicial magistrate in his personal capacity as respondent number 4. In the affidavit accompanying the application, it is stated that when the matter was taken up for hearing on 25/2/2025, this court observed that non-joinder of the judicial officer to the proceedings, since the reliefs are sought against him, and therefore it is stated that the learned judicial officer is a necessary party to the proceedings. When the learned counsel for the petitioner is repeatedly asked whether he insists on allowing this application as well as the petition, the learned counsel was very firm that the application and the petition will have to be allowed. Next. The facts and circumstances discussed above shows the conduct of the learned counsel for the petitioner in advising the petitioner against the learned magistrate who discharged his official power, official duty, and directed the petitioner to pay the arrears of maintenance to his wife and child. No evil would be attached to the conduct of the judicial officer, as he is not personally interested in the matter. Learned counsel for respondent number 3 further submits that on 31/7/2021, the learned magistrate had taken charge and was discharging his official duty for the first day. And high drama was created in the open court on that day by raising the voice. While you are representing the petition respondent before the trial court, is learned counsel for the petitioner hearing admits that he was the advocate who was representing the petitioner hearing before the trial court. Even when the party submits that he acted solely on the advice of the learned counsel, the counsel is not ready to drop the proceedings, but he is bent upon to pursue the matter. Under such circumstances, I am of opinion that the petition is liable to be dismissed. However, it is a fit case for the Bar Council, Karnataka Bar Council, to initiate disciplinary action against the counsel representing the petition. Accordingly, I proceed to pass the following. Petition is dismissed. The Bar Council of Bar Council, Bengaluru, Karnataka.
Bar Council of Karnataka, Karnataka Bar Council. Karnataka Bar Council. Karnataka Bar Council.
Karnataka
State Bar.
Directed to initiate disciplinary action against the counsel for the petitioner. So and so. In accordance with law. The conduct of the petitioner for conduct of the learned counsel for the petitioner is unbecoming of a professional. Yes. Petition is dismissed. Communicate this order to so and so. Dismissed.
One more submission, Milakshi. Yes. Milakshi, In submission, my lord, the certified copies of the annexures may be returned, my lord.
ಬೇಕಲ್ಲ ಇದು ಚಾಲೆಂಜ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಬೇಕಲ್ಲ ಎಲ್ಲದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದ್ರು. If it, when you challenge this order for the higher courts, we may have to send the entire file. At that time, these documents are necessary. Let it be there.
In my file, I have mutilated condition of this.
You know,
Copies are have been, wax copies are not visible.
ಆಯ್ತು ಅದು ಫೈಲ್ ನಲ್ಲಿ ಬೇಕಾಗುತ್ತೆ, ಅದು ರಿಟರ್ನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ.
May be permitted to take the copies of entire file, my lord.
ಕಾಪಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡ್ಬೇಕು.
ಎಲ್ಲಾ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಲ್ಲ ಅಂತಾರೆ ಸ್ವಾಮಿ, ಬರೀ ಪೆಟಿಷನ್ ಮಾತ್ರ ಕೊಡ್ತೀನಿ ಅಂತಾರೆ.
ಅದಿದ್ರೆ ಬನ್ನಿ ಮುಂದೆ
Certify ಕೊಡಕ್ಕಾಗಲ್ಲ because some of the documents will be photocopies. We cannot certify from this court to that it's a true copy. Num certificate and they'll use it somewhere else.
ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾಗ ನಿಮ್ಮ ಹತ್ರ ಫೋಟೋ ಕಾಪಿ ಇರ್ಲೇಬೇಕಲ್ವಾ?
Certified
ಇದೆ, it is
ಎಲ್ಲ ಸರ್ಟಿಫೈಡ್ ಫ್ರಮ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ತಗೊಳ್ಬೇಕು ಅವ್ರು. ಅಲ್ಲಿ ಸಿಗುತ್ತೆ ಎಲ್ಲ ಕಾಪೀಸ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಸಿಗುತ್ತೆ.
Jagdish, Shanti Bhushan.
For the respondent number 2, my lord.
Petitioners in this petition
ಇದು
read to request the order passed by the trial court on the application filed by the prosecution under section.
We have no instructions regarding this, my lord. Respondent number 2, my lord.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಅವ್ರ ಪರ್ಸನಲ್ ಮ್ಯಾಟರ್ ಆಯ್ತು.
She is the complainant.
Personal matter.
ನೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಯಾಕೆ ಹೇಳ್ತಾರೆ?
She is the complainant. She has filed complaint against her husband, one Umesh, and her in-laws, alleging that there is a under section.
Have you filed a memo? ಯಾವಾಗ?
2 days, my lord.
Huh?
Thursday, my lord.
ರೀ ಹಾಕಾಗಿದ ಕೇಳ್ದೆ ನಾನು. ಮೆಮೋ ಹಾಕೋದಕ್ಕೆ 2 ದಿವಸ ಯಾಕೆ ಕೊಡ್ತಾರೆ?
ಹಾಕಿಲ್ಲ.
ಫೈಲ್ ಎ ಮೆಮೋ. ಫೈಲ್ ಎ ಮೆಮೋ ಅದಕ್ಕೊಂದು ಮತ್ತೆ 2 ಡೇಸ್ ಯಾಕೆ?
File the court and
Wait ಮಾಡಿ.
Learned counsel for respondent number 2 filed ಅಂತ ತಗೊಳ್ತೀನಿ. You have to file. Counsel for respondent number 2 files a memo. ಏನು ನೋಟಿಸ್ ಗಿಟೀಸ್ ಏನು ಕೊಡ್ಬೇಕಾಗಿಲ್ವಾ?
ಬೇಕು ಸ್ವಾಮಿ, ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ಇದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ರೆಫರ್ ಕೇಸ್ ಇದು. ಇವತ್ತು ಬಂದಿದ್ದು ಗೊತ್ತಾಗ
ಅಂತದೆಲ್ಲ ಸಬ್ಮಿಷನ್ ಮಾಡಬಾರ್ದು ನೀವು. ಯು ಆರ್ ಎ ಪ್ರೊಫೆಷನಲ್.
ಫೈಲ್ ರಿಟರ್ನ್.
ಏನಿದು ವೆರಿ ಚೈಲ್ಡಿಶ್ ಸಬ್ಮಿಷನ್ಸ್ ಅಪ್ಪ. ವಕಾಲತ್ ಹಾಕಿದಿರೇ ಇಲ್ವೋ? ದೆನ್ ಯು ಆರ್ ರೆಸ್ಪಾನ್ಸಿಬಲ್. ಅವ್ರು ರೆಫರ್ ಮಾಡಿದ್ದು, ಇವ್ರು ರೆಫರ್, ವಾಟ್ ಇಸ್ ದಿಸ್?
ಫೈಲ್ ರಿಟರ್ನ್.
ಇದನ್ನ ನೀವು ಯು ಆರ್ ಟೇಕಿಂಗ್ ದಿ ಹೈಕೋರ್ಟ್ ಟು ದಿ ಲೆವೆಲ್ ಆಫ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ ಈ ರೀತಿ ಮಾಡಬಾರ್ದು. ಎಲ್ಲಿದ್ದಾರೆ ನಿಮ್ ಸೀನಿಯರ್? ಕೇಳ್ತೀನಿ ಅವ್ರಿಗೆ, ಈಸ್ ಇಟ್ ದ ವೇ ಆಫ್ ಮೇಕಿಂಗ್ ಸಬ್ಮಿಷನ್?
ಸಾರಿ. ಫೈಲ್ ರಿಟರ್ನ್.
ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಇಷ್ಟು ಡಾಕ್ಸಿಗೆ ಹೋಗಿದೆ ಅಂತಂದ್ರೆ you do not know what is to be submitted, what is not should be to be submitted. ಕಾರಿಡಾರ್ ನಲ್ಲಿ ಮಾತಾಡ್ದಂಗೆ ಮಾತಾಡ್ತೀರಿ. How I am concerned that the case is referred by so and so, so and so.
ಫೈಲ್ ರಿಟರ್ನ್.
Whether I am concerned with that?
ಫೈಲ್ ರಿಟರ್ನ್.
Since you are holding the brief, I am asking you.
File written. File. 2 days.
Proxy counsel for respondent number 2. Raise for time on the ground that he is not receiving any instruction. The counsel on record is not receiving any instructions from respondent. Therefore, he wants to issue notice. Notice. The petition is of the year 2018. 7 years have lapsed. And it is one of the oldest matters. I do not find any reason to adjourn the matter. However, to afford final opportunity, one more opportunity, list finally as a last chance. No further adjournment. I do not know what you will do. ಸ್ವಲ್ಪ ಸಬ್ಮಿಷನ್ ಕಲ್ತ್ಕೊಳ್ಳಿ. ನಿಮ್ ಸೀನಿಯರ್ ಯಾವತ್ತೂ ಈ ರೀತಿ ಸಬ್ಮಿಷನ್ಸ್ ಮಾಡಿಲ್ಲ.
26 ಶಂಕರ್ ರೆಡ್ಡಿ.
ಡೇಟ್ ಕೊಟ್ಟಿರಲ್ಲ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೊಡ್ತಾರೆ.
Some other day.
14C of the
Huh?
14C of the Foreigners Act.
Foreigners.
ನನ್ನ
ಆಯ್ತು.
ಟೆನೆಂಟ್ಗೆ ಬೇರೆ ಯಾರಿಗೂ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅವ್ರಿಗೆ ವೀಸಾ ಎಕ್ಸ್ಪೈರಿ ಆದ್ರೂ ಕೂಡ
Visa
ನಾನು ಅವ್ರನ್ನ
expiry
ಇಟ್ಕೊಂಡಿದೀವಿ
ಆದ್ಮೇಲೆ-
ಅಂತ ಅಷ್ಟೇ ಕೇಸ್.
ಆಗ್ಲಿ, ಇವಾಗ ಆಯ್ತು. List on first.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಕ್ಸ್ಟೆಂಡ್.
Entry ಮಾಡ್ರಿ ಇದ್ರೆ extend ಮಾಡಿ.